As the judge is already here, his Honorable Justice Adrian Fisher has taken his seat, as you can see down there. He is already seated, and he will be delivering his judgment pretty soon. So we are broadcasting live from his judgment. Thank you for watching and continue to watch AY.
Adikali de Suma Fode Vafumba Bawo Samura Matthew Wilson Kamara Kande Fode Basil Kamara and Julius Sanders Davis.
Yes, good morning. Representations, please.
For the prosecution, CT Mansebo, and with me, OV Robin Manson, Kenneth Conte, and EK Amara.
Yes, thank you very much. First accused. Thank you very much. Second accused.
Second accused. Ibrahim Sori. Ibrahim Sori, Africano Sori Sise. Brima Kuroma and Geraldine Manley, Spain.
Thank you very much. Third accused. Fourth.
Good morning, my lord. For the fourth accused, Franklin Baikabo, Ambassador Amadou A. Koroma, Melron C. Nicole Wilson, Musa Nu Kamara, Suleiman Kaba Koroma, Africanos Sise, our own Adi Macaulay, Brima Koroma, Radcliffe Jones, Roland Nylander, Geraldine Manley Spain, E.B. Touye, A. Boise Kamara.
Right, where's Mr. Toure? I can't say it. No, it's not seen. Yes.
I.A. Kamara, A. Boise Kamara, M. Berete, Festus Robin Taylor, Adama Amara, and S. Ba.
Mr. Nicole Wilson, is there going to be space on the ruling to incorporate all of those names?
We hope so, my lord.
Yes, I know Mr. Kamara will say there are more coming. All right, where's Teddy Kuroma? Yes. Yes, indeed. Okay, sit down, gentlemen. Yes, thank you. Right, I have to say, counsel, is going to be a lengthy ruling. It goes into some 100 pages. So it will take some time to deliberate. Okay? All right. This ruling concerns the no-case submissions raised by the accused persons at the close of the prosecution's case in this trial. When the matter came up for hearing, City Mansibo for the state informed the court that the prosecution wished to close its case, but was concerned that there might be a need to reopen the case subsequent to the locus in co visit which the court was proposing to make to the scene in New York. He therefore considered it prudent to defer the closing of the prosecution's case pending the locus visit. Counsel for the defense were of the view that it was appropriate for the prosecution to close its case to enable them to determine how to put their defense. All counsel were of the view that necessary. With these assurances, Mr. Mansibo decided to close the prosecution's case after an amendment to the indictment was granted. The accused persons, save for the sixth accused, subsequently pleaded not guilty to the amended indictment, and at this stage, the prosecution closed its case. When the matter accused persons informed the court that they intended to make no-case submissions on behalf of the accused persons, which would be in writing. Directions were issued for the no-case submission on behalf of the accused to be submitted to the court in writing by the 31st of December 2022, and for counsel for the state to file a response by the 15th day of January 2023. There was non-compliance on all sides with these directions owing to the late submissions, in particular with respect to the fifth accused, which meant that the prosecution could only file a response on the 8th of February 2023. Notwithstanding, I subsequently received the no-case submissions file on behalf of the accused and the replies thereto by the prosecution. On a point of principle and law, it must be pointed out at this stage that this ruling is not intended to, nor is it indicative of the guilt or innocence of any of the accused persons. It is merely determinative of the submissions made by the prosecution are sufficient to amount to a prima facie case against the accused persons, thus requiring them to be put that at the end of the case, the prosecution is unable to discharge the burden of proof. For the purposes of these submissions have been assessed to the lower standard of proof, which is the sufficiency of evidence test. Contrary to the submissions of defense counsel, the beyond the reasonable doubt test is only utilized in the determination of guilt or innocence, and to that extent, I have not utilized that test. These submissions are a culmination of a very long trial in which the prosecution led 18 witnesses, which were extensively cross-examined by counsel for the accused persons, in particular the first and the fourth accused persons, as is their right to do so. I deal with no-case submissions. In criminal cases, whenever an accused raises the issue of a no-case submission at the end of the prosecution's case, it is the duty of the trial judge to determine whether to uphold the no-case submission or, in the alternative, whether to dismiss it. The applicable test is that set out by the courts in the case of R.V. Galbraith, 1981, One Weekly Law Report 1039 at 1042C. And the test as set out in Galbraith can be encapsulated as follows. 1. If there is no evidence that the crime alleged has been committed by the defendant, there is no difficulty. The judge will stop the case. The difficulty arises where there is some evidence, but it is of a tenuous character, for example, because of innocent with other evidence. Evidence taken at its highest is such that a jury properly directed could not properly convict on it. It is its duty on a no-case submission being made to stop the case. Where, however, the prosecution evidence is such that its strength or weakness depends on the view to be taken of a witness's reliability or other matters which are generally speaking within the province of the jury, and where on one possible view of the facts there is evidence on which the jury can properly come to the conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury, as per Lord Lane, Chief Justice, at page 127. In simple terms, the Galbraith test means that there are two separate limbs for the defense to consider when making a submission of no answer. Limb 1, there is no evidence upon which the jury could convict. Or limb 2, there is some evidence, but it is so poor that it would be unsafe to leave it to the jury. Conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury, or as in this case, the tribunal of fact. Having set out the applicable test and the approach to consideration of a no-case submission, I shall now proceed to consider the submissions advanced on behalf of the accused persons, starting with the first accused and the responses thereto. The first accused is charged with 30 count offences contrary to the anti-corruption Act 2019 in count 16. Failure to comply with the applicable procedures and guidelines relating to the management of funds contrary to section 48(2)(b) of the Anti-Corruption Act number 12 as amended by the 2019 Act as contained in count 17, 19, 21, 23, 26, 28, 30, 32, and 41. For conspiracy to commit a corruption offence, contrary to section 128 of the Anti-Corruption Act number 12 of 2008 as amended, as contained in counts 25, 42, and 46 accordingly. 5. Abuse of office contrary contrary to section 43 of the Anti-Corruption Act number 12 as amended and as contained in count 44. The prosecution called 18 witnesses against the accused persons, and I shall carefully consider the submissions made by Mr. MP Fofana of Council on behalf of the accused on account by count basis. Count 16. With respect to count 16, Mr. Fofana submitted as follows: that the first accused did not tender or award any contract at all to Fairfield Construction Associates Limited, inclusive of awarding a contract for additional works to them. The first accused met, dealt with, and operated within an existing valid contract dated the 9th of December 2016, which was lawfully executed between the government of Sierra Leone, represented by the then Sierra Leone Permanent Mission to the United Nations in New York as owner, and Fairfield Construction Associates LLC, represented by Mr. Jules Sanders Davis as president and managing member as contractor, and he therefore relied upon Exhibit U. The said contract specifies at Article 16, paragraph 16 on pages 17 to 18, how changes can be made to the basic character, design, or scope of the project, and so forth, leading to what it described as change orders. 2, that the first accused never tendered or awarded any contract for additional works to Fairfield Construction Associates, nor did the latter complain about the first accused attempting to do so under the existing contract. Besides, the existing contract makes provision for events of default, quote unquote, in the agreement, and for its termination or suspension by either party, as set out in Article 10, paragraph 10, at pages 11 to 14. He further argued that neither the prosecution nor the state of Sierra Leone invoked the above clause in pursuit of the purported non-performance or default in the performance of the contract. The change orders were done in 2019 or on or about mid-2019, and not the 2018 period de facto in count 16, and that Fairfield Construction Limited acknowledged receipt of monies paid out to them on the change orders 1 and 2 in the sum of 542,000 United States dollars and 243,555,000 United States dollars, respectively, from the first accused as head of Chancery by letter dated the 1st of July 2019. These documents referred to were in Exhibit AAY 1 to 4, which was a progress report written by one Alan George. He relied upon Article 13, paragraph 2310 at page 23, which stipulates that the agreement in question shall be governed by the laws of the state of New York, both as to interpretation and performance, and shall be subject to the jurisdiction of the Supreme Court of the state of New York. He argued that it was therefore unclear to the first accused as to why he is accused of committing an offense in the city of New York, United States of America, under the existing contract, and is being tried extraterritorially in the jurisdiction of Sierra Leone. He further argued that the prosecution has throughout its case consistently failed to state and produce to the court the applicable procedure the 31st of July 2020. He sent a piece of Mr. Fofana's argument with respect to these counts is the fact that neither Fairfield Construction nor its president and senior permanent secretary in the Ministry of Works and Public Assets He argued that both PW8 he fully worked within the full mandate of his job as head of Chancery set out in the letter from PW12, Ambassador Mrs. Florence Bangali, the then Director General of the Ministry of Foreign Affairs, as exhibited in Exhibit AAS 1 to 3 and dated the 31st of July 2020. He concluded, therefore, that it submitted further that it cannot be said that the first accused willfully or negligently failed to comply with applicable procedures and guidelines in the performance of his job and duties. And he suggested that count 16 as charged ought to be dismissed. I'll deal with count 17, 19, 21, 23, 26, 28, 30, 32, 34, 36, 38, and 40. With respect to these counts, the first accused is charged with failing to comply with applicable procedures and guidelines relating to the management of funds, contrary to Section 48, subsection 2, paragraph B of the Anti-Corruption Act number 12 of 2008 as amended. The centerpiece of Mr. Fofana's argument with respect to these counts is the fact that neither Fairfield Construction nor its president and managing member, Mr. Joel Sanders Davis, ever at any point in time complained of mismanagement of funds or portions of funds due and owing to them, which himself in Exhibit AN 1 to 2 to have received well over $4 million out of the contract sum of $5,295,555 United States dollars. The said exhibit stated that the invoice sum of $4,669,549.45 United States dollars followed a verified audit, and that the balance owing to Fairfield Construction as at 21st of April 2021 was $626,000 United States dollars and 5 cents. Exhibit AN 1 to 2 is a letter from Fairfield Construction which was signed and endorsed by Jules Sanders Davis as president. He argued that Fairfield and Mr. Jules Sanders Davis' only complaint was against the government of Sierra Leone for failing to fund the completion of the building in a timely manner and rushing to criminally indict them for doing so, and in fact for doing far more than was expected. Both as to interpretation and performance, and shall be subject to the jurisdiction of the Supreme Court of the State of New York, County of New York. It is significant to note that the first accused, supported by the third and the fifth accused persons, at all material times kept the line ministry, that is the Ministry of Foreign Affairs and International Cooperation, fully informed about the activities, programs, and projects in New York, during the period under review, inclusive of the management of all funds meant for the reconstruction works at the Chancery Building. And in that respect, he relied upon Exhibit AAW 1-5, which was a report, as it were, to Capital, dated the 19th of February 2019, and Exhibit AAX 1-12 of the 29th of April 2019, Exhibit AAY 1-4 dated 11th of July 2019, Exhibit AAA 1-3 dated 20th of August 2020, and Exhibit AAZ 1-7 dated the 29th of April 2019. It therefore relied upon excerpts of minutes of meetings held on the 22nd of May 2020, which is exhibited as Exhibit AAM 1-5, and excerpts also of further meetings held on the 1st of June 2020 in Exhibit AAN 1-2 at pages 1 and 2. He argued that since June 2020 or thereabout to date, the evidence available to the court is that the necessary outstanding funds required for Fairfield to complete the Chancery Building in New York so that it could be opened for official use had not been made available to the company, in spite of the said company's out-of-pocket expenses. Besides, according to Exhibit AAZ 3-6, Fairfield had on the 2nd of March 2020, shortly before the above meetings were held, given a comprehensive summary of work on the Chancery project from its inception in December 2016 to the 2nd of March 2020. The company also projected what would be done in April and May of 2020 if the required outstanding budgeted funds were available to them to finish the said project. Mr. Fofana further argued that two technical reports on the Chancery Building project submitted by PW2 Mr. Paul Bokari, namely Exhibit AK 1-46, which is characterized as the first technical report that was submitted in October 2019, and Exhibit AK 1-46, the second technical report submitted in August 2021, contained the following facts, which showed much progress in the rehabilitation work done by the contractor, even against the myriad of funding delays and challenges it periodically faced at the hands of the state, as well as the huge unbudgeted extra cost the contractor had incurred in the demolition exercise, hiring and replacing unpaid staff, insurance matters, and the unforeseen COVID-19 challenges, and also the incidental stop work orders issued by the New York Building Department in respect of the rehabilitation works. He relied upon excerpts from Exhibit AK 1-46, which is the first technical report done in October 2019, and excerpts from the second technical report of the 4th of August 2021. He argued that none of the sums of money listed in the count charges under this rubric could be attributed to willful or negligent failure on the part of the first, third, and the fifth accused to follow applicable procedures and guidelines known to the accused. All monies disbursed to Fairfield LLC in the existing reconstruction contract were done in accordance with the said contract, and that the said company fully acknowledged receipt of the same and expended the monies received in the manner specified, incurring extra and additional costs for unbudgeted and unforeseen situations as well. Article counts 18, 20, 22, 24, 27, 29, 31, 33, 35, 37, 39, and 41, which charges misappropriation of public funds contrary to Section 36(1) of the Anti-Corruption Act as amended. Mr. Fofana submitted that the above counts are in view of the evidence led in court against the first accused and the analysis already provided in respect of the previous offences amount to failure to comply with. He argued that the sum $1,669,549.45 United States dollars was acknowledged by Mr. Jules Sanders Davis as received by Fairfield Construction Associates. In fact, Mr. Davis had stated in his acknowledgement letter of the 21st of April 2021 that he was looking forward, quote unquote, to working with Ambassador Ali Kabar as permanent representative and bringing the Chancery project to a conclusion, which all parties involved can be proud of. Similarly, Mr. Jules Sanders Davis' witness statement tendered as Exhibit F1 to 36 is replete with admissions by him of receiving the monies meant for the Chancery project for and on behalf of his company, Fairfield LLC. He therefore submitted that both the actus reus of appropriation of the monies cited in the reference count charges above and the mens rea of dishonestly appropriating the same are entirely lacking, in the sense that no evidence was led to show that the first, the third, and the fifth accused took or received the said sums of monies themselves and misappropriated them for themselves to the exclusion of the state of Sierra Leone. He argued that the above counts, which I've just referred to, should accordingly be dismissed in their entirety. Counts 25, 42, and 46. These counts charges conspiracy to commit a corruption offense, contrary to Section 128 of the Anti-Corruption Act, as amended by Section 14 of the 2019 amendment. With respect to this count, he argues that the prosecution has not produced to the court any applicable procedures and guidelines so that it can determine or measure the level and extent of compliance with the said applicable procedures and guidelines. No witness of fact stated or specified the details that entail in them, if any, nor was any expert called to speak to the applicable procedures and guidelines that constitutes the corruption offense. He further argued that no evidence was led whatsoever that indicated or suggested that the third, the fifth, and the sixth accused persons were in respective conspiracies with the first accused. All the relevant and necessary procedures in managing the funds for the Chancery building project and the project itself were followed, and no one was quit, suspended, or dismissed for failing to comply. The sixth accused, Mr. Jules Sanders Davis, was also not involved in tendering contracts with the first accused, considering that the change orders were not separate contracts in themselves, but were part and parcel of and were integral to the main Chancery building contract. He suggested that this was why PW9 Ambassador Francis Kaikai sourced the additional funding from the People's Republic of China, a willing donor, so that more floors can be added to the initial four-storied house. The evidence led by PW6, PW8, 9, 12, and 14 indicates that every step was followed through and approved by Capital, with regular reports being sent as well to Capital to keep the state fully updated and informed about the project. He argued that counts 25, 42, and 46 should fail accordingly on the basis that the said count charges were glaringly left to hang in thin, unsupportive air as their purported principal offenses generated by the prosecution for the count charges in fact cannot be found in any way, shape, or form. The defense waited, he said, to identify the applicable procedures and guidelines, but found none, whilst the onus rested on the prosecution to produce these guidelines. With respect to count 43, that offence charges offence of abuse of office, contrary to section 42(1) of the Anti-Corruption Act as amended. With respect to this count, he argues that it is central to the prosecution's case that the accused abuses office by improperly conferring an advantage on the sixth accused, Mr. Jules Sanders Davis, even though the advantage is not specifically stated therein or identified. The first accused said will therefore rely on and adopt the arguments and submissions in respect of the previous counts and wholly denies the particular set out in the charge. Apart from the fact that no evidence was led by the prosecution to substantiate the allegation of abuse, the meager resources available to complete the project then. Both PW9 and PW12, who were senior career officials in the Foreign Affairs Ministry and at the Chancery Building in New York, alluded to the hard work, enthusiasm, and integrity of the first accused. He argues that this count should therefore be dismissed as unsubstantiated and unmeritorious, as there is absolutely no evidence that the first accused ever tried to unlawfully confer an advantage on Mr. Jules Sanders Davis and or Fairfield. With respect to count 44, the offence of deceiving a principal is charged. A document that was to the detriment of the state as the principal, which the first accused is said to have intended to use to deceive the state. The arguments and submissions thus far made by the first accused to the effect that the state suffered nothing and instead, in fact, contributed to the delay in completing the Chancery Building by not paying the outstanding sums of money required to finish the project. Both the first accused and the contractor nevertheless did all that they could to sustain the reconstruction works and keep the project afloat, even to their own detriment, inclusive of, he said, the first accused being suspended from work and going through this trial, which he considered to be unmeritorious. In conclusion, he submitted that the prosecution has, one, failed to prove essential elements in the alleged offences, and secondly, the above analysis illustrate that the evidence led by the prosecution has been so discredited and is manifestly unreliable that no reasonable tribunal of fact and law in this case, the trial judge sitting as judge and jury emphasis mine, could safely convict on it, and the first accused should therefore be accordingly discharged. I deal with the prosecution's response. Mr. Mansibo for the prosecution argued that the first accused has misconceived the applicable test to be applied to submissions of no case. He argued that with respect to the charges of failure to comply with applicable procedures and guidelines relating to the tendering of contracts, the gravamen of the charge is that the very contract that was used to facilitate the renovation of the Chancery Building was not tendered in accordance with the said procedures and guidelines. He argued that the relevant legislation in question are the Public Procurement Act number 1 of 2016 and the Regulations on Public Procurement, 1st edition 2006, and that this court should determine whether the necessary evidence has been led in support of the averment in count 16, relating specifically to the first accused's failure to comply with applicable procedures and guidelines relating to the tendering of contracts. He argued that the evidence establishes that the first accused participated in the process relating to the eventual award of the contract to Fairfield Construction Associates, and he relied upon Exhibit AAH 1 to 2, which he said are minutes of meeting held by what was termed as the Extraordinary Building Renovation and Awards of Contract Committee, whose members, amongst others, included the first accused. And that meeting in question was held on the 19th of July 2011, slightly 6 years prior to the signing of the contract, which was exhibited as Exhibit U1 to 26. He submitted that it is clear from the minutes of that meeting that the first accused would have been apprised of the procedures that had to be followed with regard to the procurement of any construction services as well as the awarding of contracts. There was specific reference to the Procurement Act as well as to the financial management regulations that would govern the administration of public funds. In Exhibit A 1 to 99 at pages 14 and 15, which is the first accused's statement to the Anti-Corruption Commission, he sought to deny his knowledge of the procurement method that was used to obtain the construction services for the renovation of the Chancery building. He referenced the responses of the first accused to questions put to him at question 12 and 13, which he categorized as important. Exhibits AA 1 to 2 are minutes of the same committee in respect of a meeting that was held on the 17th of August 2011. He argued and further submitted that from those minutes, every member of the committee, including the first accused, was already aware of the identity of the contractor who would eventually attend to the renovations. He also referred to the response given by the first accused at paragraph 4 of the said minute. He submitted that the first accused cannot claim that he was not involved in the tendering of contracts. Almost 1 year before the signing of the contract, the first accused he submitted was already in correspondence with the sixth accused and held meetings with him in connection with the details of the contract that was yet to be awarded to the sixth accused. And Exhibit AC 2:1 to 2, he said, captures details of the discussions that were held between the two well before the signing of the contract. On the 4th of January 2016, the sixth accused, in his capacity as president of Fairfield Construction, wrote to the first accused as counsellor, detailing the work that needed to be done, the options available, and the respective cost of those options. The contractor had already been identified before any of the procedures and processes that are set out in the Public Procurement Act of 2016 and the Regulations on Public Procurement, 1st edition of 2006, were in place. He argues that the original contract was not undertaken in compliance with procedures and guidelines relating to the tendering of contracts. As if this infraction was not sufficient, the major additions to the scope of the works were made without any pretense of following the related procedures, guidelines, and regulations. As head of Chancery, the first accused was at the forefront of all the arrangements that were made in relation to the financing and commencement of works under the change orders. In Exhibit A1 to 99 at pages 17 to 27, the first accused explains in great detail what was done under Change Order 3. The procedures and guidelines set out in Section be clauses 144 to clauses 1. The public procurement regulations 2006 were followed. He added, not having the funds to take the project to substantial completion. At present, there is an open roof, no work done to add the 5th and the 6th floors, and substantial remediation work to be carried out on floors 1 to 4 owing to damage caused due to exposure to inclement weather. Mr. Mansebo submitted that the submissions of the first accused ought not to be counted. I'll deal with count 17, 19, 21, 23, 26, 28, 30, 32, 34, 36, 38, and 40, which is charges an offense of failure to comply with applicable procedures and guidelines relating to the management of funds, contrary to Section 48(2)(b) of the Anti-Corruption Act as amended. With respect to these counts, the prosecution submitted in response to the no-case submission that the first accused, being the vote controller, was principally responsible for the of the agreement and the participation and certification.
AYV is your home of credible, factual and balanced news coverage. We pride ourselves
cash record 1,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. Lord, I can feel and proceed. The poor man they suffer, the rich man no they offer. I can feel and proceed. Money no there, how them go suffer. I can feel and foresee. Poor and then another butter them bread. I can feel and foresee. But you don't sit, you not get you great. I said there's too much pressure on the people them eat. You make man just fed up. Too much pressure on the people them eat. You make me just stay cry. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people no get them for it, I swear. 5,000 for the day. Some people no get them for it, I swear. 5,000 for the day. Poor one no get them for it, I swear. You know me say because of free born from poor. Yeah, yeah. That's me say we for die from poor. Whoa, whoa. You know me say because of free born from poor. Yeah, yeah. That's me say we for die from poor. Whoa, whoa. Whoa, whoa, whoa. Na, na, na. Whoa, whoa, whoa. Oh, Lord. Whoa, whoa, whoa. Na, na, na. We not like that. The way the system they blow, we not like that. They want them where they before. Oh, you free tell and let them know this. 5,000 for the day. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Poor one not get them for it, I swear. 5,000 don't make Baku man go to prison. You know easy as well. 5,000 don't make Baku baby then sell girls. I saw the thing, yeah. 5,000 don't make Baku man lost their life. Kiribi won't pass. 5,000 don't change the whole wide world. The way the poor man and suffering not like that. The way the system they blowing not like that. They want them where they before. Power your free tell and let them know this. 5,000 for the day. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Poor one not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Some people not get them for it, I swear. 5,000 for the day. Poor one not get them for it, I swear. Will back on the beat.
The so-called change of the free cost of government of Sierra Leone is sum of 1,950,000 euros. It is the prosecution's case that an advantage of improperly conferred on civil was had his company graphically described as a one-man outfit by PWAT. It is absolutely no doubt they agreed that 6 accused may contain an advantage through the medium of this company. Evidence led by the prosecution to indicate that the agreed cost of adding the 5th and 6th floor was the sum of $1,950,000 US. And said there's nothing tense about the evidence that the prosecution has led in this respect, and the submission in respect to counsel must fail. Until 2044, the civil principle contrary to section 43 of the 2008 Act is amended. With respect to this count, Mr. Matthew will rely on documents to find evidence that contain misleading information on Article 7 of the contract agreement. One of the primary requirements that had to be in place was the certification by the architect. This was a prerequisite to any payment that was to be made by the first accused principal, the Ministry of Foreign Affairs and International Cooperation. The fact the court to requisitions contained in Exhibit A 1 to 7, A1, AG 1 to 8, H1 to 5, J1 to 19, A1 to 18, L1 to 31, N1 to 18, and N1 to 29.
All right, so very sorry you actually get disconnected with AYV as they're not able to get link, but we managed for go inside the law court, then Zoom for make you able to get the information as they go on. So please continue for watch.
Fully aware that it was a requirement in terms of the contract, but nonetheless forwarded those documents to the ministry, thereby misleading its principle that all documents submitted contain all the required information. More importantly, the mention of an architect's name was intended to mislead the principal that there had been some involvement by an architect in confirming the work done. He argued that there was no merit in the notice submission made by the first accused. I've carefully considered the notice submission on account by account basis as submitted by the first accused. I've done so in line with the applicable principles in Gabet 1981 21060. I'm inclined to firstly consider whether there is any element led by the prosecution that shows that a crime allegedly been committed by the accused. That test requires an analysis of evidence led by the prosecution and consideration of the element of defense to determine whether an offense known to law is committed. Having considered the totality of the evidence used by the prosecution in this case against the first accused, I cannot, at this stage of the trial, come to the conclusion that in accordance with the Gabet test, there is no evidence that the crime alleged by the prosecution has been committed by the first accused. Further, I cannot also at this stage conclude that the prosecution's evidence taken at its highest is such that a jury, or in this case where I sit alone as a trial of fact and law, and properly directed myself as to the law and facts, could not properly convict upon it. I have, however, concluded that having reviewed the prosecution case and evidence led in this case and the submission made by the prosecution evidence, I've come to the conclusion that it is evidence such that the strength or weakness depends on the view to be taken of the witness's reliability or other matters which are generally speaking within the province of the jury, and where on one possible view facts there is evidence on which I could come to the conclusion that the first accused is guilty of one or all of the offences charged. I am duty bound to allow the case to proceed to trial on evidence, thereby requiring the first accused to the defense to the charges faced. I consider that in accordance with the decision of the court 2012 England Wales Court of Appeal, Criminal 1756, that taking the prosecution's case at its highest and having properly directed itself, I could in circumstances, the notice submission by the first accused is overruled and is required to put his action in the bid to put his defense to the charges that he faces. I'll deal with the second accused. With respect to the second accused, and for being submitted to the charge with 4 offences of the amended indictment. And counsel submitted that he was appointed on 6th of June 2016 as ambassador, extraordinary and permanent representative to the United Nations in New York. He however assumed duties on 6th of September 2016 and presented a letter of clearance to the UN Secretary General on the 9th of September 2016. Counsel argued that the second accused did not participate in any of the contract procurement processes, including the award of contract to the contractor, Fairfield Construction. All of the respective processes were carried out while he was at the MIT time, serving as the ambassador of the Republic of Sierra Leone to the Republic of Guinea, with accreditation to Guinea-Bissau, Cape Verde, Mali, and Niger, with residence in Conakry. Council argued that what was the authorized the General Foreign Affairs memo of the 6th of December 2016, as shown in the AQ-104, the second accused will not have signed a contract by using the fact that as political head of the mission, he was neither a member of the procurement committee or unit of the Ministry of Foreign Affairs, nor a member of the procurement committee or unit of Sierra Armed Mission for the purposes of Section 18 and 19 of the Procurement Act of 2016. Counsel further argued that the action of the second accused was not willful or negligent. And with respect to the memo, he argued that the second accused was not according to supervisory law in the contract implementation of control over the rehabilitation of the China's living funds. The funds were disbursed and dated from headquarters of the Ministry of Foreign Affairs. And they referenced the said memo which provided for payments with respect to the rehabilitation work to be approved by the ministry before payment is made to the contractor for each phase of work. He suggested that the second accused would manifestly and wittingly place under the duty to comply with instructions without delay. His goal was ceremonial in nature, but for the erstwhile Digley's memo dated 6th December 2016, he argued that the second accused will not have signed the contract by using the fact that as a political head, he was not a member of the procurement committee. The emphasis on the phrase, quote unquote, without delay, suggesting the second accused was not allowed to do anything contrary to or outside provisions of the said memo. The second accused, he argued, acted in good faith, and the prosecution has not shown evidence to prove the case. Counsel argued that the second accused had no documentation to commit the offenses charged on count 1, 2, 12, and 45 of the indictment. With respect to count 1, Mr. Remy the second accused, argued that the prosecution does not exist evidence to prove that the second accused was in charge of managing the funds for the renovation of the Chancery building, disbursement of funds, or a member of the procurement committee or unit of the Ministry of Foreign Affairs. He went further to say that the prosecution would the procurement was done even before the second accused was appointed. With respect to count 2, Mr. Kamara relied upon the submissions made with respect to count 1. And with respect to count 12, he argued that no evidence used that the second accused signed contracts or an improperly conferred an advantage in the sixth accused to second. With respect to count 45, which charges the offense of conspiracy, he submitted that the prosecution has not shown evidence of an agreement between the second accused and the sixth accused. And significantly, the second accused did not participate in any government process. Counsel argued that the evidence of witnesses contain serious inconsistency. And there was the prosecution's response.
It releasing live
Mr.
coverage.
For the prosecution responded by stating that on Friday, 4th day of January 2023, counsel stamped a notice of mission prosecution for on behalf of the second accused.
Live coverage on Samura Kamara in case you caught.
Following offenses: count 1, failure to comply with applicable procedures and guidelines relating to procurement. Count 2, failure to comply with applicable procedures and guidelines relating to tendering contracts. Abuse of office, contrary to section 421, and conspiracy to commit a corruption offense, contrary to section 128 of the Anti-Corruption Act. Counsel argued that second accused, Sir Senior, appears to have miscomprehended the nature of a notice submission. More importantly, said there seems to be considerable confusion with regard to the law to be applied with respect to the offences to charge. And in that respect, with respect to the charge under section 48 2B of the Anti-Corruption Act, Mr. Conte argued that contrary to the submission of the Defense Counsel in the first paragraph, page 8 of its notice submission, that the prosecution failed to use evidence of probative value. He said that Mr. Kroma failed to take into consideration Exhibit B1 to 52, which is the interview statement of the second accused in his answer to question 8 at page 11 through to page 12, where in answer to the question by the ACC, second accused has said the following: that it is not my duty as ambassador to do due diligence as provided in paragraph number 1 in the memo dated the 6th of December 2016. My duty is to sign the approved standard contract, and it is for the head of chancellery, principal advisor to the ambassador, to do the due diligence. The argument is failure to comply must be a willful omission. According to the natural meaning of language use, negligence is sufficient. It is submitted, he said, that negligence in this context is failure to exercise such care, prudence, that a reasonably diligent person in the second accused position will exercise. Submitted, therefore, that the second accused has a legal duty or responsibility to ensure compliance and exercise reasonable care in handling of government funds. In starting the alternatives willfully or negligently, said section 22, section 48 2B, legislation intended that negligence would suffice in some circumstances. In the light of the suggestion that the second accused deliberately ignored instructions stipulated in the memo dated the 6th of December, which was tendered with AQ 1-4 by failing to confirm with the head of chancellor whether the precondition that a contractor, Fairfield Construction Associates Limited, provide one, a valid business license, business registration certificate, a valid tax clearance, and a record of audited accounts for the past 2 years. According to the second accused, in answer to question 9 of his interview at page 15, B1 to 52, he stated that it is not a precondition for him to see or cite the document referred to under the question before signing the contract agreement. Quote unquote, said, my duty, as stated earlier, was to sign the approved contract. It is the submission of the prosecution in that it is but prudent for the second accused to have exercised due diligence before signing the said construction contract, which is exhibited as Exhibit 1 to 26. I deal with the offense in section 48 2B. Counsel for the prosecution submitted contrary to the defense counsel's arguments in the second paragraph of page 15 of his notice submission. He submits that the cabinet paper, Exhibit AD 1 to 2, does not reflect when cabinet approved the contract. Thus, on page 2 of Exhibit AD 1 to 2, under the caption, is submitted that the procurement was still in process by April 2016 at the time the memo Exhibit 81 to 2 was sent, and that discussions were still ongoing with regards to the nature, format, and contract type when the second accused assumed duty in September 2016 as ambassador and permanent representative to the UN in New York. Abuse of office, contrary to section 4. With respect to this offense, prosecution submits that in further proof of the offences alleged under this section, it has shown that the third accused was acting in the course of his employment as a public officer when he facilitated payments to the contractor through its president, sixth accused, George Sanders Davis, thereby improperly conferring an advantage on him. And with the conspiracy to commit corruption offense under section 138 of the ACC Act as amended. With respect to this count, the prosecution submits that in this matter, the prosecution has made enough evidence to show that the willful act of the second accused not only caused, but also deprived government of public funds. The prosecution referred to the statement of the second accused on the portion of 1 to 52. And in that interview statement, which is part of the prosecution case, they argued that certain issues are raised that require explanation from the second accused. They argued that it would therefore be premature to decide to determine at this juncture that the essential elements for the offense of failing to comply with applicable procedures and guidelines relating to the procurement or failing to comply with applicable guidelines relating to the tender of contracts, abuse of office, constitutes the committee of corruption offense have not been proved. When it is clear in the second accused's own statement that he was the ambassador and permanent representative at the permanent mission of the Republic of Sierra Leone to the UN between 2016 June and 2018 July, that it was during his tenure he signed the construction contract, which is exhibited as 1 to 26 for and on behalf of the government of Sierra Leone, and that he signed the construction contract without confirming that the preconditions as provided in bullet 1 on page 2 of the memo, exhibit AQ 1 to 4, have been complied. With respect to that bullet point 1, it reads, quote unquote, request the contractor fairfield construction associates to provide 1, a valid business license, business registration certificate, a valid tax clearance, and record of quality accounts for the last 2 years. Council argued that evidence abounds for the second accused who is act of mission failed to comply with the procedures and guidelines related to procurement by signing the construction contract, knowing that necessary requisites as detailed in AQ 1 to 4, 2, at 1.1 for signing the said contract has not been complied with. Evidence abounds to say that the second accused who is acting on mission committed abuse of office by improperly conferring an advantage on the sixth accused, Jules Sanders Davis, by signing the construction contract with the U1 for the city, knowing fully well the necessary requisites are completed with AQ 1 to 4 after 1 for signing the said construction contract have not been complied. It further argued that evidence abounds the second accused who is acting on mission conspired with 6 accused to commit a corruption offense by signing the construction contract, knowing fully well the necessary requisites are detailed in AQ 1 to 4, page 2, after 1 for signing the said construction contract have not been complied with. The second accused in his interview with the ACC, acted B1 to 52, asserted at page 11 of the said exhibit in response to the charade that it was not his duty as an ambassador to do due diligence, as provided for in paragraph number 1 in the memo dated 6th of December 2016. And his duty was only to sign the approved contract on behalf of government. In the interview with the Anti-Corruption Commission matter at B1 to 52, at page 40 and question 33, when asked if he knew of the conditions of signing the contract, the second accused said to reply it was a precondition for the contract between fair construction associated for the head of chancellor to comply with before signing the contract agreement. The prosecution submitted that the second accused was the ambassador and permanent representative to the permanent mission of Sierra Leone to the UN between June 2016 and July 2016 failed to verify a very important precondition between Exhibit AQ 1 to 4 before signing the construction contract. A fact that the defense, the argument was not challenged. It is the prosecution's submission that it is the failure as an ambassador to exercise due diligence in the performance of its responsibility to verify a very important preconditions detailed in the AQ 1 to 4 before signing the said construction contract is cogent and compelling evidence of failure to comply with applicable procedures and guidelines relating to procurement and the contract and use of office and conspiracy. Counsel argued that this was not a shifting of the legal portion of the second accused, but a factual inference of common sense that in the absence of evidence of a satisfactory explanation, this court can go from the evidence that that is indeed the case. Thus, if the prosecution, as in this case, proves that the second accused failed by due diligence before signing the construction contract, it may be said that the second accused has the evidential for it to raise or show evidence of an explanation negating the inference of failing to comply with applicable procedures and guidelines related to the procurement, failing to comply with applicable procedures related to the tender of contracts, abuse of office, and conspiracy to commit corruption offense. Otherwise, he stated this court is safe to draw the inference of failing to comply with the applicable procedures and guidelines related to the procurement, tender of contract, abuse of office, and conspiracy to commit the corruption offense. He argued that the absence of a reasonable explanation by the second accused to charges within the indictment does present not only a prima facie case against him, but also gives the full evidence the charges as alleged. It further stated that in fact evidence found that the second accused failed to verify the very important condition detailed in Exhibit AQ 1 to 4 before signing the contract, and the absence of which the construction contract ought not to reside. Prosecution submits on goal, it is established a prima facie case against the second accused, and it is possible that the second accused be put to his offense. I agree with the conclusions in this case submission. I've carefully considered the submission to both counsel in this matter, and as part of the consideration of the notice submission and the response, I've also considered Exhibit AQ4 dated 6th of December 2016 in detail. The said memo required a number of actions to be conducted by the second accused, which are listed in said memo at bullet point 1 to 11. The said memo required and instructed the second accused to comply with all, not some, emphasis of the bullet points 1 to 11 on the same memo. Having considered the totality of the evidence used by the prosecution in this case against him, I cannot, at this stage of the trial, come to the conclusion that in accordance with the Garfield test, there is no evidence that the crime alleged has been committed by the second accused. Further, I cannot also at this stage conclude that the prosecution's evidence taken at its highest is such that the jury, or in this case where I sit alone on the trial of facts, and properly directed myself as the law and facts would not properly convict on it. I however concluded that having reviewed the prosecution's case and the submissions made, and prosecution evidence is such that the strength or weakness depends on the view taken of the liability of witnesses or other matters which are generally speaking within the province of the jury. And where on one possible view of the fact there is evidence for which I could properly come to the conclusion that the second accused is guilty of one or all of the offences charged and duty bound to allow the case to proceed to trial of the evidence, thereby requiring the second accused to offense to the charges he faces. I consider that in accordance with the decision of the Court of Appeal in Gordon 2012 EWCA Criminal 1756, taking the prosecution's case as its highest and having properly directed myself, I could be entitled on one view of the evidence to reach an adverse interest. I am therefore not entitled to stop the case at this point, but to require the second accused to prove the offense in answer to the charges. In the circumstances, the notice of admission that the second accused is overruled and is required to be put to election in the bid to put the offenses to the charges he faces. I don't refer to it. The third accused is charged with 20 counts of indictment, which can be set out as follows: failure to comply with applicable civil guidelines stating management funds contrary to section 48(2)(b) of the 2008 Act, misappropriation of public funds, conspiracy to commit a corruption offence, and abuse of office. It is not in dispute that the prosecution led 18 witnesses in this case who were cross-examined, but they relied on the second day in gathering. Agreement counts 3, 4, 6, 8, 9, 17, 19, 21, and 23, which charges failure to comply with applicable procedures and guidelines related to the management of section 48(2)(b). With respect to this count of indictment, the prosecution case against the third accused that he, by himself, and in some cases, justified in to willfully fail to comply with applicable procedures and guidelines relating to the management of various specified funds in the counts above. The defense disputes it. It is submitted by counsel Mr. Henry Governor to the third accused that neither Fairfield Construction nor its president, the managing member, Mr. Jules and Davis, ever at any point complained of his management of funds or portions of funds due and owing to them, which it is the brother who will trigger investigations into whether procedures and or guidelines follow in withholding such funds. In fact, Fairfield Construction, one of the chances building common new tracks, acknowledged as late 21st of April 2021, not long for the trial of this matter, to no less persons than PWAT Ambassador Dr. Ali by himself, in Exhibit AN1 to 2, to have received well over $4 million United States dollars out of the contract sum of $5,295,755 United States dollars. The said exhibit stated that the invoice sum as $4,669,549.45 US dollars, following a verified audit, and the balance owing to Fairfield Construction.
And then PW18 Ambassador Dr. Ali by himself, in Exhibit A1 to 2, to have received well over $4 million United States dollars out of the contract sum of $5,295,555 United States dollars. The said exhibit stated that the invoice sum as $4,669,549.45 US following a verified audit, and that the balance owing to Fairfield Construction as at 21st of April 2021 was only $626,005 United States dollars. Exhibit A1 to 2 above is a letter from Fairfield Construction and signed and endorsed by Jules Sanders Davis as president. He further argued that the case is premised on the fact that the current prosecution is founded on an existing contract dated the 9th of December 2016, which was lawfully executed between the government of Sierra Leone, represented by the then permanent mission to United Nations in New York, and Fairfield not a prosecution invoked the above clause.
Recording in progress.
In pursuant of the purported non-performance
explained that the new Chancery Department in New York followed correct relevant procedures in matters pertaining to the building project by seeking information and approval of every segment of the project and reporting on the progress of work as well. And PwC explained the procedures involved in the request for forms from the Chancery Capital. The third appeal refers that once the group stopped for the mission, the head of Chancery, administrative head of the mission, takes full charge and controls its youth and responsibility as the vote control of the mission. And further submitted that at all material time served on the new foreign mission, there was no official government settlement, and the mission only limited and adopt procurement units. The third accused also states that they worked within the full mandate and limited the job of financial attaché as set out in the procedures above, as well as the letter from Ambassador Mr. Florence Bangali, deceased with PW12. And he went further to say that because they had no official government unit, they relied on information from the Ministry of Foreign Affairs and approval from headquarters. The third accused further explained that in similar vein, it was at a Chancery meeting held in New York that they agreed for the 5th and 6th floors to be added to the existing structure, and that this was communicated by the head of Chancery, first accused, to the Ministry of Foreign Affairs, and approval was granted by the same ministry, which was repeated at the 25 of the C1. He argued that the various progress reports prepared by PwC Mr. Aaron George as counselor and submitted to the Director General of the Foreign Affairs Ministry on behalf of the first accused were consistent with the fact that the first accused, supported by the third and the fifth accused persons of all material times, kept the Ministry of Foreign Affairs fully informed about the mission's activity, programs, and projects in New York. There were meetings held and those meetings organized and or masterminded by PwC Dr. Ali Kebab, and the self-appointed monitor or overseer of the Chances Building Project Building 17, Dr. Imran Khan, in place of the first accused, which meetings were attended by Jones and Davis for and we have a fair instruction. The following were recorded in various minutes held, various minutes of meetings held on 22nd May 2020 and 1st of June 2020. And since those meetings were held on June 2020, the evidence is required for fair to complete the chance of building in New York so that it can be open for official use. They are not made available to the company. He referenced the 2 technical reports of the chance of building project submitted by PW2 or locally in October 2019 and the AK-146 second technical report in August 2021, and further extracts of the technical report into the AK-146 and AK-13, which dealt with the percentage of works completed from the main building facade to the 5th and 6th floor of the Chancery building, totaling 70%. He concluded that none of the sums of money listed out in count charges under this rubric could be attributed to willful or negligent failure on his part and for the first appeal to follow applicable procedures and guidelines used there. All monies disbursed directly in the construction contract were done in accordance with that contract, and the said company fully acknowledged of the state and expended the money received in the manner specified. He argued that there was no record of impropriety or evidence of impropriety by any of the witnesses on behalf of the prosecution. He went further to say that no witnesses came forward to state the applicable procedural guidelines required to an indictment, not to talk about how the third and fourth willfully reached or failed to comply with any event, and the count involving which were needed to vote should be dismissed against himself and the fourth of guilt. Argument on 5, 7, 10, 18, 20, 22, 24, 27, which deals with the misappropriation of public funds. With respect to this count, prosecution already the third accused by himself and some accused working together with the first accused, Mr. Nalo, misappropriated public funds. He relied on the victim of Rogers' definition of misappropriation in the unimportant case of the state versus Common and Mans, which he says has resonated with the court, and that Justice I, Spain, J.A. and Compton, the same in unreported ACC case of the state versus Aisha Johannes. He further submitted that the above counts are inappropriate in view of evidence then in court against him, that the analysis already confined with respect to previous offense of failure to comply with applicable procedures and guidelines. In light of the above, reference made to AN 1 to 2, in which the sum of $4,669,049.45 US was acknowledged by Mr. Joe Sanders Davis, President, as received by Fairfield Construction. In fact, he went further to say that Mr. Davis acknowledged in the acknowledgement letter of 21st of April that he was looking forward to working with Ambassador Ali Kebab as permanent representative and bringing the charity project to a conclusion, which all parties involved can have. Mr. Joseph has David's witness statement sentenced Exhibit F 126 is declared with admission by him of receiving warnings meant for the transit project for and on behalf of his company, Fairfair. Counts 11 and 25 charges offense of conspiracy. And the third accused argues that the offender willfully failed to comply with applicable procedures and guidelines written to the management of funds or obtaining the contractual fee. And the Constitution did not produce to the court any such applicable guidelines. And no evidence was led that indicated or suggested that the third accused was in any conspiracy with the first accused or any other person unknown. Counsel deals with abuse of office, contrary to section 42(1). And Mr. Fofana for the third accused submitted that the third accused will adopt the argument in self-admission in respect of the previous counter and deny the particular set out in his charge. He relied upon David Montesi's witness statement sent by the prosecution in AX 113 at pages 5 to 10 of the said statement. Mr. Montesi states that due to the COVID-19 pandemic, which added to the company's overheads and rising costs of material, Fairfield was intent on upholding total sum of $3,006,000 for the change orders in respect of the freedom clause, but they were met with heavy resistance of the Sierra Embassy in New York. When the costs and expenses were reviewed and negotiated, the change orders costed only a total sum of $1,800,000, which was consequently paid out by Joseph and Davis in the Empire Group, New York company. The argument that count 43 should therefore be dismissed. I agree with the provided by the prosecution. In response, Mr. Concept of the prosecution submitted that the defense counsel served a no case submission on them on behalf of the client, dealing with 9 counts relating to the management forms, 8 counts of misappropriation, and 1 count of abuse of office. He repeated the point that there had been miscomprehension with the principles involved and relied on the case of Augusta and the State versus Lucille Board and Learders and Shekhar Stevens and another versus the Commission of Police 1960. With respect to failure to comply with applicable procedures and guidelines related to the management forms submitted, the contrary to the submission of the defense counsel on paragraph 14 on page 6, the prosecution had not failed to state and produce to the court the applicable procedures and guidelines it relied upon. He said failure to comply is a willful omission, and according to the natural minimum language used, negligence is sufficient. On the submission themselves, he submitted that the third accused did prepare and make payments to the 6th accused. He deliberately ignored the provision that every acquisition was firstly approved by an architect. According to him, because the contract of the renovation of the Chancery building was signed by the President of Fairfield Construction, even the financial attaché started following requests approved by the head of Chancery in favor of the contractor. With respect to the offense of misappropriation of public funds, the contest admitted that mentally and actively of the kind of misappropriation are based on fraud, not on dishonesty or negligence or willful failure to act as they should, and said that the Elements of the defense are created under Section 36(2) of the Anti-Corruption Act 2008 as amended. And these elements were listed from A to E. With respect to defense of abuse office contract Section 42, they further submitted that proof of the offenses alleged showed that the third accused was acting in the course of his employment. And in the course of that employment, he improperly conferred an advantage on the sixth accused, Jules and Davis. With respect to conspiracy to commit corruption offense compared to Section 188, he argued that they led enough evidence to show the willful act of the third accused not only caused, also deprived the state of public funds. And he referenced the statement of the third accused, which was exhibited as Exhibit C1 to 66. In that interview statement, which said as part of the prosecution's case, there are issues that are raised that require explanation from the third accused. And he respectfully submitted that it would be premature to determine the case at this evidence without hearing from the third accused. He argued that the evidence suggests that the third accused, through his acts and omissions, failed to comply with the procedures and guidelines stipulated within the construction contract, when he consistently prepared and issued payment vouchers and check payment requisitions he received, which were not approved by any architect, thereby causing the state to lose public funds. The third accused, he argued, through his acts and omissions, willfully caused the misappropriation of public funds between December 2016 and 30th September 2018, thereby causing the state to lose public funds. And through his acts and omissions, he also committed an abuse of office. Further, he had conspired with other persons unknown, as well as the first accused to commit a corruption offense by willfully failing to comply with applicable procedures and guidelines related to disbursement of funds for request by the sixth accused. With respect to that, he relied on C1 to 6 and page 54 and question 78 of the third accused interviews to the SEC. He went further to argue that with respect to exhibit C1 to 56, there's an assumption of the file of the said exhibit by the third accused that his duties and responsibilities include to make payments to service providers such as electricity and water payment to staff. At page 12 to 17, he admitted to having made several payments to the contractor, the sixth accused. And exhibit A1 to 2 details the payments received by Fairfield, and further in exhibit AG1 to 7 and AI1 to 7, the requisition of order forms titled application certificate for payment do not bear the name of the architect. And the requisitions also do not contain the signature of the said architect, whereas exhibit AF1 is not supported by any application and certificate of payment for. Alright,
so very sorry. The sound we will get from Zoom in through the court and Zoom meeting.
AG1 to 8 and AI1 to 7. He went forward to say that the exhibits mentioned or reflect and confirms that the third accused was said in the statement of exhibit C1 to 66 at pages 12 to 16 that the initial payments commencing from the deposit in 2016 of $250,000 to the ninth payment made on August 13, 2018 of $187,000 was made by him. The prosecution submits the third accused being the finance as a share between March 2011 and September 30, 2018 to prepare and make the said payments. The fact that the defense was not charged. is the prosecution submission for the failure of finance associated to exercise due diligence in the performance.
All right, for most of us, we don't actually not understand. After the court hearing, we go actually count experts where they can explain within the whole ruling been talek, within at the outcome, the implication to Samura Kamara, all of them thing in there. So once we done the court ruling, we end the broadcast, and the next minute we come back with an expert, we now parliamentary court, parliamentary resident parliamentary reporter Melvin go come in, and analyze the whole ruling for we, tell we waiting at the implication where this get on Samura. So after this broadcast, we're gonna join we back because we come back on YouTube and Facebook. Now we are for make sure say we give you a breakdown for let you understand. So nobody know go and mislead you now. We go better do them for Nanayas, okay? So this type program we had. Now not forget for like and subscribe if you not don't do so yet. Thank you very much. For now, Lord, bear and patience with the sound we will get from Zoom.
The mission that accused to charges within the indictment does present not only a beneficial case, but also strong evidence of the charges as alleged. Counsel finally submitted that the notice submission is incomplete and should be dismissed. I do the conclusion to the notice submission. I've considered very carefully submissions made, particularly with respect to the alleged inconsistencies in the evidence used and in the response from the third accused. Having considered the totality of the evidence adduced by the prosecution in this case against the fourth accused, I cannot at this stage of the trial come to the conclusion that in accordance with the government's case, that there is no evidence that the crime allegedly committed by the fourth accused. Having considered the totality of that evidence, further, I again can at this stage conclude that the prosecution's evidence taken as its highest is such that the jury, or in this case, where I sit alone as a trial of facts and properly directing myself as to the law and facts, would not properly convict upon it. I have, however, concluded that having reviewed the prosecution's case and the submissions made, the prosecution's evidence is such that the strength or weakness depends on the view to be taken of the witnesses' reliability or of the matters which are generally speaking within the province of the jury, and where on one possible view of the facts there is evidence on which I could possibly come to the conclusion that the first accused is guilty of one or all of the offenses charged and duty bound to allow the case to proceed to the trial of the evidence, thereby requiring the first accused to put a defense to the charges faced. I consider that in accordance with the decision of the Court of Appeal in Gordon, taking the prosecution's case as its highest and having properly directed myself, I could be entitled to a long view of the evidence to which an adverse appearance am not entitled to stop the case at this stage, but to require that the third accused be put to his election and put his defense in answer to the charges. In the circumstances, the notice submission by the third accused is overruled and is required to be put to his election, is agreed to put the defense to the charges in favor. The fourth accused. The defense submitted a case notice submission on behalf of the fourth accused on the 3rd of January 2023. I've carefully considered the content of the entirety of the submissions and that of the prosecution in response. The fourth accused is charged with 2 counts of amended 48 count indictment, that is count 47 and 48. Count 47 under section 40 of the Anti-Corruption Act 2008 as amended by the ACC Act of 2019, and the fourth accused also charged with operation contrary to section 36(1) 2008 Act as amended by the 2019 Act. The submission relied upon by the Anti-Corruption Commission Act as amended by Council and Criminal Procedure Act and also counsel for relying on the Evidence Act, which is unknown, and the Public Procurement Act 2016 as amended. Further, the Defense Counsel relied on the following: rulings in DPP, Top B Commissioner of Police, Abbey of Jones, Gabriel, and Lord Parker's practice direction on nuclear submission 1962 and local authority on misappropriation. They also relied on a number of exhibits pretended by the prosecution in the case, which can be set out as follows. Exhibit D1 to 58, interview statement of the court accused. Exhibit U, the construction contract, the renovation of the Chancery building in New York, dated the 9th of December 2016. Exhibit AC 1 to 5, cabinet paper dated 18th of April 2016. Exhibit AB 1 to 2, the new paper dated 18th of April 2016. Exhibit AQ 1 to 4, the Director General of Foreign Affairs letter dated 6th of December 2016. And exhibit AS 1 to 4, which is the invitation to bid to renovate the Chancery building dated 21st of September 2015. With respect to count 47, he is charged with receiving the principal contrary to section 43, subsection 3 of the Anti-Corruption Act 2008 as amended in 2019. And with respect to count 48, he is charged with misappropriation of public funds contrary to section 36(1) of the 2008 Act as amended in 2019. The primary submission by counsel is that the indictment that charges the fourth accused describes him as being a former Minister of Foreign Affairs and International Cooperation. And the argues that the fourth accused at the time the alleged offence was committed was not a former minister, but a substantive minister. And clearly, he argued that the discrepancy between the description of the said accused and actions for which he is purportedly charged. And he addressed the court on this issue in his submission. Counsel further submitted that it's the duty of prosecution to guilty or accused beyond reasonable doubt. Where the prosecution failed to attain this sexual duty in incident case. The fourth accused should be acquitted and discharged by this court on both counts by reason of the following matters. Well, with respect to count 47, which is the charge of receiving the principal contract 40, subsection 3, it is submitted that the prosecution should only succeed if they are able to prove beyond reasonable doubt the fourth accused knowingly and intentionally submitted to the cabinet take the document that was misleading and untrue, and with intent to mislead, presumably the government of Sierra. No evidence whatsoever was led to that effect. Counsel referred the court to exhibit G1 to 58, which was the statement obtained by the Anti-Corruption Commission from the fourth accused over several days. In their consent statement, the fourth accused categorically refuted the allegation of misleading the principal. Counsel rhetorically asked the question, what is the evidence before the court? And with respect to that question, we relied on D1 to 58, in which the fourth accused totally denied the accusation of misleading the government of Sierra. Counsel also referred the court to the AC 1 to 5, which is the cabinet paper dated 18th of April 2016, and the 81 to 2, which is the main paper dated 18th of April 2016, neither of which the argument was offered by the fourth accused. This, the argument, was confirmed by the testimony of PW3, Mrs. Sonia Kayen, who testified in court that the AC 1 to 5, the cabinet paper dated 18th of April 2016, was prepared by the Cabinet Secretariat in conjunction with the Directorate of Foreign Affairs on International Cooperation without any participation by the fourth accused. Following from that, Mr. John Shemaya, the former Cabinet Secretary and Head of the Civil Service, testified that the fourth accused was not present in Cabinet and did not present or participate when the matter of AC 125 was discussed. From technical glitch. Okay.
Alright, we very one just for say continue for watch we just that lights don't go na courts and now make the Justice Adrian Fisher don't actually stop first. Then they try for put things in place for let them get power again. So then go continue for read the rest of the ruling. So continue for day with we. This now your channel. We are on YouTube and on Facebook. And like I say, after this ruling from Justice Adrian Fisher, remember say this now no case submission where Dr. Samura Kamara and the other one them lawyer they do na court. So this ruling will get plenty other meaning. So what we go do after we actually done for air this, we go stop the broadcast and come back with Melvin Tijan Mansari as Ingo come basically for analyze the ruling and we go look at what will be the implication for this particular thing. All right, in terms of what it will mean for him in candidacy as a presidential candidate, what it will get for mean for in political career, all of them things, and we get for look at them because this one remember one of the thing with the tag under a name na dishonesty, as they say it mislead the how they call them in principle. So we go actually come in and analyze all of them things in this. So in the meantime, lights on can don't fix things in place. So let's go back and listen within Justice Adrian Fisher they say. And please let's manage the sound because now through Zoom we get them. We never forget direct connection. And we better because AYV they continuously they go in and out. So let's manage what we get until we get what we want, okay? Stay with me. This is how we are.
If they are able to prove the unreasonable doubt, the fourth accused knowingly and intentionally submitted the cabinet documents that were misleading and untrue and with intent to mislead, presumably government officials. No evidence whatsoever would relate to that effect. They filed the court with D 158 statement obtained by the agency from the fourth accused over several days. In their first statement, the fourth accused categorically refuted the allegation of misleading the prisoner. They asked the rhetorical question, what is the evidence before the court? And in respect of that, in light of the D 158, in which the fourth accused denied accusation of misleading the government of Sierra Leone. They argued that the evidence of PDB related to Sonia Karim, who testified in court that the AC-1 filed as a cabinet paper dated 18th of April 2016 was prepared by the cabinet secretariat in conjunction with the Directorate of Foreign Affairs and National Operation without the participation of the fourth accused. Following from that, Mr. John Samura, the cabinet secretary and head of the civil service, testified the fourth accused would not be the cabinet and did not present or participate when the matter of the AC-1 to 5 was discussed. Furthermore, the testimony of Mrs. Carrier Basil, Paragraph 12, is instructive. She has stated that the fourth accused was not involved in the preparation of cabinet paper as the AC-1 to 5, nor to be signed or concerned with the implementation of projects. She emphatically told the court that the implementation of projects approved by cabinet was the business of civil servants, and that the minister can only be informed of progress. Council further denied the evidence of PWT and Iqbal and confirmed this narrative in his testimony to the court. It stated that the minister is generally not involved in financial matters or the implementation of projects at the Ministry of Foreign Affairs, where he once served as minister. The prosecution, he argued, would therefore not provide any sufficient evidence beyond a reasonable doubt to the fourth accused deliberately, knowingly, and unintentionally misled the principal, to which supposedly the government of Sierra Leone. On the contrary, argued that there is uncontroverted evidence that by the time the fourth accused left office in 2017, the sum of $2 million United States dollars was already ring-fenced for the New York Chancery Building project. And he argued that the confirmation of this from vocally known PW1 who testified that the investigation of the matter by the Anti-Corruption Commission revealed that the sum of $2 million had indeed already been deposited into the consolidated revenue fund at the Bank of Sierra Leone. They further argued that on the totality of the evidence, therefore, the prosecution of failed in its duty in that they produced no evidence beyond all of that four accused knowingly and intentionally misled the within the government of Sierra Leone in this regard. Accordingly, they submitted that the court must by law acquit and discharge four accused who want any evidence to charge today. Counsel further argued that the prosecution proved that the fourth accused knew the effect of his conduct as being misleading to the principal, misleading the government of Sierra Leone. In the instant case, the fourth accused neither prepared nor did he present cabinet paper as the AC-1 to 5 cabinet. Consequently, it would not have deceived or knowingly presented misleading documents to the principal. The resultant effect is that the prosecution failed to prove the case against the fourth accused on count 7 of the indictment. Further, defense counsel submitted that the interministerial committee is tasked with the implementation of the cabinet conclusion. This consisted of the Ministry of Foreign Affairs and National Education, Ministry of Works and Housing and Structure, Ministry of Finance and Economic Development, the Attorney General and the Minister of Justice, the National Public Procurement Authority, Sierra Leone Permanent Mission to the United Nations, and the Office of the Chief Staff. He further argued the fourth accused had no part whatsoever in all of this, other than having been nominal Minister of Foreign Affairs and International Cooperation. Monies were transmitted without knowledge, approval, or participation. He was neither copied in on any correspondence, nor did he take part in the proceedings or financial transaction whatsoever in relation to the New York Transit project. And consequently, they reiterate the fact in the submission there is no evidence or no sufficient evidence for which the successful prosecution and conviction of the fourth accused will be secured. With respect to count 14, the fourth accused charged with misappropriation of funds under the section 36(1), and counsel submitted for the appeal was in no way either by action or omission implicating the charge. The evidence presented did not prove the element for successful prosecution of the offense of misappropriation. Counsel further relied upon the opposition, the basis of the dictum of these principles laid down for successful prosecution in the case of State versus Aisha Johansson and Christopher Kamara on the reported, in which Finn J. described elements of the application. The land judge, the argument went on to cite the approval with several victims honorable to Eddie Brambach, J.A. as a then one of the reported case of state becoming a man, where it described the application in the following words. It has involving the assumption of rights of owner, and in this case, willful commission of acts, which results in owner losing funds belonging to it as amounting to its application. Counsel argued it is clear, therefore, the prosecution must prove that the defendant took the money alleged to have been appropriated dishonorably, and proof of such application can be found in the actual taking, as per the dictum of Honorable Justice I.S. J.A. In summary, counsel further submits that the prosecution did not believe or tender evidence that even remotely suggests the fourth accused while serving as Minister of Foreign Affairs and International Cooperation appropriated or took all or any part or parts of the funds allocated for the rehabilitation, construction of the Syrian Chancellor building in New York. They argued that as a matter of fact, there was documentary evidence of the fact that Jules and Davis, the sixth accused, acknowledged the state all payments made to Fairfield Construction LLC in respect of the deferred budget. Counsel further submitted that applying the said dictum, prosecution did not believe or tender any evidence that even remotely suggests that the fourth accused, while serving as Minister of Foreign Affairs and International Cooperation, appropriated or took any of the funds allocated for the rehabilitation of the Syrian Chancellor building of the New York Charity Commission. They relied on the evidence of PW1 and concluded that there is no sufficient evidence to place the fourth accused. On the issue of dishonesty, counsel submitted that the fundamental question of the test is having regard to the totality of the evidence and bearing in mind the absence of any shred of evidence for the accused appropriated or any part of the deferred funds, can the prosecution seriously and or successfully argue that the fourth accused committed any act of dishonesty. The case of Gabriel was relied upon to substantiate this submission. Counsel further argued the evidence led by the prosecution up to close of this case establishes no nexus to the fourth accused and alleged offenses committed, and evidence is therefore insufficient. And additionally, so tenuous that it is mostly unlikely to secure a state conviction in any circumstance, including a jury trial. The further submitted for the bill have no issuance and will end with partly law as stated at page 14 of Blackstone's criminal practice of 2002, which reads that a notice submission must be considered if the prosecution witnesses evidence too inherently weak and vague for any sensible person to rely on. Counsel further went to state that, in other words, the judge need not pretend to believe arrant nonsense. Thus, if the witnesses undermine own testimony as in this case by considering that they are uncertain and vital points material to prove essential element of case, or if what they say is manifestly contrary to reason, judge may be entitled to hold that no reasonable jury properly directed will rely on the witness's evidence, and therefore, in the absence of any evidence, there is no case for us. I agree with the response of the prosecution. The prosecution responded to no case submission by the defense, relying on the following matters. One, the indictment refers to the former as the fourth accused was not the Minister for Foreign Affairs and International Cooperation as of the date of the indictment. Two, the prosecution fails to prove the case against the fourth accused beyond reasonable doubt did not be inquired into aspect at this stage of the trial. Thirdly, reference is made to Section 39(7)(a) of the Anti-Corruption Act of 2008 as amended, which provides as follows: the cabinet minister should be free to be an agent for both cabinet and the government. It is submitted therefore that even if the indictment had not so claimed, self-revision would have been in place. Section 40, subsection 3 of the Anti-Corruption Act of 2008 provides inter alia that an agent who detriment of its principal uses or gives to its principal a document that arose contains anything that is false or misleading in any material respect commits an offense. Counsel for the prosecution in the contest submitted further that the phrase in any material respect in this provision and within the context of the court gives a statement to cabinet as set out in the cabinet paper, which is exhibited as AC 1 to 5, must mean the fact of verification and vetting which the accused submitted and which the court accused cannot now support by evidence. It further submitted that the claim in any material respect in this provision and within the context of the fourth accused statement cabinet AC 1 to 5 must mean the fact of verification and vetting which the fourth accused submitted and which he himself cannot now support by evidence. He submitted that the fourth accused knew at the time of submitting cabinet paper that he did not have at his disposal any facts of vetting or verification, and that it is to be implied that even if there was no falsity, there was at least an entity to which that the cabinet was misled, resulting from the categorical statement in the document. It further submitted the proper approach to local submissions in that set out in the case of Gary and the case of Gordon 2012 in the Wales Court of Appeal Criminal Security 56. Counsel further submitted that there is need to consider the evidence and court, as was illustrated in the case of Sheep 1988, Criminal Law Report 77, and the decision he argued did not depart from the two-legged tests in the 1 and 2 as set out in the closer to home, he further argued that the state versus the state born, the others, after referring to the legal cases of Gabriel and Shepard and another, were clear in the point that the accused should be acquitted on a notice submission where there is just a mere scintilla of evidence. He went further to cite the following word. Here I have to view that at the close of the prosecution case, there is more than a scintilla of evidence positive that matters which the prosecution has to prove, taken at its highest, it is evidence of which the jury properly directed could convict. It is another matter which I have to decide at the end of the case, but not at the start. I do defend the receiving principle contrary to section 43 of the Anti-Corruption Act as well as against the men. With respect to this offense, the prosecution submitted that it was established that the fourth accused was the Minister of Foreign Affairs in 2016, and that in his capacity as Minister, he presented the Cabinet for the consideration and conclusion of a Cabinet paper, which was exhibited at the ASO 1-5, in which the following statement was made. The companies undertaking the construction, renovation, and liable and were subjected to rigorous vetting. Counsel further argues that one, the fourth accused must of necessity have submitted said paper with the intent the Cabinet will accept such proposals. And secondly, that as the Minister will suffer responsibility, the onus and responsibility will on him that at the end of the day, such statement was true and was being presented consciously. And third, by implication, fourth accused would say, even though in not so many words, that the said companies, including Fairfield Construction, were to be relied on by Cabinet and the government. Prosecution further submitted, therefore, the fourth accused was submitting to Cabinet through the white paper that the company being recommended had been scrutinized in a thorough, logical, and scientific way, and that the same had been examined with extreme care, and as a question of fact that what the fourth accused was suggesting was not the case for the following reasons and the given following circumstances which are set out in the submission. Counsel further argued that the statement to Cabinet was submitted on the 18th of April 2016, and the decision was taken on the 22nd of April 2016 by Cabinet. In that light, he argued that it is significant to note the contents of the fourth accused statement to the Anti-Corruption Commission. In that statement, at the 20, the fourth accused was asked what legal vetting had been done in respect of the said company, and the fourth accused replied that he could not tell. He stated clearly on the same page of his said statement that the Cabinet paper he submitted was based on information by the Interministerial Technical Committee, which had been ordered by Cabinet. Counsel for the prosecution disputes this version of events on the basis that the said committee came into existence or was ordered to be formed after the said Cabinet paper had been presented to Cabinet for the on the 18th of April 2016. In that same interview, he argued what accused could not tell who the members of the said committee were, but more interestingly, after several suggestions had been made for the interview, he agreed that there may not have been any vetting at all of the company referenced in his Cabinet paper, thus establishing Cabinet was said. Reference was made to foreign issues which suggest that at the time the Cabinet paper was being presented to Cabinet, the Ministry of Foreign Affairs and International Cooperation was not in possession of relevant facts on which the fourth accused would have based his judgment of proper scrutiny or vetting. By a memorandum from the then Director General and Ambassador obliged to the Minister of the Penitentiary and Head of Chancery dated the 6th of December 2016, which is Exhibit AQ-1-4, the Head of Chancery was inter being asked to ensure that the following details were to be supplied by the contractor Fairfield Construction Associates. 1, a business license. 2, a valid tax license. 3rd, a record of audited accounts for the previous 2 years. This memorandum of the 6th of December 2016 was said to have been as a result of a memorandum dated 30th of November 2016 from the then Solicitor General giving his opinion on the matter. However, 3 days subsequently, the Director General and Ambassador at Large had sent this memorandum to the Minister of Penitentiary and Head of Chancellery that a contract between Fairfield Construction Associates LLC and the government of Sierra Leone was signed by the second Q. I'll deal with this information public. With respect to this count, the prosecution placed reliance on the interpretation of the words willful as enacted in section 36(2) of the Corruption Act of the Men. The ingredient of the said offense is declared in some cases like the state of State v. Lukule and the State v. Kamara as intentionally, recklessly, deliberately, though some people suggested counsel argued the little meaning of deliberately or voluntarily should not be the answer. Counsel for the prosecution submitted that it was by the aforementioned act by the fourth accused public body of government was subsequently decided when all of the disbursement payments made to and received by the contractor Fairfield Construction Associates during the period of 2016 and 2021. He further submitted a question fact that had there not been the said cabinet paper exhibit AC 1-5, which the said statement contained therein that was made by both accused and signed. All the consequential circumstances resulting, therefore, may have been different. The issue which triggered whole scenario from 2016 to 2021 was the cabinet paper 18 April 2016. In conclusion, the prosecution counsel submitted the established prima facie case in the fourth accused, and it is thought that the fourth accused will put to his defense. The no case submission is ill conceived, this matter, and the case should not be stopped as there is overwhelming evidence against the fourth accused that need to be addressed. I deal with the conclusions of this investigation. I've carefully considered the submissions made by counsel for the prosecution and the defense. And in light of the submissions made, I have gone on to carefully consider exhibit AC 1-5, which the prosecution alleges was the vehicle through which the offenses allegedly committed by the fourth accused were so committed. The said exhibit is a cabinet paper which makes the following points which I consider expedient to set out, albeit in summary form. Well, firstly, that the document is dated the 18th of April 2016, was a memorandum by the Minister of Foreign Affairs and International Cooperation. 2, the Cabinet was invited to consider a number of recommendations, which include the following matters again in summary form. 1, approval of option 2, totaling $2,560,000 United States dollars as the cost of completing the rehabilitation of the Chancery building in the New York mission, subject to negotiations with Fairfield Construction Associates and the government of Sierra Leone to be represented by the Ministry of Foreign Affairs and International Cooperation. Second, authorization of the transfer of the sum of $2 million United States dollars by the Ministry of Finance to the permanent mission of Sierra Leone in New York, being grant funds provided in 2012 by the People's Republic of China and ring-fenced in the budget for the rehabilitation of the Chancery building in New York. Third, authorization of the transfer of the sum of 500,000 United States dollars by the Ministry of Finance to the Permanent Commission in New York, the budgetary allocation of said rehabilitation. Four, authorize the Ministry of Foreign Affairs, Finance, and the Attorney General and Minister of Justice to monitor and supervise the rehabilitation works to the Chancery building and residents in Ethiopia and provide regular reports. Fifth, no addition of fourth floor and a construction period of 36 weeks, to name a few of financial implications as provided for in the said memo by the then Minister of Foreign Affairs and International Cooperation, who is the fourth accused. 6. Consultations across government were carried out with the Ministry of Foreign Affairs, Ministry of Works, National Public Procurement Authority, among others, the Office of the Chief of Staff, and the Office of the Attorney General and Minister of Justice, amongst others, and that they were issued with concurrence of the acting Minister of Works, Housing, and Infrastructure. 7. Evidence that the proposed intervention is needed and will include an advantage that the companies undertaking the innovation construction are liable and are subjected to a rigorous vetting process. 8. Annexed to the document is a document from Fairfield Construction Associates in respect of the New York mission dated the 4th January 2016 and addressed to the 4th Q. This document refers to a meeting held on the 30th of December 2015 and was signed by the 6th accused. And 9, the document itself has the signature of the 4th accused, Dr. Samura Kamara, as the Minister of Foreign Affairs and International Cooperation. Having considered the totality of the evidence used by the prosecution in this case against the 4th accused, I cannot at this stage come to the conclusion that in accordance with the Gallagher test, there is no evidence to the crime alleged to be committed by the 4th accused. Further, I cannot also at this stage conclude that the prosecution's evidence taken as its highest is such that the jury, or in this case where I sit alone trial of facts and properly directing myself as the law and the facts could not properly convict the police. I have, however, concluded that having reviewed the prosecution's case and the submissions made, the prosecution's evidence is such that the strength of witness depends on the view taken of the witness's ability or other matters which are generally speaking within the province of the jury. And where on one possible view of facts, there is evidence which I can properly come to the conclusion that the 4th accused is guilty of one or all of the offences charged and guilty bound to allow the case to proceed on the evidence, thereby requiring the 4th accused to put the defense to the charges he faces. I consider that in accordance with the decision in Godfrey 2012, England Wales Criminal Court 1756, taking the prosecution's case at its highest and having properly directed itself, I could be entitled on one view of the evidence to reach an adverse inference. In those circumstances, I am not entitled to stop the case at this point, but to require the 4th accused to put the defense in answer to the charge. In the circumstances, no case submission by a 4th accused is overruled and is required to report to inspection in the bid to put his defense to the charges he faces. I'll do the 5th accused. The 5th accused submitted his notice of submission on the 23rd January 2023 and is charged with 16 counts of offences summarized as follows. 1 count of conspiracy to commit corruption offense, 8 counts of failure to comply with applicable procedures and guidelines relating to contracts, contract section 48 2008 Act was amended in 2019, and these were with respect to counts 26, 28, 30, 32, 34, 36, 38, and 40. And 7 counts of misappropriation of public funds, contrary to section 36(1) of the Article Act 12/2008, as amended 2018, as contained in count 29, 31, 33, 35, 37, 39, and 41. With respect to this notice submission, the PDQ relies on both names of the candidate text to submit, which should not made out its case, and they are making a notice submission because they feel is on no obligation to respond to tenuous and vague allegations. The proper approach to submission of notice answer is very well used to establish and rely on tests set out in the guarantee. Notice submission of PDQs is summarized as follows in respect of section 48(2)(b) of 2008 Act, count 26. The defense refers to the fact that this count alleges the PDQ the financial attaché of the Family Commission to the United Nations in New York on a date unknown between the 1st of January 2017 and the 30th day of November 2017 at the UN Mission in New York, negligently failed to comply with applicable procedures and guidelines relating to the management of funds with payment of the sum of 35,000 United States dollars to Jules and Davis, President of Fairfield Construction. Council further relied on the E1 which shows the sequence in to some parts of 2018, the field person was a senior accountant in the Ministry of Health and Education and worked in August of 2018 that was posted to the Family Mission of Sierra to the US in New York. In fact, it was the end of September 2018 that they took over a third position as financial attaché. Before they submitted, the field was not even posted at the said mission as at the first day of January 2017 and the 30th day of November 2017. Council for the argue the fifth use as an alibi for failure question, and to that extent, the fifth use agreed categorically declared that it was a missed health interpretation as senior accountant in 2016 to some part of 2018. He argued that the state failed to investigate what essentially was an alibi raised by the fifth use. And the fifth use should be charged on count 6. With respect to count 28, 30, 32, 34, 36, 38, and 40, these charge principles comply with the procedure guidelines related to the management of funds, 42 billion Agriculture Act of 2008. The spending that refers to the provision of the 48(2)(b) and the Attorney General's reference number 3 of 2004 as the approved definition of brief, and he alluded to the point as legal to do something which is wrong, knowing it is wrong, or is indifferent as to whether it is wrong or not. The evidence reveals the PDQ was not present at the mission in New York when the construction started and came at the stage of the prosecution process. The PDQ was assisted and partner which he followed accordingly, and all the parent branches by him were duly authorized and signed by head chancellery, who at time was the boss PDQ. Counsel for the argument throughout the prosecution case, no manual was tendered, given the procedural guidelines that were breached or not complied. No payment will be made without approval of the head of base and confirmation or authorization from the head of transit. The idea that the pre-accused person will work fully within the confines of the job of financial attaché said mission. At no point in time was ever playing about following due processes or willfully negligently failed by procedures or guidance. Some total of the submission of the accused should be charged on counts 28, 30, 32, 34, 36, 38, and 40 of the amended indictment. With respect to count 29, 31, 33, 35, 37, 39, and 41, the local submission rested on the point that the prosecution allegations are predicated on the fact of the big and prosecuted with afflicting public funds with $500,000 United States dollars, $553 US dollars, $329 US dollars, $995 US dollars, $150,000 US dollars, and $202,000 US dollars we can pay to Joe Sanders David, the president of Fairfield. It's officially that it is uncontroverted that all of this payment is those persons. And all the witnesses of the prosecution confirm the same, that the said defendant never used any issue of any of the said sum was not paid to him. Nothing was done by the fifth accuser to impede dishonesty of his part, as all the vouchers caused by him were being paid to the six accused persons in all meetings, and the fact that came out blinded said forms received by the six accused, and those that granted the order of the court charge the fifth accused of all the offenses. With respect to count 42, the defense of conspiracy to commit offense, counsel for the fifth accused submitted that the accused would be charged as evidence because the court is weak and unreliable. The conviction is obtained at the end of the trial, which will give him so much hardship on his part and waste of the sources of the court. The prosecution, in response to the late submissions filed by counsel, fifth accused, dated the 8th of February 2023, argued that on Friday, the 27th day of January 2023, counsel for the fifth accused served a notice submission on the prosecution for and on behalf of the fifth, who stands charged with 16 counts under the Anti-Corruption Act 2008 as amended. These counts are set out in this book and in response, the prosecution contends that on an assessment of the totality of the evidence led by the submission of no case against the fifth accused was failed. It was submitted that certain of the offenses charged against the fifth accused by their very nature and definition require the fifth accused to profile an explanation. These are the cases of the argument with respect to which the law imposes the duty of the fifth accused to act in a specified manner, and the evidence shows the failure to do so. In such cases, it's submitted by the prosecution that a no case submission is likely to be without the fifth accused being given the opportunity to prove always on the balance of abilities that he acted according to the precept of the duty imposed on him by law. To curtail proceedings as close from the proceedings if in such cases that evidence would offend against the dictate of the law. Prosecuting counsel came for the argument the question of whether the approach of the court should be different in the determination of no case submission, whether the prosecution case is based wholly or partly on the findings to be drawn on circumstantial facts. However, he argued that the court must, in accordance with the made and the God of testing, consider and evaluate the whole of evidence used by the prosecution. And should there be any inconsistency of prosecution evidence which may impact on the reliability of such evidence, the case must continue for the assessment of the evidence by the court at the finalization of the matter. The evidence must be considered as a whole, as was stated in shipping. Further reference is made in the case of the to bond and other prosecution tender and proper identification of the element of the child apprentice that the extent of the evidence led by the prosecution. In no case, submission must be complete. In response to the charge under section 48(2)(b), counsel for the faith accused advised that the prosecution had failed to tender any manual to the court that states that the applicable procedures and guidelines should be relied upon in proof of this case to the court. Counsel for the prosecution disputed this and argued that it's a well-known principle of common law that legislation, statutes, and regulations in particular are ruled simply by the court taking judicial notice of the existence and familiarity of the court. In support of that position, counsel relied on the authoritative text of witnesses and evidence, where the land often had this to say that judicial notice is to be taken of the existence and content of all public statutes and all acts of parliament of public nature, as well as of every branch of unwritten law obtained in England. Thus, if in a common law court points of equity or of parliamentary, ecclesiastical, or admiralty law rules, even before the judicial acts, they are to be determined not by calling experts, but by the court itself, either of its own knowledge, or by inquiry, or by hearing authorities and arguments. Consequently, counsel argues that the argument filed by the accused with regard to the claimed absence of proof of applicable procedures, guidelines, and law must not be countenanced by the court. The prosecution recognized it and stated by counsel that the faith accused was not posted at the said mission as of the 1st of January 2017 and the 30th day of November 2017, and therefore could not have made the said payment charge in count 26. However, they contend that the faith accused in the witness statement to the Anti-Corruption Commission dated the 26th day of July 2021 in Exhibit E1 to 58, Article 34, in the response to question 6, stated that he had processed payment 8 times as follows. First payment was made on November 28, 2018, in the sum of $35,000 US. This is corroborated by the state accused in the witness statement Exhibit F1 at page 22, when he was asked in question 38 the following question. Take a look at the payment voucher dated 28th of November for the amount of $35,000. Was it you that signed for and received the amount on the said payment voucher? To which the faith accused replied yes. Take a look at the AL1 to 2, and the prosecution further goes on to say how the 6th accused recorded that he received the payment of $35,000 United States dollars on May the 4th, 2017, and that there is no record in the AL1 to 2 reflecting that the 6th accused received any payment on the 20th of November 2018. The prosecution further argued that the faith accused witness statement to the ACT dated 6th July 2021 will question payment process, informed investigators, and which is of some significance is the following exchange which investigators of the ACC had with the faith accused. Question 66. How many times have you processed payment made to the contractor Fairfield Construction Association? Answer: process payments 8 times. From page 34 full to page 37, E1 to 58, counsel argues that it's a reduction of the way of payment made, largely under the violation of first accused as vote controller without following any established procedure, let alone the procedures guidelines related to the management of funds. a confirmation of payments made of charge in count 26, 28, 30, 32, 34, 36, 38, 40 were shown for. Council further argued, contrary to the submission of the physical council, the submission, the petition does not fail to tender or provide a court with the manual and state applicable procedures and guidelines were released or not compliant. Council for the physical failed to take a look at the new 106 Article 7, payment to contractors at page 10 12. The construction contract between the permanent mission to the United Nations and fair pay construction. Article 7, paragraph 701A provides the contractor and architect to meet at the work site to review the contractor's performance and completion of certain items of work, and that requisition for payment must be approved by the architect. The said requisition should set forth the proportion of the contract from property allocable to labor, materials, and equipment actually operated in the work. Council further referred to the fact that the accused by his own admission admits that he had not read the construction contract, specifically Article 7, prior to the commencement of the ACC investigation. And a reference to that is set out in the interview dated 6th July, which is in E1 to 8 at page 34, question 35. And question 65, sorry, when the question was asked, when did you give said portion at 7 July? The official contract, the basic unit was still written at the end of September 2018, and this was verified in response to the E1 8, in response to question 8 at the time of the interview dated 21st of June 2021. But they said that they would only make payments without having read the construction contract, which is the U1 or in fact, seven payments to contractor of the construction contract. Council was arguing that not only the big field to pay and make payments, stick field is deliberately ignored.
Recording stopped.
Bang bang, na 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 na. Raga boys, whoa whoa. Oh lad, yoga. Oh lad, lad, lad. What? Cash record 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. Lord, I can feel and proceed. The poor man they suffer, the rich man no they offer. I can feel and foresee. Money no there, how them go suffer. I can feel and foresee. Poor one they don't know the butter them bread. I can feel and foresee. But you don't sit, you not get you great. I said there's too much pressure on the people them eat. You make man just fed up. Too much pressure on the people them eat. You make me just they cry. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. You know me say because of we born from poor. Yeah, yeah. That's me say we for die from poor. Whoa, whoa. You know me say because of
All right, we're very much sorry. They get connection with the Zoom again. I don't know what happened, but they say then they get connected again very, very soon. So please, no go on side. We go basically come back to just now with the rest of the ruling for let we know what's in the happen. Again, don't forget, say after this particular ruling, we don't end the broadcast, we come back for can analyze the whole ruling, what it mean, and particularly the points to the flag bearer for the APC, we say part of the one that we accused inside this case. And remember, say this is a case between Samura Kamara and the president of the Republic of Sierra Leone, because the complainant inside this case now President Bio. So they come talk to you why we say so, and waiting the Anti-Corruption Commission be actually say with regards this particular thing. No go on side and continue for the way. In the meantime, let's just listen music whilst we get connected again. And if you don't like the program mates, please now for continue now for do so now. Thank you very much. On YouTube, we get 709 with the watch with 529. And on Facebook, we get 681 with 4. Okay, thank you very much for the likes. Thank you very much and for the share as well.
Cash record 1,000 for the day. Some people not get time for it, I must swear. 5,000 for the day. Some people not get time for it, I must swear. 5,000 for the day. Some people not get time for it, I must swear. 5,000 for the day. Poor one not get time for it, I must swear. Lord, I can feel and proceed. The poor man they suffer, the rich man no they offer. I can feel and proceed. Money no there, how them go bluffer. I can feel and foresee. Poor and then another butter them bread. I can feel and foresee. But you don't sit, you not get you great. I said there's too much pressure on the people them eat. You make man just fed up. Too much pressure on the people them eat. You make me just they cry. 5,000 for the day. Some people not get time for it, I must swear. 5,000 for the day. Some people not get time for it, I must swear. 5,000 for the day. Some people not get time for it, I must swear. 5,000
to which I already alluded. He went further to say that not only did the 5th accused prepare and make payments to the 6th accused, he deliberately ignored the provision.
Position being approved by an architect. And in his witness statement to the ACC, the 5th accused is said to have claimed that the head of Chancery, who is the vote controller, explained to him that the contract terms and specifically the payment terms, and there was an ongoing payment towards the project before his arrival. He went further to submit that it was by the aforementioned act that the 5th accused that the government of Sierra Leone were deprived when all the disbursements were made and received by the contractor Fairfield Construction. Further argued, there is a question of fact. The 5th accused familiarized himself with the exhibit EU 1 to 26, and had he done so, the construction contract between Permanent Mission, the Republic of Sierra Leone, to the United Nations and Fairfield Construction before preparing and making payments to the 6th
all of the consequential circumstances resulting may have been different. With respect to the federal conspiracy, counsel submitted there is no doubt whatsoever that the accused persons committed these offences in their individual capacities and as well as in a constitutional capacity by failing to comply with the applicable procedures and guidelines. He argued that the 5th accused's argument is contained in the last paragraph of his submission that for the totality of the fact that he conspired with any of the accused persons, he argued that not even the first accused, whose counsel in court at a stage even grew annoyed on the basis that the 5th accused was trying to shift the burden had been sustained for reasons already canvassed in the prosecution's response. Evidence has been led of a willful act, and they submit that on the whole, a prima facie case has been established against the fifth accused and should be put to the defense. The prosecution submits that the no case submission is ill-conceived and the case must put to trial. Conclusions on the no case submission. I have carefully considered submissions of counsel for the fifth accused.
AYV is your home of credible, factual, and balanced news coverage. We pride ourselves as the nation's most trusted news source. Because of this, our brand is likely to be used to spread fake news. To verify our stories, please check our various social media pages, visit our website on www.ayvnews.com, or send us an email to info@ayvnews.com.
Bang bang, na 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 na. Raga spice, whoa whoa. Oh lad, yaga. Oh lad, lad, lad. What? Cash record 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. Lord, I can feel and proceed. The poor man they suffer, the rich man no they offer. I can feel and proceed. Money no there, how them go suffer. I can feel and proceed. Poor one they don't know the butter them bread. I can feel and proceed. But you don't sit, you not get you great. I said there's too much pressure on the people them eat. You make man just fed up. Too much pressure on the people them eat. You make me just they cry. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. You know me say because of we born from poor. Yeah, yeah. That's me say we for die from poor. Whoa, whoa. You know me say because of we born from poor. Yeah, yeah. That's me say we for die from poor. Whoa, whoa. We not like that. The way the system they blow, we not like that. They want them where they before. Power, you free tell them they know this. 5,000 for the day. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. 5,000 don't make Baku man go to prison. You know easy as well. 5,000 don't make Baku baby then sell girls. I saw the thing, yeah. 5,000 don't make Baku man lost their life. Kiribi won't pass. 5,000 don't change the whole wide world. The way the poor man them suffer, we not like that. The way the system they blow, we not like that. They want them where they before. Power, you free tell them they know this. 5,000 for the day. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. Will back on the beat. Raga spice for the dog of the answer. Yeah. Whoa, whoa, yaga. bang bang, na 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 na. Raga boys, woo woo. Oh lad, you go. Oh lad, lad, lad. What? Cash record 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. Lord, I can feel and foresee. The poor man they suffer, the rich man no they offer. I can feel and foresee. Money no there, how them go suffer. I can feel and foresee. Poor one they don't know the butter them bread. I can feel and foresee. But you don't sit, you not get you great. I said there's too much pressure on the people them eat. You make man just fed up. Too much pressure on the people them eat. You make me just stay cry. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. You know me say because of we born pampo. Yeah, yeah. That's me say we for die pampo. Whoa, whoa. You know me say because of we born pampo. Yeah, yeah. That's me say we for die pampo. Whoa, whoa. Whoa, whoa, whoa. Na, na, na. Whoa, whoa, whoa. Oh, Lord. Whoa, whoa, whoa. Na, na, na. We not like that. The way the system they blow, we not like that. The one them where they before. Oh, every tell they know this. 5,000 for the day. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. 5,000 don't make Baku man go to prison. You know easy, I swear. 5,000 don't make Baku baby then sell girls. I saw the thing, yeah. 5,000 don't make Baku man lost their life. Kiribi won't pass. 5,000 don't change the whole wide world. The way the poor man them suffer, we not like that. The way the system they blow, we not like that. The one them where they before. Power, every tell they know this. 5,000 for the day. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Some people not get time for it, I swear. 5,000 for the day. Poor one not get time for it, I swear. Will back on the beat. Raga fight for the logo there, yeah. Whoa, whoa, yaga. That's right. Bididum pum 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 pum. Bididum pum 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 pum. This is the things I do. Yes, I. For me country, green, white and blue. I know say the bella them over and down no go party. Go don't bother that. You know we come together as one. For we country flag. I go die for me country flag.
Over 18 witnesses. Ideas that you are fully case that no case submitted, but for the legal test applied in these cases, those no case submissions may well have succeeded. So time is something that we do not have a luxury of, and again we have sufficient time to deal with the question of elections, because as it is, if you would recall, the discussions that we had prior to the close of the prosecution's case is that after the no case submission, we'll be proceeding on the locus. And I'm going to be seeking to do that next week. So we can deal with all of that. So effectively, that gives you enough time to prepare for whatever thing you want to do, or the manner in which you want to carry out your defense, whilst we proceed to New York and come back. And at that stage, Mr. Mantibo would have an opportunity to determine whether he needs to witnesses, or in fact, defense counsel will also have an opportunity based upon that locus to determine what they want to do. But essentially, what I'm not minded to accede to is just granting a government to decide which election to choose. Because I don't think that will be
the last bit of your statement almost answered. I mean, you said that some week you will entertain that, because if he minded to call witnesses.
No. He's minded or otherwise is subject to the locus visit. Because he might well go to the locus and say, no, I'm happy with my case, I'm not going to move from here. So that was what we had discussed, and that was what previous orders that I gave.
So in essence, the material time that then they should be put to their election.
No.
As a matter of fact, questions about the locus might reopen issues.
No. Mr. Fofana, the locus is election, part of the case. The locus is part of the case, yes. But we were very clear, if you go back to the orders that I gave as to what we were doing at the locus. You've put questions in cross-examination to witnesses, which, as SC, tended to cast a light on the defense's case. You understand? The question is simply, am I going to call witness? Am I going to rely on my statement, or am I going to testify? That is not to say, without prejudice, that an accused person cannot again, upon reflection, decide that, well, I said I was going to call witnesses, but I've changed my mind in the light of what I've seen.
Of course, we'll definitely hear that, my
Lord. No, the opportunity would be given for accused persons to change their mind if they so desire. But what I do not want to do is just give a whole week's adjournment just to decide which way I'm going to go. Then we come back, we go on a local visit, then we say, well, if I change my mind again. So we get over this aspect of the case, so we are clear on the basis of the evidence as it is, because if Mr. Mansibu comes back and says, I'm not going to do anything, I'm happy, then we continue. But time is not of the essence. And again, this case has taken a long time.
So, as my Lord, before, I'm sure Mr. Kabo would want to say something, but before I sit down, just to be a little bit clear on that, I mean, is it therefore the case that if we are put to our election, for example, I'm still saying that I need instructions, but if that happens, and then Mr. Matibo comes back and says, wait a minute, I still have witnesses that I need to recall based on the locus visit.
Well, so we
are supposed to open to
No, you're not. No, don't get confused. When I have not said, neither am I saying or implying that once you put to your election, you start your defense now. No, I've not said that. What I'm saying is that the law requires that at the close of the notice submission, the accused persons are put to the election. That needs to be done. Now, after that is done, next, the time that we still want, we'll go to the local visit in New York, and upon our return, depending on what Mr. Mansibo intends to do, the accused would then be in a position to put their defense or to start the defense of their case. So the 1 week that you're asking for, you're going to have 2 weeks. But what I'm not going to have is 1 extra week and then 2 weeks.
That's the problem. Still something just to clarify.
No, sure, that's fine.
I mean, my Lord, you know, the reason why I believe Mr. Matsibo has not totally closed, I will say, because he has not entirely, we've made a no-case submission, but it was premised on the fact that he may come back to the court following the locus visit and probably one of situations.
I captured that in the locus submission, that at the end we all agreed, all defense counsel were agreed that should Mr. Mansibo wish in this case, he'll be allowed to do so. And once he reopens his case, of course, he'll be cross-examined.
What if you want to make further no-case submission based on the locus visit?
No, there cannot be a further no-case submission.
Because the locus visit is very integral to the
No.
Anyway, Mr. Kago, do you want to?
No, hold on. The no-case submission is relevant to the prosecution's case and your defense, not to the no-case submission. The no-case submission is made on the strength of the prosecution's case, which is not an issue. But what happens in New York affects the prosecution's case and would be relevant to defense as well. So this is where we are. The situation we just think we'll do it.
We go to New York, my lord. This is spent and then completed. We go to New York. We meet a finished building with everything that they anticipated. The building stands there, my lord.
That would be a miracle.
Are you saying that when we come back, we cannot make a no-case submission on that?
No. You will not make a no-case submission, because when you come back, your argument would simply be, they told us in evidence that there was no building in New York. Now we've gone to New York, there's a building. So the accused have to be acquitted and discharged. Plain and simple. Yes.
Without opening a defense, you can.
Yes.
That is a no case that will be making.
No. Don't get this wrong, Mr. Fofana. You got to bear in mind that the prosecution have led evidence against your client. They've said this is their case. The central piece. Okay? If we go to New York and we find that there is a building there, then it makes the prosecution's case inconsistent. And that evidence cannot possibly be changed, which means they clearly, under any shape or issue or speculation, they cannot satisfy the burden of proof, which means the accused person's work. It's as simple as that. But you cannot come back and say, well, oh, by the way, we've gone to New York now, there's a building there, so there's no case submission. No, they get acquitted. Period. There's no two ways about it to go and come back. Because the evidence, you must not forget that it would be inconsistent with the evidence given in this case. And we've had the evidence. Your cross-examination was centered on the basis that they've said all of this, you went to town with the reports, querying the reports, that in fact this report shows what was going on. So if we go to New York and we see something totally different, that enhances your client's case. It's that. So you cannot come back and say, well, I'm going to have another no-case submission. No. The no-case submission is on the strength of the prosecution's case as it is. Should Mr. Mansibo choose to come back and reopen his case, it will be subject to the proviso that some of the evidence, he cannot possibly reopen them. But this will be contrary to established evidence that is already before the court, which means the advantage shifts to the defense.
So, my lord, before I sit down,
you need to bear that in mind.
Will I be understanding your ruling to be that whatever comes out of the no case will not be part of their case? Whatever comes out
No. You see, you need to go back. No. You need to go back to the ruling that I gave. The ruling was very specific that they will only be allowed to reopen on specific points. That does not mean have carte blanche to come and reopen them. They don't. Very clear.
Conditional affirmation give us at least a sense of understanding that when they are totally done with whatever conditions may or may not, then the burden now shifts on us.
No. Mr. Fofana, you still have not got this. Yeah. The prosecution's case is closed. There's no question of them coming back as of right. Look, let's be clear on the point.
Mr. Matsibo, we understand you.
No, hold on. It's a very serious issue because I gave, if you remember, Mr. Fofana,
yes, sir.
I gave a written ruling on this point.
Yes, sir.
That the prosecution will close the case. They will only be allowed to reopen their case on specific grounds. So they don't have carte blanche to come back and say, well, we've gone to New York, we've seen this, so we want to come back with 10 witnesses. No, they don't have that bite. They will only be allowed to reopen subject to an application being made, which defense counsel can object to. That is in the ruling. So don't think there's going to be another prosecution's case coming back up. No. We're only going to New York to examine the contents of what the prosecution have put before the court. But then some minor clarifications, they may be allowed subject to an application being made on that point, which I will rule upon as to whether they can reopen the case to do that. But to reopen
I get your drift, and I just will respectfully continue to implore you to give me time to receive the instructions from my client, at least not today, my lord. So that
your client has been giving you instructions every day of this trial.
So that
your client has been giving you instructions every day of this trial.
I mean,
you know, right there.
Of opening his defense, my lord. But
no. Mr. Fofana, one thing you need to get a clear grip on is you don't have to prove anything. If you listen to what I said in the no case submission, this is not about guilt or innocence. The tests that are applicable in this case is a very low test. Anybody can break through that test, unless, of course, the first lane in Galbraith applies. Then in which case, that's the end of the case. But then, in a case such as this, the prosecution are not relieved of having to prove their case. So effectively, you can say nothing whatsoever and say, we'll address the court. Then the burden shifts to them to establish on what they have before the court that higher standard of proof. So this is the whole point. So it's not a question of saying that you have to prove anything. No, you have nothing to prove. They have come here, they have led 18 witnesses, the evidence is before the court. So for now, yes, they can get through the sufficiency of evidence test. But getting through the prime facie test, the reasonable proof, beyond a reasonable doubt test is a whole different game. And this is why you would note counsels that have not interfered into the evidence at all, so as not to give the prosecution an advantage. I've just left it at that. So they have the burden to prove. It's not going to be a question to say, well, oh, well, this is what we're going to do. We passed that first test, so we're going to pass the second one. No. It's an evidence we have to prove.
My lord, I mean, that is really what I will still try to confer with him, but
sure.
My lord, yeah.
It's just an election. What do you want to do? You want to rely on the statement? Yeah, it's an election. Nothing more, nothing less.
My Lord, may I state
Mr. Sesebi, do you not want to confer?
My Lord, because of the sensitive nature of this case and the issue of the issues that have come up from your ruling, my Lord, we want to have a comfortable place where we could have a conference with the second accused. And Lord, we had not envisaged this ruling, I'll say it. We had not envisaged it.
Is that so?
Yes, my Lord.
Yes, as I say. And you put a no case submission, you get A or B.
Lord, we had not envisaged it. And if you look at the time taken by the prosecution to investigate, they took over a year. And if you look at the time they've taken to prosecute, a lot investigate and prosecute, we are looking at over 28 months. 28 months. I mean, Lord, equality of arms requires that. under Section 23 of the Constitution, the fair hearing, equality of arms, for the defense to present its case. I mean, Lord, we are not asking for the same latitude. The 28 months, we are not asking for that. Because, Lord, if you're
not going to get it anyway.
No, Lord, if you look at where the race is, the issues involved, Lord, we will need to get our witnesses, get conferences with them, get evidence.
Well, how are you going to get a witness when we don't even know if you're going to call one?
Milord, in fact, it has just tied up properly with the locals which you had made a ruling on, my lord. And just tied it properly, my lord. And my lord, what we are looking for here is for justice and equality of arms, of course. It's just for both the prosecution and the defense, my lord. My lord, I will hold on. We're not saying that you need to start the defense straight away. And I've said to Mr. Fofana just now that there will be at least 2 weeks to do that. All we're asking for is what is your election, which for me to comply with the law, I deal with that aspect. But then of course, subject to what happens in New York, you would have an opportunity to change your mind. Yes. Milord, I mean, you know, that's what I'm saying. Milord, may I state that for the second accused, the visit to New York, the election of the accused is predicated on the visit to New York. No, it cannot be. On the following reason. It cannot be. No. I will not agree with you because, Mr. Tse, you know yourself. Let me say, no. I can simply get on a plane, go to New York, have a look at the building and come back. You can do that. And my lord, the psychological effect of changing your position in this kind of trial. No. My lord, we need to consider that as well, my lord. No. Look, you relying on Section 23, and what I've said is, Section 23 requires fairness. I get you. Now, the fairness that I have put in place is that following the visit to New York, should you be in a position that you require a change of election, you'll be afforded that opportunity. But look, the same Section 23 you're talking about requires time management of the case. Now, what you want me to do is to say, okay, well, give me a week, let me go and think whether I want to testify, or whether I want to rely on my statement, or alternatively, whether I want to just give an unsworn statement. My lord, that's what you're asking for. My lord, if you look at the atmosphere around, my lord, the atmosphere at the moment, my lord, let us have a time with the second accused outside of today, so that we'll put the facts to him, having received the ruling from you, and then we can come to this court now and make our election. All right, now, hold on. Yes, you were talking about the atmosphere. Yes, my lord. Now, the court cannot be oblivious to the fact that there is an accused person who is going for something very important and who, in fairness, ought not to have this hanging over his head. That is one major issue. Yes, my lord. So, the issue here is this. It needs to have... No. You are talking about Section 23. He needs to have a clear hand and a clear head that what his fate is. And what I do not want to do is to subject the matter to further delays. And this is where the matter of Section 23 that you rely upon, I've set it out in a simple way to say, okay, to avoid prejudice, but without sacrificing time, we know what the elections are going to be. We can properly and better plan the trial ahead, subject to changes eventually, should there be a need to do so. And you cannot get better than the best of both worlds. My lord, I will again repeat our position for the second accused. My lord, the atmosphere is not at this material time appropriate for the election. Really? Yes, my lord. How do you work that out? And my lord, I have again raised this issue of the psychological side of this kind of bail proceedings for the second accused to come to make an election, and then after any locus gets back to change that. My Lord, it is psychologically.
But you do know your case, right?
Yes, we know our case. But as I said, we are not envisaging this ruling, my Lord. And my Lord, it's over 100-page ruling,
which says nothing.
Recording in progress.
There's a prima facie case.
my Lord,
Which says nothing.
my Lord.
The only thing you say is there's a prima facie case.
My Lord, we know your kind of rulings. We are going to look at it. We need the comfort of our chambers to discuss with our clients.
And are you saying the court is not comfortable?
My Lord, not now. My Lord, not now. My Lord, not now, my Lord. My Lord, with all fairness, I don't think the accused is comfortable in the dock.
How do you know that?
Oh, my Lord, I know.
Have you taken instructions?
My Lord, I know the accused is not comfortable. The second accused. My Lord, that's all for the second.
Thank you very much. Mr. Gebauer.
My argument, I'm sure, right, my understanding of the prosecution has not moved.
No. You see, we go back to the same thing. The prosecution's case is closed. It's closed. Whatever they want to do, they have to make an application which may or may not succeed. That was in the previous ruling that I gave. You remember that?
Yes, my Lord. My Lord, point taken. My Lord, on that note, I want to implore you not to have the defense to put the accused persons to their or for the court not to put the accused persons to their elections today. My Lord, like my colleague MP Fofana said, one would have to think through the indictment for you to be able to put together the number of witnesses you really want to call. There are some of the counts you might not want to call a witness and respect of. Along that means I want to crave your indulgence to give us a date, albeit even if it is not the 1 week that is requested for you to grant us an adjourned date to give us the opportunity to have a conference with this accused person, particularly the third accused person, for him to be put to his election. Now, once that is done, I am sure it gives you an indication as to what the defense case is going to be.
That's all I'm asking for. Just an indication.
Yes,
nothing more.
Yes, madam.
So you know where we're going.
I crave your indulgence for a date, even if it's not the 1 week adjournment that is requested. I will need time to actually hand the accused have a total rehearsal or overview of the entire case and come up with the number of witnesses that I'll be calling in this case.
Well, you say you call it witnesses. That's one part of it. You don't know what the other part is. Or you might choose not to call witnesses.
Yes, you might choose not to put him on the stand. Yeah. You know, all of these things are legal issues that you want to actually think through and weigh carefully. You know, having been a very brilliant criminal law practitioner, you know what it takes if you want to put the accused persons on the stand as against merely calling other witnesses that will testify at his behest. So these are issues we have to think through critically before we come to conclusion. All the reason why I'm pleading with you for an adjourned date, for it not to be within a 10-minute standard that you had indicated.
Yes, Mr. Campbell.
Very pleased, my Lord. Let me first of all report the now elevated status of our client, the fourth accused in this matter, Dr. Samura Kamara, who was resoundingly elected to the position of flag bearer and leader of the All People's Congress in fulfillment, beloved, of the order of the court in another matter. That said, beloved, I wish to congratulate the judiciary also for the coincidence of the celebratory mood we had yesterday. And matter coming up today, beloved. We appreciate that.
And what are you trying to imply?
Nothing, beloved.
You know what, Mr. Kagbo, remember what I said. Let me just remind you. Yes. I did say, yes, if we have all of this, yes, by end of December from the Fed, prosecution by mid-January, end of January, will be done. That's what I said. So it wasn't premeditated, but I said that it will be done.
I simply congratulated the judiciary.
And I'm just clarifying the congratulatory message.
By reason, my Lord, that they are falling in line with the national reality. My Lord.
But the courts always take the national reality into account.
That is it, my Lord.
Yeah, and you had what I said just now to Mr. Fofana.
Now, even when I wish to speak with our clients, I'll have to crawl.
Is that so?
Sometimes prostrate, my Lord.
I doubt that very much.
Because in all likelihood, my Lord, in all likelihood, that fourth accused there is going to be the next president of Syria. I'm sorry for that.
And this is the reason why, you know, and you see, look, you know, one thing, this is the reason why you had what I said to Mr. Sisi just now, that if I am going for an office like this, I want to have a clean head. I want to have, hey, gentlemen, please, come on. You know, this is a court, please. Yeah, let's just calm down. Let's just calm down. I mean, the very senior counsel is on his feet. Let's just calm down, please. Yes, Mr. Kagbo.
My Lord, certainly we cannot be oblivious to this fact. We came into court this morning on a different level of expectation, my Lord. Be that as it may, we are not prepared to be put to our election immediately following the conclusion of your ruling, my Lord. There are a lot of variables to be considered in terms of consulting with our clients, my Lord. I would therefore want to re-echo and adopt the positions of previous speakers from the defense team and seek your indulgence, my Lord. That exceptionally perhaps you accede to our request for an adjournment so that we can better consult with our clients. That will be all, below.
Yes, thank you very much, Mr. Kagbo. If I need not even ask him, because I know what his answer is going to be. Are you hanging on his tailcoat?
Provided he's not going to shift the burden on us, my Lord. In fact, I was just telling them that when we came this morning, we came fully fulfilled that we were going to receive the Obama aphorism. Yes, we can. But we got the negative. Yes, I cannot.
You received it. You received it. At least what is clear is that the prosecution have no clue
as to how far they have gone to satisfy the burden of proof.
That's a major part. A lot of work was put into that new case, my lord. Hours of sleepless nights. But
indeed. Yes, Mr. Kumar.
My colleagues, that an adjournment be granted us as we need time to confer with our clients. The issues before you are very, very serious issues. And I'm sure in order for to be enhanced respectfully, whatever short date that this court will give, it will be of immense help for us to ensure that we have proper instructions from our clients. And just a little concern, which I may also want to raise, because I'm sure this locus visit, which we all agree on, because it's also very important to this client. And then I'm sure a conclusion is yet to be reached as to when, in fact, that will materialize.
I'm just saying next weekend.
Next weekend, as Milord presents. So, Milord, we want to seek Milord for an adjournment, Milord, for us to come before you to see exactly what
Yes, Mr. Matibu, or Mason or Conte.
My Lord, I've been put into a rather peculiar position where, as part of the prosecution, or the prosecution rather, I stand up in protection of the constitutional rights of the accused persons themselves. Section 23 is very clear of the Constitution. Please.
We see you are the one winding him up now.
My Lord, Section 23,
he will soon be asking for an adjournment.
beholds the court to ensure that any person who is charged with a criminal offense be afforded a hearing within a reasonable time. I remember, my Lord, when this matter first came up, I believe it was, if I'm not mistaken, November 2021. At least that is the date on the indictment. And as we speak now, that is more than 1.5 years. And your Lordship, if I remember correctly, actually intimated that all things being equal, you anticipated that this matter would be resolved within a period of 12 months. Was it 12 months or 12 weeks? Not 12 weeks.
12 weeks. Because I wanted to get some.
Yeah, it was.
Of course, issues were coming up.
Yes. And I'm at pains to understand why counsel for accused persons are so intent on having this matter delayed in its resolution.
Well, wait a minute. I mean, you guys, hold on. You guys were given an opportunity to speak. You spoke your hearts out. That is his view. That doesn't mean that I buy his view.
Why you all open up?
Lord, Mr. Maximo.
No, but that is his own view.
But your Lordship, I want to caution you the sort of language you use in this place, my Lord.
I don't know.
I know English is not your first language.
Mr. Kambo.
Yes,
Mr. Kambo.
My Lord.
You know what? Look, allow him. He's got his own view. Let him say what he wants to say. I'm listening to him. That doesn't mean I'm going to accede to what he says. I'm not listening to him.
My Lord, I won't take issue with I would call it a practice of my learned friend to interrupt counsel when he is speaking. I don't think, my learned friend is fairly senior. He knows how these things are done. You don't just stand up. You are given an opportunity to respond at an opportune time. But that said, my Lord, I won't be deterred from making my point that what is being suggested will amount to further delay in the resolution of this matter. My Lord, if Council had taken your suggestion to heart and consulted, by now the election exercise would have been completed. We are not, as I understand, they are not being asked to indicate how many witnesses they are going to call, maybe so, but certainly not to lead any evidence. So clearly, it's simply saying we are going to put the accused on the stand, or we are not. That is not something that requires any substantial amount of consultation. None of my learned friends, with all due respect, has proffered a reason as to why they require a period more than what is available to them. Yes. My Lord, I still make that point that this matter now cries out for resolution, given the amount of time that has already been spent on it. And more significantly, my Lord, given what my learned friends are referring to as the prevailing circumstances. The sooner this matter is resolved, the better. And for that to happen, we have to utilize each and every moment that your Lordship has at his disposal. Your Lordship has got almost always a full docket. Afford us the time to proceed with this matter. And my learned friends should be grateful. Yeah. So, my Lord, without belaboring the point, it's not an empty statement when people say justice delayed is justice denied. This is precisely the circumstances where it comes into operation. Doesn't matter where it's coming from, for as long as the point is made, my Lord, that we would rather the court does all in its power to avoid delay in the resolution of the matter. So my submission, my Lord, would be that just as the prosecution was constrained, if my learned friends' memories are clear on that, the prosecution was requested against its what it considered better judgment to close its case, and that required a much more substantial exercise, because we had to look at the evidence that had been proffered and come to a clear decision that, well, this is it, we will stand by this. What they are being asked to do right now does not demand anything at all of them, rather than an indication to your lordship that we are taking this route or we are taking this route. That's all. And they can change it later, the circumstances demand. Yes. So, my lord, I would submit that there be an adherence to your direction, and the accused be asked to make the election. And in the event that for whatever reason there ought to be a delay, we respectfully suggest that, my lord, should it be convenient to the court, we resume with this tomorrow morning for them to make their election at least. But that is a concession that is made in the event that for whatever reason we do not find favor with our submission that we ought to have the election made right now before we adjourn. That is all, my lord.
Exceptionally, my lord, my learned friend Suleiman Bobokuruma wants to address your lordship.
Well, there's nothing more you can say than you have been saying.
No, something else, something.
No. What do you want to say?
With your leave and permission. What we want to say here is we have the optics here. This whole proceedings is being covered live. And our learned friend there has made statements which insinuates that we may have been the cause of the delay. Your lordship gave an order. Your lordship wanted this matter to finish in record time. You gave orders for the prosecution to do so many things which were not done in time with your orders. Last of them all was the order that you gave for the response to the no case submission. Your lordship indicated to this court that by January 20, if all applications are in, all responses are in, you will have delivered your ruling. They asked for an extension of time to January 31. And then that was the time they came in with their own case. And we commended your lordship for the industry in able to, within 3 weeks, to deliver this ruling. However, your lordship has given a detailed ruling this afternoon on the no case submission. We know the choices available to us in the election. That one, we can choose to even change our plea and say we are guilty. Or we can change our plea to say, yes, we are going to testify, but testify from the dock. Or we are going to testify from the witness stand and be cross-examined. Or we are going to testify, we are going to call in witnesses. But my lord, as my landed senior indicated, the status of the fourth accused person has changed. He is not only standing here as the fourth accused Samura Kamara, but he is also the leader of the All People's Congress Party, pursuant to an order of this honorable court. And being the leader of the All People's Congress Party, whatever advice as lawyers we have to give him, we have to take into account what will be the implication for himself and the party at large. So, my lord, we cannot now just come and sit here and say, oh, he has to put on election, we'll go to the witness stand, give us 10 minutes, doctor, please, we want you to tell us whether he wants to testify, or whether he wants to call witnesses, or whether he wants to this. But the fact of the matter remains, we cannot shut our eyes to the judicial notice that he is the flag bearer of a political party that's going to contest an election in June. So as lawyers, we also have to be mindful whatever we take into account, because it involves a public interest. So based upon that public interest, that's why we are saying, give us a date first, let us confer with our clients, so that we know which kind of election he will be put into. Then once that has been done, then we can now come before the court can give directives when each defense should start to open up their own defense. So my lord, we are saying, my lord, because of the judicial notice and the nature which has changed on the fourth accused, we want this court to grant us the time, because this matter has now become a matter of public interest. It's no longer a matter between the state versus Samura Kamara, but it's a matter of public interest for the state of Sierra Leone, because whatever be the outcome of this matter will hinge upon the outcome of June 2024, June 2023 elections that we have to conduct. So because of that reason, that we are asking you to grant us the time so that we can show to our clients for him to make an informed decision what he wants to achieve when we come as to the election of what happened. That's why I see my lord. That's why I wish to see my lord.
All right, look. You talked about the public interest. I have to look at the public interest, and I'm going to look at his own rights to have this matter out of the way. Because it will be most unfair for this matter to be going on whilst he's focusing elsewhere. Most unfair. And I certainly would not be doing that. This matter, as far as Mr. Kagbo has urged that we look at the prevailing circumstances, of course, we're not shutting our eyes to it. And this is the reason for my stance, that having regard to what has happened, we need to deal with matters quickly. So it gets it out of the way. The important issue is, as you know yourself, when a person is facing trial, they need to know their fate. Very important. For me, I am not going to be delaying matters for no reason whatsoever. If there's going to be a delay, it should be good reason for that delay. That said, I bear in mind the arguments raised by Mr. Mansibo, and I have built in protections in line with Section 23 that Mr. Sise has raised to ensure that the trial is not prejudiced in any way, shape or form. Which is why, if you remember my starting point, I said I needed to have indications so I could better plan the trial going forward to make sure we don't get into a situation where you're going to need extended bits of time off. Because at the end of the day, whatever extended bits of time you grant, the matter is still hanging. And it's that issue that is of concern to me, that the matter should not be hanging over somebody going for such high office. And secondly, having a matter hanging over somebody who's going for such high office may arguably lead to disadvantage to him, because the reference will always be he has a case, and that is not right. So it needs to be cleared up. The deck is clear. If it's going to be acquitted, then he's free to go and do what he wants to do. So all of these matters are weighing heavily in terms of how we deal with this issue. And also, you talked about the public interest. I've got to think about the public interest of Sierra Leone as well, that contenders for high office, quote unquote, have a case hanging over them. That is affecting Sierra Leone as well. So we need to, yes, the wider picture. So the end of the day, yes, the prosecution has spent a lot of time dealing with this case. And if you will recall, Mr. Kumar, I think you mentioned it just now, I cancelled 2 holidays that I should have taken to ensure that this matter was dealt with. I did not go on holidays for the past 2 years, thereabouts. Even the Christmas holidays, I could not take it because I wanted to get this matter dealt with. I put aside all the matters that I'm dealing with. As Mr. Mansibo mentioned, I got a full docket, but I put aside my docket to deal with this matter and to fast forward it. Because if I had not done so, by now we would still have been on PW4. So, but at least we're where we are. I just want counsel to be mindful of the fact that time is not on our side. In the interest of fairness, insofar as the fourth accused is concerned, I do not have an issue one way or the other, but what I would say is I have brought in mind what Mr. Sise said, and yourself and Mr. Kagbo. I recognize that it is a difficult decision to take, having regard to the prevailing circumstances as to what to do. And as they said, it's either you do, you're done, you don't, you're done. So in those circumstances, Mr. Kumar, you're the one who's raising the issue. I feel that as a matter of law and even practice, the question of election is not a matter that requires a whole week's adjournment. That's the starting point. That said, I don't have a problem. Upon reflection, I might very well grant an adjournment to enable you to look at the issues and then to come back with an election. As I said, I've put in a built-in protection to say after the locus visit,
If there is a need to change elections, I will entertain it. But at least that way, I have a clear mind and a clear pathway as to which way we're going to go in terms of dealing with the trial. But what I will not be acceding to is a whole week's adjournment just to go and decide what to do. So that's as far as I can go. Yeah, and in fact, I think I have sat here right throughout this trial. What I can certainly say is that counsel across the board have a clear grasp of the evidence. Clear grasp. There's no question about that. The nature and the incisiveness of the cross-examination on all sides tells me that all of you are fully au fait with what needs to be done and the nature of the case against your clients. So in those circumstances, I'll adjourn this matter to tomorrow morning. We all are not sleeping. I did not sleep last night, so you're not going to sleep tonight. You need to get your client down, sit with them, and figure out what the elections are going to be. And then we're going to come back tomorrow. We'll deal with the elections. And then, as I said, I'm going to incorporate it into an order that if there is need to change elections subject to what happens in New York. Mr. Kamara, you're listening? If there's need to change elections subject to what happens in New York, I will entertain it. No, let him finish. He's on his feet.
What I want to say, again, judicial notice must be taken that yesterday the fourth accused was standing on top of a vehicle from McKinney to Freetown. As I have said, he has always been coming before the courts. Even when he went home by 4 a.m., he was able to wake up this morning and be here before 9.
Well, at least he went to bed and he got up. I did not.
What we are saying here, my lord, the adjournment he wants to give for tomorrow will be too short.
Why?
We want to come on Monday.
No, why?
The reason why it is too short.
I need a good reason.
The reason why it is too short, first of all, we did not envisage that our no case submission will not be upheld.
No.
That is one.
No, don't give me that.
That's one. Secondly, my lord.
You're very senior counsel.
Secondly, my lord. We have to go through this ruling and show him the options. As I said earlier, my lord, he is no longer just Dr. Samura Kamara. He is now Dr. Samura Kamara.
No, listen. No, look. The court, Mr. Kumar, the courts have already paid due deference to that. Okay? But the criminal trial would need to be dealt with in accordance with the law. So I cannot have those extraneous considerations overshadowing the legal position.
The main reason, my lord, the ruling is on the page and above. It is now 3 p.m. My lord, we cannot just say because of what we had in court, we have formed an opinion and then we say sit down here. We want to go through it and let us see the kind of, because when you come on election, you will ask next, now that you've elected, how many witnesses will you call? We'll have to know whether we have to call 5, 10 or 15 witnesses. We don't just come and say, oh my lord, we elected. If that's the case, then we will not even ask for an adjournment because we know that we will testify and call witnesses. But we want to know, if you are calling witnesses, how many witnesses? When will we serve this witness statement? These are all matters that have to be considered in our discussion. And even though
do you need to serve witness statement?
No, what I'm saying, my lord, we need to have the list of witnesses on them. My lord, whatever case we know as the lawyers, he knows the case more than us. Many matters have been dealt with by you in your ruling, interministerial council, civil servant. So we may have to know whether in fact we need to call 5, 10 or 15, and also considering the nature of the case before the court. Minus all other things, my lord, he is not the only accused person standing here. There are other accused persons, and their defense and innocence is presumed and assumed by the Constitution. So we have to ensure that we do justice to the case. We don't just have to come and speak to everything. Oh yes, we have elections in June. Let us try to finish it before June.
No.
We have to ensure that the justice of the case is met.
No. That is not an acceptable statement, Mr.
No. I take it back.
No.
I take it back.
Hold on. Hold on. I will come back to you. Look, the issue here is this. Nobody is sacrificing justice at the out of speed.
As my Lord pleases.
I've never done it and I will never do it.
Grateful, my Lord.
But notwithstanding, I cannot ignore speed for other considerations.
As my Lord pleases.
So I need to bear that in mind to make sure that this matter is out of the way, because for a whole year my docket has been messed up. So that's another consideration.
So my Lord, that's why we're asking for Monday. So that we meet with the client and then we know the number of witnesses, we know our case, we ask it. The day is far gone now, it's past 3. We live here, we have engagement, we have prayer other matters coming up by tomorrow, my Lord. My Lord, if my Lord, you can see, we've been at this morning. So, we've not had the ruling in our possession. So, Lord, we are saying, because of the ruling that you've given, for us to come with a proper election and to show the court the number of witnesses we have, we're asking for Monday. From 1 week, we've now come to 2 days.
So do I take it that you're going to be calling witnesses? You see, so that tells you that you know what you want to do.
Based upon what the conference we have, as long as we may have our instructions. Who knows? Maybe the guys might come to us and say, I'm guilty. Don't call no more witness. I'm tired of this case. How about that?
All right. Mr.
Frankly, that is just a summary that I mean, in all honesty, my Lord, I mean, first of all, we started by congratulating you for the time spent. So, my Lord, to have a halfway house, I think he offered tomorrow, and I was asking for a week. I think Monday will really be reasonable, I mean, in the circumstance. The reason being,
I just knew that you were going to say that.
The same, because I mean that is why I said he probably took the wind out of my sail. But the point is, your ruling we will still need a hard copy of to discuss with our clients, because they are all literate. They may want to read it themselves, so that if there is anything that they did not pick up, and then they give us instructions. You know. But Mr. Matsibo, you asked for tomorrow, not so? He said if today is not possible, let's get tomorrow. I asked for a week. So if Monday can be the compromise, my Lord, respectfully give us Monday. I mean, we know you've been here since this morning. We have been going in and coming out. So you need to, I mean, probably spare tomorrow as well. I mean, you have other matters tomorrow.
I have other matters tomorrow. You see, you guys have the luxury. I don't. So you see, we're back tomorrow.
But I'm sure the flag bearer will have a lot of work to do. To be a flag bearer is not
Not at all. Mr. Mansimo.
My Lord, maybe just to reiterate what we have just been saying. I think given that my learned friends cannot actually precisely indicate to you what it is that they need all this time to make an election, not to prepare their cases. Their cases, they can have as much time as possible. But to make an election in a matter in which you have been in attendance since its inception, and in which you have made a no-case submission, and you say we still need to look at aspects. My Lord, with the greatest respect, I believe, and I would submit that justice demands that it be not delayed, and your indication for tomorrow as the date for their election is reasonable and appropriate.
No, frankly, my Lord, that is not a fair analogy, and I must say this. I can very well recall when Mr. Matsibo was about to close. He had called about 17 witnesses. He could not get the 18th, and we kept adjourning for him. We were all very understanding. At that material time, we did not push him beyond limit. We're just asking. I mean, Monday is not far enough. It is equality of arms. I mean, we know you are on the stronger side, I mean, but give us space to rearrange, I mean.
Before internet.
Council, I just need to make sure that everything we do here is in accordance with the law. So I'm going to rise for 10 minutes and I consult my Archibald. I'll come back.
testify for 10 minutes.
AYV is your home of credible.
That's right. Bididum pum 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 pum. Bididum pum 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 pum. This is the things I do. Yes, I. For me country, green, white and blue. I know say the bella them over yonder no go party. Go don't bother that. You know we come together as one. For we country flag. I go die for me country flag. Oh nana. If they say what they eat and go up on Paris, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who that them? Now the bella them. Who are they? The bella them, you go one of them. Hey lad. If they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them Paris, you go one of them. Now who that them? Now the bella them. The bella them, you go one of them. Mama, this is the moon. Lo lo lo. Oh lo 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 lo. Papa, this is the moon. Oh lo lo.
Alright, you still listen to We Are on YouTube and on Facebook. Then just get 10-minute break. Then they come back and see when then we're able for basically adjourn the next case. Because Fisher actually, while they meet back tomorrow, but the lawyer then they say they need for read the ruling, they need for consult with their clients. So then they ask that the Justice Adrian Fisher give them say Monday for let them come and meet back. So basically Fisher say just want for do the right thing according to the law. So let them get 10 minutes, they figure out certain things them and then they come back for let they able for get a final time when they meet, whether they go meet tomorrow or then go meet back on Monday. Yeah, so please continue for the week. We go stay around for the next 10 minutes. Let we come back and hear waiting basically they happen with regards this particular ruling as the lawyer of Samura Kamara and the other one them don't make a case of no submission. So let me wait and see waiting basically they happen. And we'll try to figure out for see because of the time we'll try for see whether we come immediately after the ruling, after they don't get adjournment, or we can come and net with the expert for let we discuss the issue. But stay with me, we will continue for inform you accordingly, you know, as to waiting we go decide for do. Yeah, thank you very much. If you not like the program yet on YouTube, we get 1,000 just now, but now we get 925. Please like the program, and if you know subscribe yet to this channel, please consider for do so. And I want to tell thank you to the one that we don't join with for the very first time, and we get plenty of people that we don't join with but they don't subscribe yet. We get 67,143 people that we don't subscribe, where we can call family members them. So we actually want you for you will not subscribe it for please do so. And not forget we actually get a pool where actually they go on. We get a pool where they go on. I'll just try for go to the page and actually get to let me see exactly what in the time for say okay. So I want for basically showing us something here. And this one get for do with, you know, the running mate of the APC. So let me watch. If we go to YouTube, for example, you then a YouTube and then you search for Weird. Let's just skip this out and see. You search for Weird. We spell as W space YARD, weird, and then you enter or you search, then it will take you to this. You have to get this logo. If you see this logo, this logo now, so something like green, white, green, black, and blue, and then you press the. Then it'll take you now the page. Where it take you now the page, basically, you'll see with page, you see home, you'll see videos, you'll see shorts, you'll see live, you'll see playlist, community, channels, and about. Okay, so if you want for vote for who that you feel say could be the best, person for be the running mate for APC, then you can come now this side where na community. Watch for community. After we come out from home, video, short, live, playlist, and the next one of community. Press community. And then it'll take you inside the page. Where it take you inside the page, you basically see the side outside we ask the question, the poll. Now, like voting, you vote for who that you want. We don't vote, we don't post this thing 2 days ago, and we ask, say, who do you think could be the best or the APC running mate for 2023 election? Amongst the list of people, we get Yvonne Akisoya, we get Cherno Cherry Coco, we get Diana Konomani, we get Sheikh Al-Haji Muhammad Kamara, we can call Jagaban, and we get Madina Rahman. These are the 5 people the way we read the name they seriously they play. So out of 1,300 and 1,300 people and we don't vote, this now how they go by percentage, and the total percentage now 100. So when they share, the 5 people share the percentage by the vote we don't receive so far. Even Akisoya get 30 votes. Cherry Kuku get 54 votes. Dana Konomani get 4%, as in 4 votes, 4%. And Sheikh Al-Haji Muhammad Kamara Jagaban get 9%. And Madina Rahman get 4%. So for the flag bearer post for the flag bearer election where we do now by the polls we actually get, and by the way take note, these are opinion polls. Now people them your opinion about who that them feel say could be the right person for as the flag and the running mate for APC. Then they already get Samura Kamara, although it in a court right now. We try for see waiting will be the faith of him and the in political career and them for the party. But as well we go say who that could be the fittest person for go as running mate with him. Okay, so even Akisoya gets 30%, Chernobyl gets Jericho get 54%, Diana Konomani gets 4%, Sheikh Al-Haji Muhammad Kamara Jagaban get 9%, and Madina Rahman get 4%. So if we put this all at 100%, and the number of people that we don't vote so far now 1,300. Let's just refresh and see us at the talk. So if we get more people, then we actually don't vote. Okay, 1,300 people. So if you want to vote, you can follow the process. We actually don't show you. Follow you see waiting they happen. Alright, so this is basically waiting to go on. So in the meantime, whilst we wait for Fisher for come back and tell we waiting in don't decide, let me continue for the listen to a music from Raga Spice.
This is the things I do. Yes, for me country, green, white and blue. I know say the bell of them over yonder no go party. Go don't bother that. You know we come together as one. For we country flag, I go die for me country flag. Oh, nana. If they say what I eat, then go weapon for we, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bell of them. Who are them? The bell of them, you go one of them. Hey lad, if they say what they can, then go disturb with peace, you go one of them.
Fisher, and also the Justice Adrian Fisher has asked for a 10-minute stand down. He's gone. He say he wants to give a ruling that is within the law. So perhaps they don't need to rush him. So he's gone into his chamber, I presume, and hopefully he'll be coming back in 10 minutes to explain whether this will continue or whether he'll give the 1 week that they asked for, or whether they should come again tomorrow, as he stated earlier. So we're all waiting and seeing, and this courtroom was full with people this morning when it all started, but after the ruling on the fourth accused, Dr. Samura Kamara, some people started leaving. There's been some semblance of an empty courtroom, even though we still have some people around. Dr. Samura Kamara is still speaking to some of his lawyers and supporters, women, young men who are around to show solidarity to the flag bearer candidate, the presidential candidate of the main opposition, APC. And one of the things the lawyers said, especially lawyer Suleiman Kabakoma, who spoke for the fourth accused, Dr. Samura Kamara, he said yesterday afternoon or in the morning, Dr. Samura Kamara left McKinney and he was on a truck standing till 4 a.m. this morning before he could get home to get some sleep. So presumably he's tired, he needs some rest. And the Honorable Justice Adrian Fisher said also he has been all night for 2 days putting his ruling together. So they need to continue. But interestingly, there's been some jokes between the defense lawyers and the Honorable Justice Adrian Fisher about the importance of this matter. But what has been very clear, especially from Honorable Justice Adrian Fisher, is that this is a public interest matter, even though he clearly said, the status of the fourth accused, Dr. Samura Kamara, will not mean, the law will not be followed. He clearly made mention of that. But he is also aware that this is a public interest matter and it needs to be expedited so that the fourth accused, who is Dr. Samura Kamara, will have time to perhaps campaign or prepare himself for the June 24th multi-tier elections. You're watching AYV and we're still broadcasting live from the main law court building here in Freetown on Sheikh Stephen Street and Pademba Road, where the state versus 5 accused persons, including Dr. Samura Kamara, standing trial for alleged corruption, on the construction of Salion Chancery building in New York. As I mentioned earlier, this matter came to court in November 2021. Dr. Samura Kamara was indicted and others were indicted in November of 2021. And they've been appearing in court, they've been standing trial on this matter before he went to McKinney last week and was elected as flag bearer of his party, the main opposition, APC. There's been a lot of public interest discussion on this matter, as you've heard today. The lawyers defending him have been asking that his status has changed. He's a flag bearer, leader of a main opposition party, the presidential candidate of the APC, who will be going into the elections on June 24th, 2023. So that needs to be taken into consideration as they were asking the Honorable Justice Adrian Fisher to consider as the matter proceeds. So we're still waiting for Honorable Justice Adrian Fisher to come and perhaps tell us whether the request for a week is going to give or whether the matter will continue as the prosecution team have asked that they continue today or tomorrow, or whether I will give up to Monday, as was requested by lawyer Pamomo Fofana and lawyer Suleiman Kabakoma, who is representing Dr. Samura Kamara. So we're still in the courtroom waiting for the announcement on the coming again of Honorable Justice Adrian Fisher and what will happen next. But, jokingly, when this matter started, when the defense lawyers were mentioning the number of people who are representing Dr. Samura Kamara, the fourth accused, Honorable Justice Adrian Fisher jokingly asked whether they will have a space for the battery of lawyers who are here. Like I mentioned earlier, you have African Osise, who is here as a lawyer representing Dr. Samura Kamara. You have Adi Macaulay, the former anti-corruption commissioner, who is also here. You have lawyer Suleiman Kabako Umar. You have the former Attorney General and Minister of Justice, Frank Kagbo, who is also here representing the fourth accused, Dr. Samura Kamara. You have Roland Nylander, who is here. You have Radcliffe Jones, who is also here, representing Dr. Samura Kamara. They are all here this afternoon. They've been here since this morning up to this afternoon, to listen to the ruling, the 100 pages ruling. And before it started, Honorable Justice Adrian Fisher actually warned or cautioned that he will be delivering a 100-page ruling on the no-case submission. So people should be attentive and be ready to sit for that trial. So he read it, his laptop computer went off, they had to get him to get power again, and it came on, and he continued with his ruling. And he delivered the ruling, and no-case submission was overruled for Dr. Samura Kamara and the other accused persons who were standing in the dock earlier today. So we're still here. You're watching AYV Television live on Channel 33. We are streaming live on our Facebook page, AYV News, and on the website at www.ayvnews.com. We are still here waiting for the coming of the Honorable Justice Adrian Fisher to tell us whether this matter will continue today and whether it will continue tomorrow, or whether it will continue on Monday as requested by two of the other lawyers who are defending the accused persons here, or whether he will give 1 week as was requested for by Honorable Indolo Moyo Gevao, who is also one of the defense lawyers here. There has been a lot of people who are coming to shake hands with Dr. Samura Kamara, have photos of him. As we mentioned when it started, he's coming into this case today not as Dr. Samura Kamara, the person who was accused earlier, but he's coming today as the flag bearer of the main opposition, All People's Congress. So there are a lot of people. I'm sure this courtroom was packed full this morning because of his status and who is he. And the number of lawyers who are representing him grew also this morning. And Honorable Justice Adrian Fisher was jokingly mentioning it, that he wonder whether there will be space for all the lawyers who were mentioned in the matter that will be representing Dr. Samura Kamara. There are signs that Honorable Justice Adrian Fisher is coming back to his seat. There are signs that they will make an announcement soon of him returning to his seat. So we'll continue with the proceedings here at the main law courts building, where we are witnessing the matter that has to do with the alleged corruption in the construction of the Chancery building, the Sierra Leone Chancery building in New York. For some context, Dr. Samura Kamara and others were indicted in November of 2021. They've been standing trial, they've been coming to court, and Justice Adrian Fisher has said this is a matter that needs to be expedited, and the lawyers, the defense lawyers, have applauded him. They've commended him for pushing this matter this far, and it has been, commendation from both ends that he has actually tried his best to ensure that the matter reached to this point and is expedited. And this is a matter, the no-case submission case, the ACC case between the state versus Saidu Nalo, Fode Vafomba Bawo, Adikali Fode Suma, Samura Matthew Wilson Kamara, Kande Fode, Basil Kamara, and Julius Sanders Davis. And we must mention that Julius Sanders Davis is an American who, when Honorable Justice Adrian Fisher was giving his ruling, he said this accused person has neither submitted a no-case submission or neither made an appearance in this court since they started in November of 2021. So he was also amongst those who were indicted in this matter in November of 2021. But he is a foreign national who, was amongst those indicted, but he has never made an appearance. So there was no ruling on whether there was a no-case submission or whether there was no case submission for him. So the Honorable Justice Adrian Fisher made that very clear this afternoon when he was finally mentioning his name as he delivers his ruling. Honorable Samura Kamara, as you can see from our your screens, from our camera, he's still speaking to his lawyers, those who have been going back and forth. Some of them have returned to their seats. Frank Kagbo, who was the Attorney General and Minister of Justice, is here. Lawyer Sulaiman Kabako Omar is here. Roland Nylander is here. Adi Macaulay is seated. I see he's talking with Frank Kagbo and others. They're having a discussion. On the other far end of the sitting, you have Honorable Indolo Moyo Gevao, who is representing one of the accused persons. You have Pamomo Fofana, who is a lawyer for one of the accused persons, a defense lawyer. You also have the ACC prosecutor, Monsibo, who has been asking that, the defense lawyers have in mind that this is a public interest matter, and that saying that justice delayed is justice denied should be taken into consideration. So he has been saying they should continue the matter today or tomorrow and not continue with adjournment for a week or to Monday, as was requested for by the defense lawyers. The courtroom has been a little bit empty. Perhaps some people have gone out to get lunch or relax or ease themselves. We came here around 8 a.m. to 9. We met a lot of people who've been in. There's been some security presence, I should say, at the outside. People are screened and they're searched before they come in. It has not been too tedious. It's an easy process, but people are not just allowed to come in like that. You need to either present an identification or explain what you're coming in for. OSD officers have been outside around the cotton tree. We are in the central business district, actually. The main law courts building is in the central business district. There's been some security presence, around there. And this has been, the case for this matter. Most times when this matter is called up or when they are coming to court, there's been some semblance of security presence around the law courts building, even though it's still accessible to a lot of people, but there's been some security presence. Earlier I spoke to El Casano. El Casano is the communications director of the Judiciary of Sierra Leone, and he clearly I asked him about why is the judiciary opening up this matter to the media. This matter has been ongoing, but this is the first time the media is allowed to broadcast it live. And we must state that AYV is the only media house, broadcast media house, that is providing and giving live coverage to our viewers in Sierra Leone and right across the country. And we want to apologize. We know we've been having some technical issues. We've been having some technical issues with our broadcast, but we've tried our best to ensure that this broadcast from the main law courts building goes out to our public. And we are the only media house that is presently giving you live coverage of the proceedings. We started this morning up to this afternoon It's past 3 and going to 4 p.m. now. Continue to watch AYV. There are signs that Honorable Justice Adrian Fisher will be coming in soon to continue the proceedings and to let the lawyers who are here representing the ACC and the accused persons know whether the matter will continue as requested by the defense counsel, or whether the matter will be adjourned to Monday as requested, or whether it will be a week adjournment. This is the matter between Saidunalo, the state versus Saidunalo, Fode Vafomba Bao, Adekali Fode Suma, Samura Matthew Wilson Kamara, Kande Fode Basin Kamara, and Julius Sanders Davis. So the matter has been ongoing, and the defense lawyers made a request that, there is no case submission, that their clients, the accused persons, have no case to answer. So today, Honorable Justice Adrian Fisher overruled, and he said, no, there are cases to answer in this matter. The allegations against them stands, and they need to prepare their defense. Their lawyers should come and defend them, and the matter will continue. When the fourth accused was mentioned and the Honorable Justice gave his ruling, there were reactions in the court. Some people left already after the ruling. They left the courtroom and went out. And when one of the defense lawyers, the former Attorney General and Minister of Justice, Frank Kagbo, stood up to make a statement after his submission, mentioning that the fourth accused person, Dr. Samura Kamara, actually is the presidential candidate of the APC, and he mentioned in his own words the next president of the country. There was a loud applause in the courtroom to a point that the Honorable Justice Adrian Fisher had to caution, people in the courtroom to understand that they are in the courtroom. It's presumably most of the people who are here in solidarity or support of the APC flag bearer, Dr. Samura Kamara, who is what accused person here this afternoon. And other people who, are also standing trial. They're still in the dock. They're still in the dock. They're still in the dock. They're still in the dock, standing there, speaking to their friends, some of their people. You see them. The camera is rolling on them. They're still standing there and waiting. These are people who've served in public service, in the foreign ministry, at the country's embassy in New York. So they're here today as accused person who were indicted by the Anti-Corruption Commission in November of 2021, on allegations of corruption for the construction of the country's Chancery building in New York. And what we understand today as well is that the Honorable Justice Adrian Fisher will be making a visit to the Chancery building, which is part of the matter, to ascertain what is happening there. So he made that very clear that he will be going to New York, and we'll come again and see how the matter is. We are going to our studios at Tawail. As we continue to wait, I've just got a signal that the Honorable Justice Adrian Fisher has asked for some time. We'll get to connect back when he returns, so that we'll continue with our broadcast here from the main law courts building. Back to our studios at Sahil. We'll get back to you once the Honorable Justice Adrian Fisher returns to his seat. But you're watching AYV TV. We're bringing you live broadcast from the main law court building, where Justice Adrian Fisher has ruled today on the no-case submission of the ACC case, the State versus Saiduna Law, Fode Vafom Babawo, Adikali Fode Suma, Samura Matthew Wilson Kamara, Kande Fode Basil Kamara, and Julie Sanders. These persons were indicted in November of 2021 by the ACC on allegations of corruption for the construction of the Sierra Leone Chancery building in New York. So there's been the ruling. The Defense Counsel have been asking for an adjournment to reappear again before the Honorable Justice Adrian Fisher. The Prosecuting Counsel has asked that they continue the matter today or at least by tomorrow because of time. But one of the lawyers representing the fourth accused, Dr. Samura Kamara, lawyer Sulaiman Kabakuma, said this is a public interest matter. And Dr. Samura Kamara is the flag bearer of the APC. They need to engage properly before coming. So they asked for Monday, for the matter to be adjourned to Monday. Honorable Justice Adrian Fisher has asked for a 10-minute stand down. He has gone into his chambers, and we're expecting him to come. But I've just got an indication that he has asked for some more time before coming. So we are still here waiting and continue to watch AYV. We're going to our studios. We'll get back to you once Honorable Justice Adrian Fisher returns to his seat. Keep watching. This is AYV, and I am Amadou Lamganaba, bringing you live coverage from the main law court building here in Freetown, the Central Business District. Keep watching.
That's right. Bididum pum 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 pum. Bididum pum 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 pum. This is the things I do. Yes, I. For me country, green, white and blue. That's right. Bididum pum 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 pum. Bididum pum 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 pum. This is the things I do. Yes, I. For me country, green, white and blue. I know say the bella them over yonder no go party. Go don't bother that. Sierra Leone now we on the real we come together as one. For we country flag, I go die for me country flag. Oh nana. If they say what I eat, then go up and Paris, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bella them. Who are they? The bella them, you go one of them. Hey lad. If they say what they can, then go disturb with peace, you go one of them. If they say what they can, then go lock them Paris, you go one of them. Now who da them, now the bella them. The bella them, you go one of them. Mama the system, the moon, lo lo lo. Oh lo 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 lo. Papa the system, the moon, lo lo lo. Oh lo 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 lo. Mama the system, the moon, oh lo lo. Oh lo 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 lo. Papa the system, the moon, oh lo lo. Yeah, oh lo 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 lo. Oh lo lo lo. Capital A, capital B, capital C. They want turn them to D. Within a them plan, now they want go sabi. Within a them plan, now they want go sabi. We no go ever retreat and we no go surrender. Holy Ghost fire, they make them they blunder. All them bad plan, them back to sender. Papa God, now you know we defender. Time don't go, now check the calendar. We all they see, we not just live in one. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live. Wololo. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live. Wololo. If they say what I eat, and go up and power, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bell of them. The bell of them, you go one of them. Hey lad, if they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them power, you go one of them. Now who da them, now the bell of them. The bell of them, you go one of them. Mama, the system, the mona, lo lo lo. Oh lo 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 lo, Papa the system the mona. Oh lo lo, oh lo 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 lo, Papa the system the mona. Oh lo lo, oh lo 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 lo, Papa the system the mona. Oh lo lo, oh lo 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 lo. Oh na na, them a free know this say we the score pass. Them a free know, them a free know, them a free know, them a free know this say we the walk past. Them a free know, them a free know, them a free know, them a free know this say we country salon for glory. Them a free know, them a free know, them a free know. Oh na na, if you no get good player, you na buy the player, the one where they try, the one where go come pull water na the eye, the player where go make everybody they smile, the player where go make we knock upside, the player where go make we fly and fly, the player where go make all the bill of them die, the player where go make we the boo boo bamba, na the player where go make we know the one them where they lie, the player where go pull water na we eye, na the player where go make all the bill of them die. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live. Wololo. If they say what I eat, then go up and power, you go one of them. You go one of them. If they say what we score, then go disallow the goal, you go one of them. You go one of them. Now the bell of them, the bell of them, you go one of them. You say lad, if they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them power, you go one of them. Who da them, now the bell of them, the bell of them, you go one of them. Mama, the system, the mona, lo lo lo. Oh lo 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 lo, Papa the system the mona. Oh lo lo, oh lo 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 lo, Mama the system the mona. Oh lo lo, oh lo 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 lo, Papa the system the mona. Oh lo lo, hey God, oh lo 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 lo, Sucky are the kill we. 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 That's right. Bididum pum 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 pum. Bididum pum 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 pum. This is the things I do. Yes, I. For me country, green, white and blue. I know say the bell of them go by and down no go party. Go don't bother that. You know we on the all we come together as one. For we country flag, I go die for me country flag. Oh na na. If they say what I eat, then go up and power, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bell of them. Who are they? The bell of them, you go one of them. Hey lad, if they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them power, you go one of them. Now who da them, now the bell of them. The bell of them, you go one of them. Mama the system, the mona. Lo lo lo, oh lo 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 lo. Papa the system, the mona. Oh lo lo, oh lo 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 lo. Mama the system, the mona. Oh lo lo, oh lo 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 lo. Papa the system, the mona. Oh lo lo, yeah God. Oh lo 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 lo. Oh lo 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 lo. Capital A, capital B, capital C. They want turn and to D. Within a them plan, they want go sabi. Within a them plan, they want go sabi. We no go ever retreat and we no go surrender. Holy Ghost fire, they make them they blunder. All them bad plan, them back to sender. Papa God, now you know we defender. Time don't go, now check the calendar. We all they see, we not just live in one. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live. Wololo. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live. Wololo. If they say what I eat, then go up and power, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bella them. The bella them, you go mona them. Hey lad, if they say what they can, then go disturb with priest, you go mona them. If they say what they can, then go lock them for we, you go mona them. Now who da them, now the bella them. The bella them, you go mona them. Mama, the system, the mona. Lo lo lo, oh lo 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 lo. Papa, the system, the mona. Oh lo lo, oh lo 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 lo. Mama, the system, the mona. Oh lo lo. Somebody say, oh lo 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 lo. Papa, the system, the mona. Oh lo lo, oh God. Oh lo 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 lo. Oh na na. Them a free know this say we the score past. Them a free know. Them a free know. Them a free know. Them a free know this say we the walk past. Them a free know. Them a free know. Them a free know. Them a free know this say we country salon for girl. Them a free know. Them a free know. Them a free know. Them a free know. Oh na na. If you no get good player, you na buy the player, the one where they try, the one where go come pull water na the eye, the player where go make everybody they smile, the player where go make we knock upside, the player where go make we fly and fly, the player where go make all the bill of them die, the player where go make we the boo boo bamba, na the player where go make we know the one them where they lie, the player where go pull water na we eye, na the player where go make all the bill of them die. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live, wololo. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live, wololo. If they say what they eat, then go weapon for we, you go mona them, you go mona them. If they say what we score, then go disallow the goal, you go mona them, you go mona them. Now the bella them, you go mona them. You say lad, if they say what they can, then go disturb with priest, you go mona them. If they say what they can, then go lock them for we, you go mona them. Who da them, now the bella them, the bella them, you go mona them. Mama, the system, the mona, lo lo lo, oh lo 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 lo. Papa, the system, the mona, oh lo lo, oh lo 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 lo. Mama, the system, the mona, oh lo lo, oh lo 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 lo. Papa, the system, the mona, oh lo lo, hey God.
All right, we still watch live coverage from the court, the Supreme Court. Usai Samura Kamara and a lawyer them make case of no submission. Well, according to any of Adrian Fisher, the justice, he don't refuse. He don't say they actually get case for answer. So that system of no case submission, we mean say they no get any case for answer. I say no, they actually get case for answer. So basically, then they look at when them for get an adjournment, where they will come and look at the different issues them. So far, then still the wait as Adrian Fisher. We don't ask for 10 minutes, but he actually don't pass 10 minutes as he don't ask for additional time because he say no one for make mistake. He want for basically see that he take the right action, and he basically say and as Samura Kamara now the flag bearer for the APC, he wants for make this case done quick one. So Samura Kamara will actually focus on in campaign as presidential candidate. He say he not go find for the campaign as presidential candidate. At the same time, the things they get case and something them for a good deal with in a court. He say that they very much unfair and instead self not go able for sit down with that kind of guilt they inside him for say this man a flag bearer at the go campaign and then at the same time they think of when and now for the Kamna court for can answer to case we then say it get for answer. So basically this now waiting to go on now the court, Supreme Court before Justice Adrian Fisher as he don't take a break quick one and say they come back for can see whether because the lawyers and they ask for they adjourn the case. In one for adjourn the case to tomorrow, Justice Fisher one for adjourn the case to tomorrow back. But the lawyer then they ask say they left and say Monday because they actually get for look at the ruling and then they actually advise the client when Dr. Samura Kamara on the necessary options them with them. So Justice Adrian Fisher be says and they say okay, let them give them some time, let it go and figure out certain things and then they come back for come see whether they go actually meet tomorrow or it go agree for let them meet on Monday. So if you want for know waiting will be the final adjournment date, please continue for the with this. Now we are on YouTube and on Facebook. If you know like the program, please consider for like the program and share them as well. And at the same time, if you know subscribe it to the channel, please consider for subscribe. We get 67,000 some 100 right now, and then we want for reach like 100,000 for meet up, you know, by the end of next month. So we get 67,159 people, then we actually don't subscribe. where we can call family members. So if you know say waiting we do relentless work, we actually try for being kind of the best of information to you. Please continue for watch the program and don't forget for like very important. On YouTube we get 896 where you watch right now because we don't get a break, so most of them don't go. And on Facebook at 921. So please continue for watch the program and share them as well. And don't forget for subscribe and follow we page them. For you and not subscribing to the channel, please consider for subscribe on YouTube. Thank you very much. We appreciate you. And thanks and welcome to the latest family member. We actually don't subscribe. If you watch up, also we say please give us 100,000 subscribers. You can see the number of YouTube subscribers, they change. You know, as we get people in way don't subscribe, you can see it change. Okay, so let me continue for listening to music whilst we wait for Justice Adrian Fisher for come and see waiting could be the next adjourned date. Okay. This is
the things I do. Yes, for me country, green, white and blue. I know say the bella them over and down no go party. Go don't bother that. You know we come together as one. For we country flag, I go die for me country flag. Oh, nana. If they say what I eat and go up on Paris, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bella them. Who are they? The bella them, you go one of them. Hey lad, if they say what them can, then go disturb with priest, you go one of them. If they say what them can, then go lock them Paris, you go one of them. Oh, now who da them, now the bella them. The bella them, you go one of them. Mama, this is the moon, lo lo lo, lo lo lo. Papa, this is the moon, lo lo lo, lo lo lo. Mama, this is the moon, lo lo lo, lo. Papa, this is the moon, lo lo. Capital A, capital B, capital C, they want turn and to D. Within a them plan, they want good sabi. Within a them plan, they want good sabi. We no go ever retreat and we no go surrender. Holy Ghost fire, they make them the blunder. All them bad plan, them back to sender. Papa God, now you know we defender. Time don't go, now check the calendar. We all they see, we not to sleep in wonder. I say the country, the wololo, the youth, them, the wololo, the system, wololo, we all live. Wololo, I say the country, the wololo, the...
Alright, so we go back to the court as then we can start the sitting. Justice Adrian Fisher don't come back.
DAPC. Justice Adrian Fisher has acknowledged that, and for the caution that, you know, that should not mean the matter will not go in accordance to the law. He'll do his work diligently with fear, having in mind that this is a public interest matter, as was mentioned by the defense lawyers. Party of lawyers representing Dr. Samura Kamara. You have the former Attorney General and Minister of Justice, Frank Kagbo, and in this same matter, the former Attorney General and Minister of Justice, Joseph Fijial Kamara, has represented Dr. Samura Kamara. He's not here today, but the former SEC Commissioner, Adima Kolizia, lawyer Sulaiman Kaba Koma is here, who made a submission earlier, lawyer Africano Sise, who was recently elected as the legal representative of the APC, is also here. Lawyer Alpha Jallo is here. Lawyer Roland Nylander, Radcliffe Jones, and many others are here representing Dr. Samura Matthew Wilson Kamara. On the other side of the bench, you have lawyer Pamomo Fofana, who is representing one of the accused persons. You also have Honorable Indolo Moyo Givao, who is representing one of the accused persons as well. You have Matsibo, who is representing the prosecuting team, the Anti-Corruption Commission in this matter. He has said he agrees time is of essence, justice delayed is justice denied. So he believes that the request of the Honorable Justice Adrian Fisher to the defense team should continue. The matter should continue today. That is what is requested for. The defense team have asked that the matter be adjourned for a week, and later they agree. Well, actually, lawyer Suleiman Kabak and Momo Fofana agreed that at least Monday they will have enough time to engage with their client, just so that they understand how to continue with this matter that has been in court since 2021. It's quiet here. Someone's phone is ringing, but it's quiet, and even a drop of a pin can be heard. Honorable Justice Adrian Fisher is still writing, perhaps writing what he will be reading. But what is unprecedented, but I think that is it. He is known as one of the tech-savvy, honorable justices. Even when he was here some time ago before he went to the UK and came back, he was delivering his judgment from a laptop computer. And I think journalists like him most times because his judgments are easily accessible. He types them and you get the soft copy, so it makes their work easier, and presumably even the lawyers. So he's known as one of the tech-savvy judges here at the Court of Salion. He was using his computer earlier today when reading his over 100 pages ruling, and everyone was listening attentively. And I must say, he's a guy, he's a judge with a very nice voice. Perhaps he could have been a good broadcaster, but he's here as the High Court judge, and today he has presided over this matter and gave his ruling. And he has been commended by both the prosecuting team and the defense lawyers of expediting the process, to this point. And the show of the exchanges and arguments most ended with laughter and some undertone, which might indicate that he's got a very good relationship with his land colleagues. Dressed in the black and white mostly, with their wigs on. The lawyers are all seated, some still reading, while some are still browsing their phones, waiting to hear what Honorable Justice Adrian Fisher, who is still writing with a pen, opening a very big book, reading, and then writing perhaps what he'll be delivering shortly. He has his red gown on and his wig, looking very serious. And understanding that the nation is watching and listening to him on what he'll be saying, as it's very clear now that this matter will definitely continue. The accused persons, including Dr. Samura Kamara, has a case to answer on allegations of corruption for the construction of the Chancery Building, the Salion Chancery Building in New York, the United States of America. I must say, this law court building has one of the best air conditioners. You don't feel the heat when you're in here. Perhaps it's different from so many other public buildings. It looks well maintained with a lot of light and fully air conditioned. Well, lawyers use wigs, they have their accounts on, so you definitely will have to, they are always well suited with their coats and tie. You can't afford to have them in a place that is not well ventilated, or better still, air conditioners that are workable. So I think that's one good thing that we should say. The courtroom looks very nice, with enough light for our camera guys. Honorable Justice Adrian Fisher is about to speak. Keep listening and watching.
I have reviewed the relevant laws and I've looked at the statutes, including relevant authorities on the ruling of the court. I've listened carefully to the pleas of the defense counsel in this case and seeking a date for the accused persons to be put to the election. This is a criminal trial and the applicable laws and procedures have to be followed. I've had regard to section 192 to section 194 of the Criminal Procedure Act 1965, which requires the accused persons to be put to their election at the close of the prosecution's case and not after the prosecution's case or after a no case submission. A submission of no case is separate and distinct from the requirement of the accused to indicate to the court as to how they intend to conduct their defense. The court is also open in appropriate circumstances in the interest of justice to allow an accused person to amend their election if they so choose. This case has been in the courts since November 2021. And the lawyers for the accused have had a sufficient time, as demonstrated by the extensive cross-examination to which witnesses were subjected to have decided what to do at the close of the prosecution's case. To require time simply to determine what to do at the close of the prosecution's case, or in fact after the prosecution's case and after a no case submission, when the prosecution's case became closed on the 12th of December 2022, is inimical to the interest of justice, and in the circumstances the accused persons would be put to their elections immediately. I've also considered paragraph 549 of Archibald 36th edition, which requires such an election to be made at the close of the prosecution's case and not after the prosecution's case. And upon a review of the relevant authorities, the election is akin to taking a plea, and time cannot be given for the taking of a plea upon the arraignment or appearance of an accused person. In the circumstances, I would order as follows: the accused be put to the election and may be advised by their lawyers if they so please. I'm satisfied, secondly, that ample time has been given for that decision to be made, having regard to the 30 minutes time down that I have already taken and the length of time the proceedings have so far been taken to reach this stage. That's the ruling of the court. Right, Mr. Nalo, stand up, please. Now, yeah, sure, feel free to do so. Right, Mr. Nalo,
the law requires that in a criminal trial, I must follow the law to the letter. There's no room to short circuit or to change the laws. I've got to follow it, because any non-compliance with the laws can create problems. So, in that regard, the law requires, under section 192 to 194 of the Criminal Procedure Act, that at the close of the prosecution's case, I need to put you to your election. That does not mean that you have to start your defense immediately. It simply means that I need to tell you what your options are and to get an indication from you as to how you intend to conduct your defense. Now, in the area of witnesses, you don't have to tell me at this point how many witnesses you wish to call, if you do wish to call witnesses. But suffice to say, I need to know if you intend to call witnesses, and then of course the court then gives you time to determine when those witnesses will be called. Do you understand what I'm saying so far?
I do.
Right. So I need to comply with what the statute says, which is the Criminal Procedure Act. Okay? So now you're free to confer with your counsel to ask him what should I do if he has not already told you. But these are the options that you have available to you. Now, you remember that back then when this case started, you gave a statement to the ACC. You remember that statement?
Yeah.
All right, and that statement has been tendered in this court. It is before the court. Okay? So, you can decide to say, okay, I'm happy with what I've said in that statement, and I have nothing more to say, but I'm going to call witnesses, or I am not going to call witnesses. Do you understand that?
Yes, I know.
All right. So that is option number one. So keep that in the bank, and then we'll come back to it later on. Okay?
So,
all right.
Just on procedural issue, we see that the cameras are still on in court. We don't know whether the cameras can participate while the trial is proceeding. Yes. So given your ruling has finished, and then the cameras are still in court. So we just want to get, it's a criminal trial. So we don't know whether the cameras are allowed to hear while the trial is going on out there, because the ruling has been given and it has completed.
The Constitution requires a criminal trial to be held in public. So nothing wrong with that.
That's an application. Full-fledged studio and equipment, and as accused persons, whether we can also bring our equipment into the court to
make your application.
As the law.
Right. So, Mr. Dalo, you understand the first option that I gave you?
Yes,
okay. All right. Now, the second option, where you are right now, you can just stand there and tell me everything you want to tell me about the case. Okay?
Okay.
I would listen to you, I would record all of it down, but then nobody will ask you any questions. Okay? So you will just explain what is going on, and we will still consider what you have said. So that's the second option that you have. Okay? Now, the third option you have is you can decide to say, I'm going to come into the witness box and I'm going to testify in the same way that the witnesses for the prosecution have testified. Okay? The difference here is when you come into the witness box there, the prosecutors will ask you questions, they will cross-examine you in the same way that your lawyers were cross-examining the witnesses for the prosecution. Do you understand that?
Yes, ma'am.
Right. Now, there's something else I should let you know. If you stand where you are and just explain about the case, the weight that I will put on that evidence will not be as if you are in the witness box, for the simple reason that that evidence is not tested by cross-examination. So I will listen to you, but I might believe you, I might not believe you. All right, that is what that is for. Now, if you come into the witness box here, where you take one of those books, you swear on them, and then the prosecutors ask you questions, the law requires that I evaluate that evidence in terms of whether I believe you or not, in the same way that I evaluated the evidence of witnesses for the prosecution. So, in other words, I'll look at them and say, well, I believe what Mr. Nalo is telling me, and I disbelieve what the prosecution witnesses have told me. Or alternatively, I can say I don't believe what Mr. Nalo is telling me, but I believe what the prosecution witnesses are telling me. But essentially, you need to understand the difference between the two. That will still record where you are, will still record in this witness box, but the evidence that you give in the witness box will carry more weight than one that you give standing where you are. And then with all three of those options, you have a right to still call witnesses or to decide that well, I'm not going to call any witness. Okay, you understand those points? Yes, so these are the three options that you have, of which the law requires that I address it to you and ask you to make a decision, of course, subject to whatever advice your counsel gives you.
Thank you.
Can you understand those, yes?
Yes, I do, my lord.
Okay.
Can I ask a question, please? You're giving me three options. Is it the case that I may choose all three options, or I have it's only one or two?
No, you only have one out of the three. So it's A, B, or C. Because that's the way the statute, the Criminal Procedure Act says you should go about it. But with all three options, you have a right to call witnesses. Even if you are coming into the box, you can call a witness. Even if you're just relying on the statement which you gave to the ACC, you can call a witness. If you're standing there, you can call a witness. Alright? But you only have one main option and then the witnesses can come in.
Thank you.
Thank you very much.
The instruction of the client is that...
No, I can't hear from you.
Oh, okay.
It should come from him.
Yes, no, I was just going to say that he's ready to be put to the election.
Yeah, but it has to come from him.
Yes, he's ready to do that. That's what I said.
Okay. Mr. Nalo, again, I need to make sure. Have you had advice from your lawyer?
I've just conferred with the lawyer.
No, I just want to know that. Have you had advice from him?
Yes.
Okay. Yes?
My lord, at this stage of the trial, I must let you know that right from the beginning, I have made it known to my solicitor that I'm ready to take the case box. Thank you very much.
Okay.
And I call witnesses.
And call witnesses. And let me just let you know, as I've just said, just to remind you, that your evidence will carry the same weight as the evidence given by prosecution witnesses. So it doesn't mean I treat your evidence any less than I treat their evidence. Yes, you may say, thank you.
And when you follow caveat that it is subject to what comes out of it.
Yes, and this is in the ruling that should there be a need to change elections as a result of the local visit, sure, the court is open to that.
As your lordship.
Right, Mr. Suma, stand up, please. Right, Mr. Mr. Suma, I know you've had this all before, but the law says I need to tell you. Alright? In a criminal trial, we must follow the law as it is. There's no room to change things around. Okay?
Yes, my lord.
So, what the law requires is that at the close of the prosecution's case, I must immediately put you to your election. Now, there's been a no-case submission which has taken some time to complete, but notwithstanding, the law requires that I do that. It's in the Criminal Procedure Act. Okay?
Yes, my lord.
So, having said that, the law says I should ask you and give to you 3 options that you pick one of those options. Now, option number 1, you can stand where you are and just explain everything you want to explain about this case. I will note it all down, and when I come to consider a verdict, I will look at it, I'll take it into account with all the other evidence that is before the court.
Yes.
Okay? That's number 1. Do you understand that option?
Yes, my lord.
Okay. Now, option number 2, you can decide to say, I gave a statement to the anti-corruption at the start of this case. I'm happy with that statement. I've got nothing to say. Because you do not have to prove anything. It is the anti-corruption that have to prove their case against you. They have the burden to prove the case against you. So you're not obliged to even say anything in this case, but it's a matter for you. So you can simply rely on the statement that you gave to the ACC and say nothing more. Okay? Yes. That's option number 2. Now, option number 3, you can come into the witness box there, take one of those books, you swear on them, and then you give your evidence in the same way like the other witnesses for the prosecution have done. Now, when you finish giving that evidence, the lawyers for the ACC will ask you questions in the same way like your lawyers were asking questions of witnesses for the prosecution. Do you understand that?
Yes, my lord.
Okay, now there are benefits and demerits to both coming into the witness box to testify on oath and to stand where you are and just tell the court anything you want to say. Now, if you stand where you are and just tell the court everything you want to say, I will not give it as much weight as I would give it to the evidence that you give in the witness box. So I will listen to you, but then I might decide, well, I don't believe him anyway, and I just ignore it. Now, if you come into the witness box and you testify, because of the fact that the prosecution will be asking you questions, the law requires me to take that evidence in the same way like I would take the evidence for witnesses for the prosecution.
Yes,
so I'll look at what you say and I'll compare and contrast backwards and forwards until I come to a position on it. Okay? So you understand those 3 options?
Yes, my lord.
Alright. Now, the other option that you have is you can call witnesses. Either option that you choose, A, B, or C, you can call witnesses and say to them, look, come and testify for me. You don't have to tell me how many witnesses you have now, but you could simply say to me, I think I'll be calling witnesses. Okay?
Yes,
now, down the line, when we come back from New York, if you think that, well, what I said to the court earlier on, I want to change my mind, you let me know. And then, of course, I will give you an opportunity to change your mind if that's what you want to do. The law allows that.
Yes,
okay?
Yes.
Now, again, the statement that you've given to the ACC, you can rely on that and then say, well, I have a witness or I don't have a witness. So, do you understand those 3 options?
Yes, my lord.
All right. Now, before I hear from you, you have an opportunity to confer with your counsel. Ask for him to advise you as to what you need to do. And before you speak again, I will ask you if you've got that legal advice from him. Alright? Yes,
Miller, having looked at the authority section 192 section 1, as long as the accused is defended, that could be done by counsel.
No. The accused is put to his election.
No. As long as counsel.
No.
I go through the.
No, I have gone through it. That's why I went upstairs to consult and to look at it. I've looked at the authorities. No, the accused must be put to his election. I've looked on it. It's not just 192 I've looked at, 192 to 194. No,
as long as counsel is defended.
I have ruled on it. Because they say, I'm not going to entertain it. The accused can get advice from counsel, but it is his trial and he needs to decide which way he wants to go subject to advice.
The authority is saying, as long as the accused is defended,
I've seen
counsel can do it.
No, I've looked at the authorities as well. That's why I went upstairs. There's several authorities on the point. It is the accused that is put to his election. I know what you say in the CPA, but the 192 to 194 gives the accused the right to put to his election.
The authority 192 is very clear on this point.
Yeah, but there are several case law, right up from the Supreme Court.
This is the authority of the Bible.
So what? So the Supreme Court has interpreted and you say no? No.
It is where accused is only represented.
No.
That is where
I have ruled on it and they say no. I'm not going to rule on it again. I've ruled on it.
May be taken out that you made a ruling on it.
Yes, I have. That's what I've ruled on it.
Are you going to take me out on the objection?
No, I will not reopen it because I've ruled on it.
I have not made my objection and
no, I will not reopen it because I've ruled on it. I've gone upstairs, I've looked at the authorities, I've looked at the law.
Made the objection,
no.
And now you have ruled on it, my lord.
And I've said no, I'm not going to reopen it. No, I'm not reopening it. All the authorities that I saw from the Supreme Court down to the Court of Appeal and the High Court requires the accused to be put to his election. You can advise him, it's the same thing. It doesn't make a difference.
Yes, my lord, I can do it for him because he's represented, my lord.
No, he's represented, I know, but the accused must be put, the opening salvo is the accused must be put to his election.
My lord,
no, Mr. Sisi, no.
And my lord, counsel is represented here.
No.
Can rightly so answer pursuant to section 191.
Mr. Sisi, I've ruled on it, I'm not going to rule on it.
I've made my application.
No, I've ruled on the point, I have had what everybody said, I went upstairs, I took the CPA, I ruled on it, and that's it. No.
May I be favor with the ruling?
No. I've ruled on it. No. The law is very clear. I've ruled on it. You know, the accused is here, he can speak for himself, his counsel does not need to speak for him.
The authority is here. This is the Bible.
And the Supreme Court has decisions that I've looked at.
We've not seen your ruling.
Well,
we've not seen your ruling. We've not had your ruling.
No, I'll finish with this. Yes, Mr. Suma. So, Mr. Suma, I will say that you're free to consult with your counsel on the options that I have given you. But the law is very clear that I should hear it from you. That's why I'd like to listen to you, okay?
Yes, my lord.
Right, Mr. Suma, again, the law requires me to ask you, for the purpose of subsection 23, have you conferred with your lawyer?
Yes, my lord.
Right, and of the three options that I've given you, which one do you intend to take?
My honor, I elect to pursue the third option and call witnesses.
Yes, no, all of the three options that you have, you can call witnesses on all of them.
I elect to take the witness box.
You need to take the witness box?
Yes, President.
But let me just remind you again that when you testify in the witness box and you take one of those books and you swear on them, the evidence has the same weight as that given by prosecution witnesses. Yes, sir. All right, so I'll look at it in a round. And then you say you're going to call witnesses. Yes, sir. Okay. Thank you very much. You may sit. Yes, sir. Mr. Bawo. I know you've heard what I've said, but I still need to go over it again with you. Okay? Now, the law requires that everything we do in a criminal trial must follow the legal process. So, the CPA, that's the Criminal Procedure Act, requires that at the close of the prosecution's case, I must put you to your election. Okay? Now, in putting you to election, you are simply indicating to the court what you intend to do as part of your case. Now, you are free and you have the right to confer with your lawyer at any stage. So, whatever it is you say, you're doing it on legal advice. Okay? Now, you remember when you started off with this case, you gave a statement to the ACC. Right. Now, that statement is already before the court. So you have a choice. Okay? You can rely on that statement that you gave to the ACC, and then you say, I have nothing more to say. I'm just going to rely on that statement that I've given to the ACC. So that is option number one. Do you understand that? Okay. Now, option number two, you can stand where you are as it is, say nothing whatsoever, or in fact explain everything you want to say, or just whatever you want to say, you say it. I will note it down, but then I'll listen to it, but then I'll take it into account as part of the overall case. That's option number two. Okay? You understand that? Yes, sir. Alright. Option number three, you can come in here and then you say, okay, I'm going to pick one of those books in there, Bible or Quran. I'm going to swear on them, and then I'm going to tell the court exactly what happened. Now, the law requires that I should give you equal weight, like I gave the prosecution witnesses. So in other words, their evidence is not better than yours. I'll consider it in the same way like I'll consider them to determine one way or the other who I believe. Okay? But when you finish in that box, the state lawyers will have to ask you questions. So the court examine you in the same way like your lawyers have been cross-examining witnesses for the prosecution. Do you understand that option? Alright. So now, the difference between the two, that is you standing where you are and telling me anything you want to tell me about the case, and coming to the witness box, it means that when you stand there, I don't place much weight on it. I will simply listen to you, record it, and if there's something in there that I believe I should pay attention to, I will. Because the reason being, questions were not asked by the prosecutors. Okay? Yes, sir. But if you go in there, it's different issue. So those are the three options that you have. Okay? Of those three options, A, B, and C, if you want to call witnesses. So you can say, you don't have to tell me now that you have 5 witnesses or how many witnesses, but I have witnesses which I will call subsequently. Okay, so do you understand those three options? Alright, before you tell me what you want to do, you have a right to confer with your lawyer to say, well, what do you advise me to do? And then when you finish, I'm going to ask you again whether you've got legal advice. I don't want to know what your lawyer told you, but just tell me that yes, I've got legal advice. Okay? So you understand those? necessarily come out. I think you should be planning what to do. Okay. Okay. Now, Mr. Bao, have you had legal advice from your counsel?
Yes, ma'am.
Alright, so of those three options that are given you, what do you intend to do?
The third one, I want to put with a proviso, sir, as I have witnesses.
Sorry?
I have witnesses. I have planned to get witnesses from America. So I intend to request from the court to fund their trip for America to here and from here to America.
Right. Now, your witnesses do not need to come here because we can arrange video links where they can testify via video links. So it saves cost. But when we're done, the registrar will tell you what to do. Alright? Now, you say you have witnesses to call, yeah? Alright. Thank you very much. You may sit. Right, Dr. Kamara, good afternoon.
Good afternoon, my lord.
Right, in every criminal trial, the law requires that we follow the law to the letter as it is, which means that at the close of the prosecution's case, the law requires, as in the Criminal Procedure Act, that I should put you to your election. In other words, I should inquire from you how you intend to conduct your defense in this case. Alright? So that is what the law requires me to do. Now, of course, you're represented by counsel, so you are free at any stage of the process to consult with your counsel and get legal advice from them. Okay? Alright, so now, remember when this case started off, you had statements taken from you at the ACC.
Yes, madam.
Alright, so you can look at those statements and say, okay, I've given those statements to the ACC, I'm not going to say anything more. Because it is the prosecution that brought you here that have the duty to prove your guilt in this court. You don't have to prove anything. Okay? So you can simply say, I've given my statement and I say nothing more. Case closed. That's option number one that you have. Okay?
Yes.
You understand that option?
I do.
Okay. Now, option number two that you have, you can simply stand where you are and say, okay, you know what? I need to explain what has been going on. And then, however long it takes, whatever you want to say, I will record everything that you're saying to me. And then you can say, okay, I've said all what I want to say, and that's it. I know it at that. Okay, that's option number two.
I do.
Okay. Now, option number three, you can decide to say, you know what I'm going to do? I'm going to come into this witness box because I want the court to hear from me as to what happened. So you take one of those books, Quran or the Bible, you swear on them on oath, and then you testify just like witnesses for the prosecution. So essentially you'll be allowed to say your counsel will be asking you questions and then you explain what you want to explain, and then when you're done, the lawyers from the prosecution would ask you questions. So that's option number three. Now, I need to explain to you the two options that you have. Now, if you stand where you are and just explain to me whatever you want to say, I will listen to you, I will record it, but then I might say, okay, yeah, well, I've had it, but I don't have. You okay?
I am.
Okay. So I might just say, okay, I listened to you, I heard you, and that's it. But if I see something that maybe is important, I will listen to it. But then the weight that I give to it is not like the evidence that is given in the witness box. So if you are in the witness box, even though you are accused, but your evidence carries the same weight as the prosecution witnesses that testified here. But the only thing is, the prosecutors here will ask you questions. Then we can assess the evidence one way or the other. So these are the three options that you have. Now, amongst those three options, you can call witnesses that will come here, take the oath, and then they will testify on your behalf to say, oh, doctor, don't do this, or whatever it is they want to tell us. And then when they finish, the prosecutors here will ask them questions. And then we will take all of that evidence in the round and consider it with whichever option that you choose to determine how to go about the verdict. Okay? Yes. So the important thing here that you need to remember is there are benefits of taking one option and there are demerits of taking another option. But then what you do, you confer with your counsel who will advise you as to what you wish to do. Okay? Now, when you're done, the law requires me to ask you again if you've had the benefit of legal advice. So you understand those options? I do. Alright. So you're free to confirm with Mr. Kagwe.
Thank you, my Lord.
So, Dr. Kamara, have you had legal advice? Well, don't tell me what he told you. I just need to know if you've had legal advice.
Within the time frame given to me, I have.
But you have conferred with your lawyer?
Within the time frame. I wish I had more time.
Well, you know, you still, let me say, you have the option. Down the line, I'm open to say to you, if you feel that, well, that option that I chose, I don't like it, I can change it. I'll give you that option as well.
Okay.
Because we have to go to New York, and when we come back, you might choose to change your mind. But just so I have an indication of how you intend to conduct your defense. All right? Okay. So, what do you intend to do?
I will testify. I'll call witnesses over time. From the box, yeah.
So you come to the witness box to testify as a witness in the case?
To the best of my ability, I will.
Okay. Now, just so you know, that evidence that you give is the same. We're not looking at you as an accused when you're in that box. You're a witness like everybody else. You understand that?
I know, well.
Okay. All right. Thank you very much, sir. Yeah. Right, Mr. Teddy Kromer.
Yes.
The client online?
Yes, you have called him. And he has been following the proceedings.
All right. Mr. Kamara, Dr. Kamara, sorry, can you hear me? Sorry, not you.
Kamara?
Dr. Kande Basil Puri Kamara.
We judge is now addressing you, okay? So you have to listen. Yes, sir. Yes,
all right. Can you hear me what I'm saying, Dr. Kamara?
I'm not getting you clear because of the mic.
Alright. But can you hear me now?
Yeah, I can hear you.
Alright. Now, we're at the stage of the proceedings where the law requires that I need to put you to your election to decide how you want to put your defense in this case. Do you understand?
Yes, my lord.
Alright. So, the law says that I should give you a number of options. Now, I'm going to give you those options and I'm going to explain to you what those options mean. But when I'm done, you are entitled to confer with your lawyer to get advice from him as to which way you intend to go. Do you understand that?
Yes, my lord.
Alright. Now, Option number one, you remember when this matter started off, the ACC did take a statement from you. Remember that?
Sorry?
Do you remember giving a statement to the anti-corruption?
Yes, my lord.
Alright. So, option number one that you have is you can simply say you're going to rely upon that statement that you gave to the ACC and you say nothing more. That's option number one. Do you understand that option?
Yes, my lord.
Alright. So keep that in the back. Now the second option you have is you can swear on oath, take one of those books, Bible or Quran, and then we'll get a video link out for you to make sure you have a Bible and a Quran, and then you can testify in your own behalf. You understand that?
Yes, my lord.
Alright, and when you finish, whilst you're doing it, your lawyer will ask you questions. And when you're done, the lawyers for the prosecution would ask you questions again. Do you understand that?
Yes, my lord.
Alright. Now, the other option that you have, which is the third option that you have, is you can simply, like you're talking to me now, just explain anything you want to explain about this case. You understand that?
Come again, my lord.
Alright, I said you can simply explain to me, like you are right now, tell me anything you want to tell me about this case.
Yes, my lord.
I will listen to you, I will note it down, but then that's about it. Because I will not be able to give it a lot of weight because it has not been tested in cross-examination. You understand that?
Yes, my lord.
So the benefits and the demerits of the two of them is, if you just tell me anything you want to tell me about this case, I might not take it in the way I should take it if you are testifying on oath. Simply because the evidence that you give on oath would have been tested in cross-examination. So you will be treated as a witness like all other witnesses for the prosecution. You understand that?
Yes, my lord.
Alright. Then, of all those three options which I've given to you, you have a right to call witnesses if you wish to. Do you understand that?
Yes, my lord.
So either option A, B, or C, you can call a witness to come to court here or to testify via video link on your behalf. Do you understand those three options?
Yes, my lord.
Alright, so now you are going to be free to talk to your lawyer who will advise you what to do. But then when you're done, I'm going to ask you if you've had legal advice from your lawyer. Do you understand that?
Yes, my lord.
Alright, so you're free to talk to your lawyer.
Permit me.
Sure. Dr. Kamara, can you hear me? Alright. Now, have you had legal advice from your counsel?
Yes, my lord.
Alright. So, of those three options that I gave you, which one of those options would you elect to choose?
The second option.
Which is what?
The second option.
Which option? Which of the three? Tell me.
The second option.
What is the second option? Testify.
To testify on the oath.
Now, do you have any witnesses that you wish to call? Do you have any witnesses that you wish to call?
I may, my lord.
Are you saying you may call witnesses?
Yes, my lord, I may call.
All right. Now, what I want to say to you is this, that in as much as you've chosen these options now, you're free, following the visit in New York, to change your mind, and I'll accommodate you on that, okay?
Yes, my lord.
All right. Thank you very much. Right. Just so councils are aware, the locus in co-visit is likely to be done between the 1st and the 8th of March. The 1st and the 8th of March. So preparations are actively in earnest for that period. And I propose to bring this matter back on the 17th of March for the start of the defense case. So anybody that has witnesses, I think we should be getting our witnesses ready. If obviously, depending on what happens in New York, what we see in New York, people might change their minds. I don't have a problem. But the only thing that I would say is, if there's going to be a change of mind after New York, please do an application quickly so we don't waste time on it. So I know there's going to be a change of mind, so and then I can adjust the dates one way or the other, bring it forward just to deal with the question of election. But the defense case will start on the 17th of March. Anybody has any issues with that?
I'm not with that part. Michael. Once again, listening to this election, he was trying to inform the court that he intends calling witnesses on my advice, my lord. But it is clear that the witnesses we will be calling are all in the United States of America. And we really love to actually have them in person so that the judge gets to see the examination in chief and the cross-examination. They are to study the demeanor of the witnesses as it's often done, or as it was done with the prosecution witnesses, my lord.
So I can't see them on video link?
My lord, I would just love the court to follow the trend. I mean, the prosecution, there were times it took like a month or two just waiting for one witness to come from abroad to come and testify. You know, if my memory serves me well, there was one particular witness we adjourned for over a month or so because the court really wanted to see that witness in person. You know. I take the cue that we are fastly trying to go technological, but as defense counsel, I would be much more comforted if this witness, we have to take the witness stand and examine him in chief, my lord.
So are you prepared to pay for him to come in?
My lord, that's why I am asking the state, my lord, because it's justice, my lord, justice for the accused and justice for the prosecution. My client has not been working since he was indicted in this matter. He's not been working, he's been on 50% of what he needs to earn.
Well, now you see, Mr. Guevara, why that's another reason why I want this matter over and done with. Because it's certainly not fair on somebody, if they're going to be acquitted, to have to be suffering for months and months and months and months until the matter is finished. You know. But then if you're saying to me that
Just telling me, I think 600,000, 800,000 years.
Well, absolutely, and you know, nobody can survive on that.
Yes.
So that's all the more reason why I sit and I think, well, I would not want to be in the position that they're in. So this matter needs to be dealt with. You know, I mean, people need, because already they've lost a lot by being in court. So we cannot ignore that. But that said, if you are saying to me that you want the witnesses to come here, then you need to give me the legal basis for the state to foot the bill.
Madam, we will endeavor to justify why the state should. Madam, if you look at our jurisdiction, madam, we operate on a legal aid basis, particularly when an accused person is impecunious. My Lord, speaking from the bar, I am doing this matter pro bono because this accused person cannot afford my services.
And God will bless you abundantly.
Yes. And I know because he cannot afford my services, he definitely cannot afford the means of flying a witness from America to come and testify at his behalf. My Lord, all the reason why the state being a person is interested in justice for the state and justice for the accused under its peace. The accused who is under the peace of the state. That's why the state should afford us the opportunity by funding our witness to fly in and come and testify. Now, a criminal matter of this nature is something we take very serious as a defense, me in particular, because we all know the end product of it. We know the end product of it. You know, if you get the sweetest word in the world, not guilty, you go sleeping. If you get the most sad word of guilty, your entire life is put on hold. So there is no amount of financial investment that will match human liberty. Now, that's all the reason why I am pleading with this court manual to afford us the opportunity to present the best of defense in this case for the third accused person.
Right, well, let us put it this way. I can only imagine that Mr. Maximo might have something to say about that. But what the law does require is if you cannot afford to pay for a lawyer, the state will pay for it. But then you will have to convince me that the law should be made to pay for a witness to come and testify in your case. But there's no precedent for it.
My Lord, in the same vein, I am not sure there is precedent for lawyers for the defense to be funded abroad for a locus income. But on this case, taking the exigency or the importance of the case, the state is going to be funding defense counsel because the accused person is impecunious to fund his own.
No. The difference with that is that lawyer is going to carry out legal representation, albeit in New York. So the state must fund that. But as to calling a witness to say, well, come and testify for me, and then the state should pay for that, there's no precedent for that.
My Lord, the question that I would love to ask to the state is just if this witness cannot afford to bring his witness to testify, and as a result of his failure to bring a witness, he's convicted.
Well, that is why we have video link. I can look at the witness, I'm able to see what the witness is saying, I'm able to assess the demeanor in the same way. Like I would look at the witness if he's standing across there.
So I take the point. Man, I take the point.
But not to discourage you, Mr. Guevara, what I would say, if you believe passionately about it, file a motion asking for those prayers that the state funds the provision or the facilitation of a witness from the United States to Sierra Leone and back. And then, of course, it gives the state an opportunity to respond, and then I will rule on it. That's the best I can do.
Great, for the direction.
All right. Mr. Massimo, I guess you have something to say about that.
As a preliminary observation, there seems to be some confusion rather is to the state and the prosecutor. I'm fully aware that we prosecute in the name of the state. But when it comes to issues relating to legal aid, and it's not really the responsibility of the prosecuting authority.
No, it is the state. That is what the Constitution says.
Yes, the state, but not for clarity, not the ACC.
No, but you are representing the state.
Yes, and there are mechanisms, there are bodies that are set out specifically for that. It doesn't have anything to do with the prosecutor. Whether it's the state.
No. It is not you per se, or as in the ACC should deal with it, but if an application is made, which I believe Mr. Giva was talking about, it's a matter for you to then pass it on to the state that you're representing. To say, I have this application before me, counsel for the accused is asking for a witness to come here, and then you take instructions, because you're representing the state.
Yes. Wouldn't it be far faster, so to speak, if they approach the appropriate body?
No.
Legal aid is there.
No, the Legal Act would not effectively cover that request that he's asking for.
Okay.
What is happening here is we're in the middle of a criminal trial, and he says, well, as part of my defense, I need to have a witness here, but I cannot afford to get that witness here. So it is for this reason why I've said to him, you need to file a motion seeking the state to pay for that witness to come over here. You will have an opportunity to file an affidavit in opposition, and then I will rule on it as to the best way forward in the interest of justice.
Yes. It's that obligation that
No. The issue is, the onus is on them to show. That's why I've told Mr. Gibao to tell me the basis of his application and to put it in application. So then I see the legal basis of his request. Because as far as I am concerned, I can see the witness by video link. Now COVID has got us to the point where we can see people across the world. So, but if he is saying he wants to see the witness here live, he needs to give a good reason in his motion. That's why. So, and then of course you will have an opportunity to respond to anything that he says. So this is where we are, and this is why I've not said anything about it until he files, and then we'll have to explain the reasoning behind his filing. Right? And of course, if that is the case, then arrangements can be made, or if there's a ruling to the effect that the state should pay, then we'll take it from there. Is fine? Okay. Yeah, Mr. Kaki.
Just a little. At this point, I want to just inform the court that I will be going on the New York trip. And in that regard, I wonder whether you could vary. Was it an order that was given us to the people going to New York to have our friends on the other side assist in securing the visa?
Well, I think that is subject to the previous ruling, but then I also gave a ruling yesterday, which I ordered the master to forward it to Foreign Affairs and to get necessary applications dealt with. You want a copy of the ruling, the registrar will give it to you.
Yes, my lord.
But that was sent yesterday.
Okay, my lord. The next issue is whether the cameras are now a permanent fixture in this court when this trial is on, because
you also have your own.
We have our own, yes, my lord, that we would love to bring, given the opportunity, my lord. And we broadcast, we really broadcast worldwide, my lord.
Well, it's, look, put it this way, a decision was taken.
Yes, my lord.
That this ruling, for transparency purposes, needs to go out, needs to be broadcast. As to what happens after today, I cannot say. But in view of the fact that you have your own media,
yes, my lord,
I would suggest you write to the Honorable Chief Justice and tell him that we want to also come and broadcast. And of course, if he gives the go-ahead, I'm sure your media will be here too.
Yes, my lord, that's the That's normal nowadays in the...
Yes, but I think, you know, trials like this,
yes,
my view is that they should be broadcast.
As we not please.
You know, that's my view.
Yes.
That everybody should be able to sit in the comfort of their homes and observe what is going on in the court.
Yes, and that's a very powerful campaign record for us.
Well, whatever that might be, I don't know. But all I know is a trial should be published so people get to know. I mean, you have court TV in America.
Yes,
Yeah. So I see no reason why we should not have court TV here.
We should write to the CJ.
Yeah, write to the CJ and ask him to say, look, I have my own media, whatever your media is called. Yeah. I don't know, but I'm sure he will consider it.
That's the Lord, please.
Right? But for today, the cameras are only here for today.
For the ruling.
Yes, I have got nothing else to say that they will be here on next adjournment.
And that's a landmark ruling, Lord.
I mean, we just have to deal with it, you know, and to let the public understand what's going on.
As blood pleases.
You know.
But Lord, you will still need to perhaps emphasize the fact that nobody has been convicted, nobody has been found guilty. Because for us in the political arena, you know these things can be twisted.
No, yes, and I entirely agree with you, and this is why you would have noted that at the start of this ruling, I indicated that at paragraph 5, that nobody has been convicted. This is not about guilt or innocence. It's simply about whether the prosecution has established a case. And that's why I went into length to say, at the end of the day, the prosecution has not established a case. So nobody should be going out there to say, oh, guilty or not guilty. No, we've not reached that stage.
Much of that, sir.
You know, and I'm sure members of the press understand that we've not dealt with guilt or innocence today, and I do not want to see anything about guilty or any of that in the papers. But I'm not worried about the papers anyway, but I'm worried about the social media.
As the Lord pleases.
You know, and those who are in the habit of giving out misinformation on social media,
yes,
about people being guilty when they've not been found guilty, if you're caught, you know, it won't be nice.
As the Lord pleases.
So I hope people understand, if you're going to make comments about the case, be accurate. Nobody has been found guilty. We're just here today to look at what the evidences that the prosecution has given. I've been very clear that the test we used was not beyond reasonable doubt. Just a basic test that is there a case, yes, there is a case. We'll continue.
That's me, Lord.
Right? And I think those who are wise enough understand that.
Lastly, my Lord, on behalf of the defense, perhaps we want to have hard copies of either hard or electronic copies of the ruling, sir.
Sure, you get hard copies of it. It won't be today, I'm afraid. I would have loved to give it out today, but it'll be tomorrow.
As we not please.
So if you have a talk with the registrar, Anne,
yes,
you're there, yes?
Okay, sir.
Yeah, if you have a talk with the registrar, he will get copies of it available, and then I might just, those who supplied by email, forward these soft copies.
As we not please.
But I'm not promising, but I just might.
Thank you, Lord. But I will take it now that the adjournment to a week's time is...
No, that is dispensed with. We're back on the 17th of March.
As we not please.
For the defense's case, and in between now and the 17th of March, the notification will come out. We need to go to New York and come back.
As we not please.
And when we come back from New York, if there's any applications that need to be made, Mr. Guevara, I'm thinking about you. You need to make that application, so we'll deal with it before the 17th. I would not want to come on the 17th, then we'll say, well, oh, you know, I have this and that. No, so let's deal with it. And Mr. Mansibo, the same applies to you as well. If there are any issues that you wish to raise after New York, I'm going to reopen my case where I seek to, I need to have those motions before the 17th so I can deal with them. All right? But if they are known, that's fine. We'll come, the defense starts their case, and that's it.
Just one other it's a bit sensitive in the sense that these are issues that we have been dealing with a bit of discretion, i.e. we have made reference to prevailing circumstances. Every one of us knows what those are. But my learned friend, with the greatest of respect, has made a statement which might be interpreted otherwise.
What statement?
When he made the indication that accused number 4 will be the next president.
Wait a minute. Why are you guys pouncing on him?
I just want to assure. I just,
can I finish? My lord, can I be allowed to finish my submission?
Hold on, hey. Gentlemen. Hey, gentlemen, please. Please. Hey, Mr. Kamara. No, please. No, please. Hey, gentlemen, please. Come on, this is a call. No, hold on, Mr. Kamara. 1 second. Hold on. Look. Let's not descend this place into some gutter or junk gutter. There's a simple, the lawyer is making an issue, is saying something that concerns him, right? And address it to Mr. Kagbo. And I expect to hear only from Mr. Kagbo. So please, let's just maintain the decorum. Mr. Mason, I think you want to say something.
For 1 or 2 reasons, I've kept quiet throughout the day. But I too found it unnecessary for the statement to have come from my learned friend, for whom I have the greatest of respect. My Lord, this is a court of law, and this is a criminal trial, and nobody is above the law. I know that only His Excellency the President, while in office, cannot be brought to justice. My Lord, my learned friend Masibo and I whispered together that making that statement might send the wrong message. And I have seen, unfortunately, a demonstration, not by the public, but by our colleagues, who, when this, my learned friend, made mention of the fact that was unnecessary, it was jumped at. My Lord, I never like to join into political issues. I've always kept the distance. But my Lord, the public is there. And some members of the public may see us as not doing our job, but going after their leaders. So I think it behoves all of us to, especially when we're in court, maintain an atmosphere that will not send the wrong message. My Lord, I know that perhaps I am far gone in age, but I would like to leave this world in a peaceful way. These are not normal circumstances. We all know what the circumstances are. Well, I would plead that we keep the political issues out of court. Thank you very much.
Please, my Lord. First of all, let me start by assuring Mr. Matsibo that the gentleman is not going to be president of Zimbabwe, Lord. And in terms of trying to put a fetter on council, that can only be done by your lordship. And when I raised the issue, my Lord, it was as harmless as in the way it was brought up. For our learned colleagues on the other side to take umbrage, I think it's unbecoming of the prosecuting bar in this case. I don't think that issue is in doubt, Lord. We are confirming reality here. But I think
No. I think, Mr. Kagbo, on a serious note, I think the considerations that Mr. Mason has raised are serious. You see, we have people who are very gullible. We have people who believe what they want to believe regardless of what the truth is. This is a court. So far I've tried to maintain this trial on the law and not on any other consideration. And I'm going to continue to do that. But in the same time, we have to bear in mind, which I said I bear in mind, what is going on outside. But that does not mean that we need to feel the anxieties and the excitedness that is going on outside. Because what we certainly do not want to do is to politicize the courts. You are a very senior counsel and you know as well, even from your time as Attorney General, that the courts ought not to be politicized. So it is not going to be, it is not a political trial. Yes, we have regard to considerations outside, but we're simply looking at what is before us by way of evidence. And that is the message that I prefer to see outside. Whatever happens outside, that's an issue for another day. It's not consideration for the courts. So we need to be careful about our utterances, because then, as Mr. Robin Mason quite rightly pointed out, there are people who will misconstrue what you said. I mean, I did not say anything because I knew it was just an excited utterance from you. So that's why I just focused on the case. But there are people outside who would not understand that it's an excited utterance. So please, let's leave the campaign outside of the courtroom. Let's focus on the law and what is before us. I think that will help all of us.
Beloved, I take your admonition in good part. And I assure my learned friends that as long as they keep on the straight and narrow, we'll continue in the
We are not going to politicize the trial. So we'll leave it out of it. And this is why, let me make it clear today that, in fact, one of the instructions that I gave this morning, and I'm not going to shy away from that, is that I do not want to see people clad in political affairs in this court. Political garments. I said it very clearly. Because I was against it. I want us to all be in here. You as lawyers have an opportunity to represent your client in the best possible interest. But what I do not want to see is political garments in the courtroom. Because then you're going to have other callers coming into the courtroom and then there's chaos. So we need to be mindful of that.
As the Lord pleases, as I say, I take your admonition in good part. And
let's focus on the law.
We'll ensure that focus on what the Lordship.
Let's focus on the law. This is a serious matter, and we don't want to get distracted by what is happening elsewhere.
As the Lord pleases.
And the public needs to understand that here we're looking at the law.
As the Lord pleases.
There's nothing else we're looking at here other than what is before us.
We certainly are going to address you just on the law.
Yeah, let's just
and the facts.
To the law. And the facts, yeah.
As the Lord pleases.
Because you see, at the end of the day, I always believe that when an accused is appearing in the court, they need to have the best possible defense, which means a defense that is focused on the case. Because if you're not, then you leave lapses. So this is where I want us to focus on what is before us.
We'll do that, my Lord.
Please. I appreciate that.
Thank you, my Lord.
Alright, thank you. Mr. Mason, I believe that adequately deals with your concerns. Alright, thank you.
Sorry, my Lord.
Yes, Mr. Fofana.
Yeah, now that this local visit will be coming up and we are not coming back to court before the visit, I was just wondering if Mr. Jules Sandovi will be informed, because there is a possibility that the court will have to constitute itself at the locus. And Jules Sanders, I mean, he's an accused person before the court, and the court is moving to the jurisdiction of the contract. Your Lordship didn't want to say anything about that, but I think it is crucial, because if it is possible, we probably might want to have him as a witness at the locus. I mean, so that we lay that issue to rest once and for all.
Well, you just encourage that Mr. Maximo, but he just don't object. But that is why in the no-case submission, I referenced the fact that Mr. Sanders is free to come into the trial if he likes.
No, so it's about informing me.
Yes, he will be informed.
About the basis.
He will be informed.
I don't think Balan Frey has anything to object to about that.
No, he's an accused. He's just not before the court, but he's an accused.
My only objection would be whether this court can be constituted in the US.
The court can be constituted anywhere. Even the locals, the court is going to the locals.
My Lord, like I say, I stand to be corrected. My understanding is the jurisdiction of this court ordinarily is limited to the geographical.
No.
Indeed, my Lord, only in instances where, for example, offences are alleged to have been committed within the embassy or the...
No.
Now you see that he had no business bringing us here. He's admitting that. He's fully aware that he had no business bringing us here.
No. Hold on. Gentlemen, Mr. Maximo.
I'm saying...
Mr. Maximo. All right, look.
Yes, ma'am.
You would recall,
yes,
not long ago,
yes,
that a British judge came here and conducted a trial here. Right? Quite recently.
Well, yes, the trial was conducted here.
But so likewise, this court can move to New York and conduct a trial in New York. It is still the court of Sierra Leone sitting in New York. The court can sit anywhere. As long as I am there, I call counsel, the court can sit.
It's within the precincts of the Chancery.
That's right. And in fact, the Chancery building is Sierra Leone.
That's the distinction I was making.
We're giving Sierra Leone.
We're giving some international lectures.
Don't wind them off. You want to wind them off. You see, this is what you do.
That's why there is a possibility too, Mr. Matsibo, there is a possibility too to prepare Dr. Ali Kaba for a recall at the Chancery building.
Well, certainly, when witnesses are upset, it's open. Anybody that wants to change tack can file an application and then I will rule on it. It's as simple as that. Alright? So I think all matters are settled. Please, gentlemen, Mr. Deval, if there's going to be any changes, let me know in advance. So other than that, Mr. Fofana, in fact, both of you, if you should be ready to take the first accused on the 17th.
Lord, we'll prepare for that.
Thank you very much. Mr. Campbell.
Proceedings today, and we look forward to seeing you on the 17th.
I thought you would say you look forward to seeing me in New York.
Yeah, I'll be in New York with you, and then I'm sure I'll take Mr. Matsibo for a drink.
Oh, certainly. I'm sure he's looking forward to that too.
On Fifth Avenue, my Lord.
Gentlemen, the notices will come out as to the day of convening in New York, but it'll be between that period of time. But don't worry, you've been given advance notice, so you know that it's around the corner. And you see, your little friend Nico Wilson has been very excited about this trip.
Mr. Cabo is now going to New York.
All right. May I just extend thanks to all counsel that filed the no-case submissions. As you can see, without your assistance, maybe I'll still be writing it because it's huge. So I'm grateful to all of you for the assistance given in filing the no-case submissions, which obviously mentioned the relevant authorities, so it made it easier slightly to get it done quickly. So similarly, we'll be looking to do the same thing when it comes to closing addresses. Right, so please bear that in mind. Alright? So we'll adjourn in the first instance to the 17th of March, and then we shall all see in New York.
Welcome back. This is AYV Television on Channel 33. We're broadcasting live from the main Law Courts building here in the Central Business District in Freetown. You might be seeing the camera rolling. The court has been adjourned. Lawyers who were here today to defend the accused, they are up from their seats, preparing themselves to leave perhaps for their homes or their chambers. But it's been a long day. We started here around 10 to 11 a.m. and we are still here, with the no case submission ruling. That was what we started with this morning. The Honorable Justice Adrian Fisher overruled the no case submission that was, asked for by the defense team of Dr. Samura Kamara, who is the fourth accused in this matter, and Fode Vamfumba Bawo, who is also an accused in this matter, the Caliph Fode Suma, Dr. Samura Kamara, the fourth accused, and others who have been standing trial on this matter. They were indicted, just to give a background on this matter that has been ongoing here in court. The Anti-Corruption Commission indicted these individuals for alleged corruption. They said they misappropriated public funds amounting to $6,530,000 United States dollars, and up to that some amount that was meant for the construction of the Selion Chancery building in New York. But the high-profile individual in this matter is Dr. Samura Matthew Wilson Kamara, who was the Minister of Foreign Affairs. He once served as Minister of Finance, but he's accused in this matter when he was at the Ministry of Foreign Affairs. He is charged with one count of deceiving a principal and one count of misappropriation of public funds amounting to $2,560,000 United States dollars meant for the construction of the Selion Chancery building in New York. These accused persons were arraigned before the court on the 10th of December in 2021. They were indicted on the 21st of November in 2021 by the Anti-Corruption Commission. So the matter has been going on since December, and they've been coming and going. So today, the Honorable Justice Adrian Fisher of the High Court overruled their submission for a no-case submission, their plea for a no-case submission in this matter. He said, there is a case. They need to answer to the corruption allegations, and their lawyers should prepare their defense. So what happened after the ruling was that the Honorable Justice Adrian Fisher had to ask them to put them to elections and to determine how they will be putting up their defense. So the things that he asked them today, they must choose from three options that are open to them on how they want to go with their defense. Whether they will rely on their statements made to the investigators and already before the court during the investigation with the ACC, and whether they will want to narrate their own version from the dock without being cross-examined, and whether they want to testify on oaths and call witnesses to their defense. And all of them who were here today, including Dr. Samura Kamara, preferred to take the witness stand, and also they will possibly be calling witnesses. So that was agreed on, even though there were some objection from African Osise, who is one of the defense lawyers, but that was agreed on, and the Honorable Justice gave his ruling on that, so that was clear. And the other matter was they will have to travel to New York to go and see the Chancery building. They will have to do a locus visit, what they call in law. This means they will have to go and see the location, because this is a question of the Chancery building that was to be constructed for Sierra Leone in New York. So they'll be traveling. They're expected to travel to New York between the 1st to the 8th of February. They will have to travel, and then they will come again to Sierra Leone. When they come to Sierra Leone, they should be meeting around the 17th of March here in Freetown to continue with the matter. So that is actually what has happened. It has been a long day. This was a packed full, courtroom. You can see well-wishers or supporters of Dr. Samura Kamara are moving outside with him. And this was where the defense lawyers were seated, and also the prosecuting lawyers and other defense lawyers were seated. But the room is almost empty now, and Dr. Samura Kamara is moving out with the people who came here to support him. But one thing that has been very clear is that the Honorable Justice Adrian Fisher clearly warned that this matter should not be politicized, even though he agrees that it's a public interest matter, considering the fact that Dr. Samura Kamara is already the flag bearer of the main opposition, All People's Congress. It clearly stated that the matter should not be politicized. The lawyers should leave politics outside. When they come here, what they should speak is the law. He gave that warning, and if as well warned journalists and people who write on social media to be very mindful of what they said. What he clearly said is that no one has been found guilty in this matter. The matter will continue, and people should be looking for. There was some arguments whether the cameras will be in here again, whether live coverage will continue. But he clearly said he couldn't comment on that for now. But one of the defense lawyers, the former Attorney General Frank Kagbo, also requested that they want to come with their own media to continue covering these proceedings live. What's also Honorable Justice Adrian Fisher made clear is that, in his own opinion, matters like this should be live in the media. The people should understand and know what is happening. So perhaps the next proceedings, or even moving to New York, the media will be allowed to cover whatever will be happening in this matter. There were some arguments about politics, and with the prosecuting lawyer, Mansibo, is a Zimbabwean who is representing the Anti-Corruption Commission, and renowned lawyer Robin Mason had to come in and gave some caution about politics and security and their well-being, as well as lawyers who are prosecuting this matter. The other side to this is that one of the accused, who said he is on 800,000 Leon salary, is represented by Honorable Indolo Moiwo Gevao. He is appealing that the state fund his witnesses who are in the United States of America, because he's not receiving much. He's not been working since he was indicted. His lawyer has been saying he can't afford to pay for the witnesses to come in. Even when the Honorable Justice Adrian Fisher said they can speak to the witnesses through video link, the lawyer was saying they want them to come so that the judge can see them in person, and they can be cross-examined in person. So he has asked him to write and ask about it and see whether they can, and the state can fund that and do that. But we've spent almost the rest of the day here following this matter, and the Honorable Justice Adrian Fisher has received commendation from both the defense team and the prosecuting team for how he has handled this matter, the time he's given them, and also how he's letting them understand that time is of essence, considering the fact that one of the accused person, the fourth accused, Dr. Samura Kamara, is expected to be contesting the June 24th multi-tier elections, and he's already the presidential candidate of the main opposition APC party. Even though he warned them about not bringing politics into the court, he said he's also aware of the atmosphere in the country and the individual that is involved. I want to talk to El-Kas Sano quickly as we round up with our coverage here live from the Law Court building on what this means for the judiciary. El-Kas, once more, welcome to AYV.
Thank you for having me again. Final time.
We're closing out. We've spent almost the rest of the day here covering this matter. But what clearly came out is that the judge, Honorable Justice Adrian Fisher, clearly said, this is part of transparency and accountability, letting the public know. And in his own opinion, he thinks this should be happening. But one of the defense lawyers, Frank Kagbo, was asking whether this will continue.
Yes, thankfully, we have a Chief Justice who is a reformist. The judiciary, under his leadership, has gone through a lot of unprecedented reforms. To his mind and the mind of the judiciary management and staff, we have this unshakable conviction that transparency inspires confidence. Accountability will always build trust. So, therefore, the vehicle to use as a transmission belt to convey this message is the media, which is why the Honorable Chief Justice invited the media houses, journalists, to come and tell the story independently, impartially, in a very unbiased manner, without giving your opinion, but to stick to what obtains in court. And that notwithstanding, which is why you also hear the judge sending out a message on those who are bent on sending the wrong message, false information, to paint the judiciary wrongly, to send a message that does not befit the status of the judiciary. We are moving forward. What is important here is the willingness. We want to see the judiciary of Sierra Leone becoming an envy within the sub-region, like it is happening now. People are coming from the Gambia. People are coming from Nigeria, other places, to come and learn from the judiciary of Sierra Leone, which is why also we had quite recently the UN team headed by the UN resident representative was here. Okay. He visited here. He visited the chambers of the Honorable Chief Justice with a lot of commendations. We are commending him because of his kind of leadership style.
What is very much clear, El-Kas, is that even the judge, the Honorable Justice Adrian Fisher, has agreed that this is a public interest matter, considering the fact that one of the accused persons, the fourth accused, Dr. Samura Kamara, is the flag bearer of the main opposition, All People's Congress. What is very clear, it's a public interest matter. Do you want to assure the public whether this will continue, whether the cameras will be allowed here, considering the fact that he is already leading a political party?
At the moment, the judiciary limited it to the no-case submission. Okay. Certainly, the Honorable Chief Justice or the judiciary is an institution that is always responsive. If we want it to continue, we'll certainly communicate it to the respective media houses. But we will not preclude the very fact that it will not continue. Because even when we sent out the media advisory, we said because it involves the flag bearer of the main opposition, All People's Congress, we want people to see. We want to disprove naysayers. We want to disprove rumor mongers who over time have held the wrong perception about the judiciary. Okay. And the Honorable Chief Justice is always on top of situation. And the only thing I will say, I will continue to allay the fears of Sierra Leoneans. I will also continue to give confidence in our revered public, to have confidence in the judiciary, to have confidence in the leadership provided by the current Chief Justice, his Lord Chief Justice Desmond Babatude Edwards.
Okay. Thank you very much. El Casano is the Communications Director at the Judiciary of Sierra Leone. What we should make very clear, and what the Honorable Justice Adrian Fisher made very clear, is that no one has been convicted, no one was found guilty today. What happened today was that he overruled in the no-case submission that was asked for by the Defense Counsel for the accused persons, including the fourth accused, Dr. Samura Kamara. He said there is a case, they should answer the alleged corruption case, the matter should continue. What we understand is they will be doing a locus, what is interpreted that they will be visiting the scene, because it's the U.S. Chancery building, the allegation of misappropriation of funds for the construction of the Chancery building in New York. They'll be traveling between the 1st to the 8th of February to New York, to the preparation between that time for them to travel to New York to see what has happened there, what are the allegations. And afterwards, on the 17th, they will meet here again in Freetown, and the matter will continue. So we'll be following up. We'll be, if the judiciary thinks we need to broadcast as well to continue this with this matter, we'll definitely be here. But it has been a day's broadcast, a long day broadcast since this morning to this time. We've been bringing you live coverage from the main law courts building here in the central business district of Freetown. Thanks to the technical and production team, and I have been Amadou Lamranaba, thanking you very much for listening and viewing on our social media platforms. We know it has been a little bit of challenge with our earlier broadcast, but we'll continue to try to give our best. Thanks for watching, and continue to stay with AYV.
This is the things I do. Yes, for me country, green, white and blue. I know say the bella them over and down no go party. Go don't bother that. You know we come together as one. For we country flag, I go die for me country flag. Oh nana. If they say what I eat, then go up and Paris, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bella them. Who are they? The bella them, you go one of them. Hey lad, if they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them Paris, you go one of them. Oh, now who da them, now the bella them. The bella them, you go one of them. Mama the system the moon, lo lo lo, oh lo 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 lo. Papa the system the moon, oh lo lo, oh lo 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 lo. Mama the system the moon, oh lo lo, oh lo 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 lo. Papa the system the moon, oh lo lo, yeah, oh lo 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 lo. Oh lo lo lo. Capital A, capital B, capital C, they want turn and to D. Within a them plan, they want good sabi. Within a them plan, they want good sabi. We no go ever retreat and we no go surrender. Holy Ghost fire, they make them the blunder. All them bad plan, them back to sender. Papa God, now you know we defender. Time don't go, now check the calendar. We all they see, we not to sleep in one. I say the country, the wololo, the youth, them, the wololo, the system, wololo, we all live. Wololo, I say the country, the wololo, the youth, them, the wololo, the system, wololo, we all live. Wololo. If they say what I eat, then go up and Paris, you go one of them. If they say what we score, then go disallow the goal, you go one of them. Now who da them, now the bella them. The bella them, you go one of them. Hey lad, if they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them Paris, you go one of them. Now who da them, now the bella them. The bella them, you go one of them. Mama the system, the moon, lo lo lo. Oh lo 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 lo. Papa the system, the moon, oh lo lo. Oh lo 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 lo. Papa the system, the moon, oh lo lo. Oh lo 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 lo. Papa the system, the moon, oh lo lo. Oh lo 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 lo. Oh na na. Them a free know this say we the score past them a free know. Them a free know, them a free know. Them a free know this say we the walk past them a free know. Them a free know, them a free know. Them a free know this say we country salon for glory. Them a free know, them a free know, them a free know. Oh na na. If we no get good player, we no buy. I the player, the one where they try. The one where go come pull water na the eye. The player where go make everybody they smile. The player where go make we knock upside. The player where go make we fly and fly. The player where go make all the bill of them die. The player where go make we the boo boo bamba. Now the player where go make we know they want them where they lie. The player where go pull water na we eye. Now the player where go make all the bill of them die. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live wololo. I say the country, the wololo, the youth them, the wololo, the system, wololo, we all live wololo. If they say what I eat and go weapon power, you go one of them, you go one of them. If they say what we score, then go disallow the goal, you go one of them, you go one of them. Now the bell of them, the bell of them, you go one of them. You say lad, if they say what they can, then go disturb with priest, you go one of them. If they say what they can, then go lock them power, you go one of them. Who of them, now the bell of them, the bell of them, you go one of them. Mama, the system, the mona, lo lo lo. Oh lo 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 lo, Papa the system the mona. Oh lo lo, oh lo 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 lo, Mama the system the mona. Oh lo lo, oh lo 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 lo, Papa the system the mona. Oh lo lo, hey God, oh lo 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 lo, Sakia the kill we. 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 That's right. Bididum pum 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 pum. Bididum pum 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 pum. This is the things I do. Yes, I. For me country, green, white and blue. I know say the bell of them over yonder no go party.